Hey, good morning. This is the May 12th, 2026 meeting of the Water Quality Control Commission. I'm the chair, William Brancard, and we will start with a roll call.
Good morning, all. Commissioner Bayless, are you here?
Yes.
Got it. Chair Brancard.
Here.
Commissioner Barunda, who I'm going to call his name, but for the record is absent today. Commissioner Shakalian.
Here.
Commissioner Chapman.
Here.
Commissioner Langer. Here. Commissioner Laney is on the platform.
Good morning, here.
Good morning. Commissioner Fry.
Here.
Commissioner McWilliams.
Here.
Excellent. Commissioner Sloan.
Yo.
Vice Chair Thompson.
I'm here.
Thank you. Commissioner Vigil is also on the platform. I thought we let him in.
See.
Commissioner Commissioner Anderson.
Here.
Excellent. Commissioner Vigil, can you hear us? I don't see him on the platform anymore.
I do. I see him.
Oh, do you see
But
him?
he's muted.
Do you have Mr. Vigil unmuted? Yeah. Okay, Commissioner Vigil. Okay, well, Chair Brancard, you have a quorum.
Thank you. So everyone should have an amended meeting agenda before them. And we will start with this approval of the meeting agenda as amended for today.
So moved. Second.
Okay. All in favor of approving the agenda?
Aye.
Aye.
Opposed? Off to a great start. Okay, so now we have the minutes of the April 14th, 2026 meeting. I believe you should also have a copy of that before you.
Move approval.
Second.
Okay, do we have any comments on the agenda minutes? Well, if not, then I'll make a few. Right at the beginning, we have an appearance by Chair Thompson. Sorry. My fault. Okay, and then on item 4, legislative update, we had a great presentation by Jonas Armstrong, but I believe Commissioner Anderson also participated in that discussion. So if we could make a note of that. Under item 6, it says we heard comments from 36 members of the board. Those 36 people present in the hearing room, is that correct? And so there are then additional persons on WebEx.
There were.
Okay.
I'm going to add that number.
All right. Any other comments on the minutes?
Chair Brancard, you mentioned Chair Thompson started the meeting. Do we need something about the transition?
No, that's a clear mistake. It should have been Chair Brancard. Any other comments? Okay. So we have a motion as amended?
Move him as amended, yes.
Thank you. Second?
Second.
All right. All in favor of adopting the minutes?
Aye.
Aye. Opposed? Okay, so we now have items 4, 5, and 6, which are status conferences, which brings us to the issue of what's ahead for the commission. Once again, just so we're aware of what's going on here, we have one hearing today, the Fox case. And then in June, we have, I believe, 9 or 10 days of the surface water rulemaking hearing. So 24-35, the Santa Fe compliance order, which was scheduled for today, is now scheduled for July 14th. All right? And then we have the triennial review late September, early October. There was another case that was scheduled for July 2619, the Ritter abatement. The parties have decided to submit additional written filings. They'll be done by July, so we'll have to schedule a date for that at some point. That's not on the agenda today. Okay, so what we do have is 3 status conferences, and I'll call number 4 on our agenda, WQCC 22-37, New Mexico Environment Department versus Gallegos et al. We have appearances.
Good morning, Chair Brankford, Commissioners. Crystal Weatherly for the New Mexico Environment Department.
Thank you. Is there anyone here on behalf of the respondents in the complaint? Have you heard from any of the parties, Ms. Weatherly?
Yes, I believe Mr. Sommer is on. Yes.
Mr. Sommer?
Yes.
I don't think we can hear you.
Can you hear me? Can you hear me?
Yes, I think we can hear you now.
Okay, all right. Thank you very much. Carl Summer Crimes and Associates, on behalf of the respondents.
Okay. And we only have some of the respondents left, right? This case was originally dismissed for some of the case, Ms. Weatherly?
Yes, Chair Brankford, if I may just give a little
Please.
background. Good morning, everyone. NMED is before you today to request that the Commission resume its review of WQCC 2237, appoint a new hearing officer, and schedule a hearing for our preferences for the September Commission meeting. In the petition that we filed back in July of 2022, NMED issued an administrative compliance order that required compliance actions and assessed a civil penalty to 3 respondents, Frank Gallegos, the Jones Family Trust, and Mesa Grande Development, LLC. In August that year, respondents Frank Gallegos and Mesa Grande Development filed a timely answer to the ACO and requested a hearing. In September that year, the Commission granted the request for the hearing and appointed Mr. Chagalian as the hearing officer. Later that month, the parties attended a pre-hearing conference with the hearing officer, and the hearing officer issued an order waiving the 90-day hearing deadline and also issued a scheduling order which set a hearing date of January 10th, 2023. Meanwhile, what happened with respondent Jones Family Trust is that in October of 2022, NMED and the Jones Family Trust came to a settlement agreement, and the Commission in November that year issued a stipulated final order to partially resolve the ACO as to the Jones Family Trust only, after voting to approve the settlement agreement at the November 8th Commission's public meeting. The stipulated final order articulates that the Commission retained jurisdiction to proceed over the remaining parties to whom the HCO was issued. However, the hearing in this matter never commenced, and we are not really sure why, except that there was a changeover in counsel and hearing officer and staff. So that is all that I know of for a possible reason why there was never a hearing. It was not on the January 2023 agenda. In any case, the department would like to resolve this matter and bring it back before the Commission. Respondents Council and I have been in communication and have discussed a September hearing date if that pleases the Commission. And so again, we ask the Commission to appoint a new hearing officer and schedule this matter for the September public meeting. And that's all from the department. I'll yield to Mr. Sommer.
Thank you. Mr. Sommer, do you have something to add, please?
Not much to add, Chairman. The recitation of facts is correct, and the matter should be set for hearing and a new hearing officer appointed. One of the problems has arisen since I last spoke to you about council. I've got something coming up in the summer. It's one of some of my time, and I'm wondering if the October meeting would work. We are in the process of trying to come in compliance. There's a new party that needs to be added to this, I believe, and that is we have formed a association under the sewer the act relating to the formation of an association to take over this. We deeded the system to that. We're in the process of applying for necessary discharge permits. The October deadline, the October hearing will be better for us. I'm sorry, I didn't get a chance to speak to council before this meeting, but aside from that, I believe we're in forward.
Thank you. Thank you. All right. Any questions, comments from the commissioners on this matter? So we have a proposal before us to set this for the September meeting. Okay, just to be clear, we already have a rulemaking hearing in September, but it's at the end of September. So we could actually have our regular meeting in early September and hear this matter then. The only complication is that we will have to schedule a day, maybe two, or maybe more days at some point in either August or September for deliberations on the surface water rules. I'm hoping for August. We can move forward on the surface water rules in August, and that would leave this slot open in September for this hearing. So, is that confusing enough? So I can work to try to set up to find a hearing officer for this if the commission gives me the authority to appoint a hearing officer. And so I would look, there's a motion to set the hearing for September, the commission's regular meeting in September, and then authorize me to appoint a hearing officer.
So moved.
Second. Okay. So just so you're aware, we're voting to set this for hearing at the commission's regular meeting in September and authorize the chair to appoint a hearing officer. Are there any other issues that we need to deal with?
Chair Brankard, no, none from the department.
Okay, great. All right. So all in favor?
Aye.
All opposed? All right.
Thank you.
Okay. Thank you, Council. We're now on item 5, WQCC 26-21. This is the Mexico Environment Department versus U.S. Department of Energy, Newport News Nuclear, BWXT, Los Alamos, LLC. Did I get all the letters?
N3B is good. Yeah, good morning, Chair Brankard, members of the commission. Mark Roseborough on behalf of the Environment Department.
And Jeff Wexler on behalf of N3B. I suspect we have Mr. DeRoma also on behalf of N3B on the platform, as well as Mr. Evans on behalf of the Department of Energy.
Okay. Well, you're going to do the talking.
I suspect they may have something to add.
Oh, okay. Great. So do we have those folks?
They're available.
Okay. Great. Great. All right. So, Mr. Roseborough, you give us a quick summary of where we're at in the department's position about going forward here.
Sure, we would certainly like to schedule a hearing today, but I will note that we already have initial settlement conference negotiations scheduled for the 28th of this month. Our general position would be that we would like to have a hearing concluded and resolved before the end of the year. There are 4 separate ACOs involving Los Alamos National Labs generally that were issued. Not all 4 of them are before the commission, but we already have schedulings in July and September. And I know that you guys are scheduled out. So I would suggest maybe we get a hearing on the calendar for October, subject to Mr. Wexler's availability and their client's opinion. But I would note that we, as I said, already have settlement negotiations scheduled, and hopefully they'll be productive.
Thank you. Wexler.
Agreed, we already have a settlement discussions on the books. We don't know yet how successful those will be. We haven't had any initial discussions. This matter actually from our perspective would be better to go forward first than the others. There's reasons that there are predicates within this particular ACO that ultimately feed into the other two. As for the October dates, I already have hearings on the books, including one of the ACOs is actually scheduled for a number of different days before a hearing officer in October. And I also am chairing the water law conference, which occurs sometime in the middle of the October dates. So from my perspective, it would have to be pushed to November or December.
Okay. So Mr. DeRoma? Or Mr. Evans, is that the other counsel?
Yes, Chair Branker.
Yes,
This is John
any
Evans on behalf of the Department of Energy.
Okay, and do you have any comments on scheduling or the status of this case?
No, I agree with Mr. Wexler as far as the timing and the fact that this is a predicate matter before one of the other ACOs.
Mr. DeRoma, any comments? Going once. All right. So we have a proposal to tentatively set this for a hearing in October, but council has conflicts, and we could do November, December. Okay, so the issues October, November is that we have to schedule, we have a hearing at the beginning of October, which is the triennial review. And then we have to schedule deliberations on the triennial review, which I was thinking might be November. But we could just tentatively schedule this for November and then see what happens, particularly since you all have negotiations going on. There could be changes in the status of this case. But just to give you a date this year so that you have something to shoot for.
That would be acceptable. Thank you, Chair.
All right. So again, the proposal is to set this for the hearing at the Commission's November meeting, and to give the chair the authority to appoint a hearing officer. If I can't find somebody, I'm stuck doing it.
So moved.
I'll second that.
All right. Any further discussion on the motion? So this is to set this for the November meeting of the commission. All those in favor?
Aye.
Opposed? All right. Thank you all.
Thank you.
And I'm up next, so I'll stay.
Oh, yeah. All right. Item 6, WQCC 26-32, Environment Department versus Otero County.
And again, Mark Roseborough on behalf of the Environment Department.
Okay. Do we have counsel here for Otero County?
Yes, R.B. Nichols, County Attorney for Otero County.
Thank you. Great. Love your beard. Really.
Thanks.
All right. So let me just throw out the issue that the commission faces here on this case. We put this on the agenda because we physically did not receive the response in a timely manner. And so we want to know, A, what the parties think about it, and B, whether we have to do anything about it. So I'll start with the department.
Yes, I am aware that the commission appears to not have received a physical copy. The Environment Department was served via email and hard copy in Santa Fe. I'm not sure what happened with Otero County's service to the commission. And I'm not prepared to waive our rights. Otherwise, that the commission is inclined to think it was an untimely filing.
Okay, so I guess I'm hearing this for the first time. So the department did receive a timely filing of this petition.
Yes. So Otero County in its certificate of service, and this is my understanding, Mr. Nichols, of course, can correct me, in a certificate of service said it had served the commission as well as the environment department, the petitioner. And so Ray Romero, paralegal for the Office of General Counsel, received one hard copy addressed to me, Mark Roseborough. It is my understanding of what happened. And I believe that there was supposed to be a second service out there from Otero County to the commission. And perhaps Mr. Nichols knows what happened if indeed there were two filings.
Mr. Nichols, I'll give you an opportunity here.
We did send out multiple multiple copies. We don't know what happened to the other copy. We haven't received the certificate back, and so it's still unknown what happened with that. I didn't dig into it further. I thought we were okay on the issue, but I will and can if necessary.
Okay. All right. So I guess we should just resolve this issue initially. I will say that the previous matter that was before us, the DOE case, also had a service problem where they actually filed their petition with the department and actually listed the department as who they were filing it for. But the department worked out with DOE a process for correcting that petition. Okay. So we've been lenient in one case. And so the question is whether the filing in this case with the department is sufficient for the filing with the commission. Council, any thoughts?
Thank you, Chair Brankard. I think you've appropriately asked the commission for their thoughts on it.
Thank you.
Mr. Chair,
Commissioner Sloan.
I think I heard that Otero County had filed both electronically and in the mail with the department. Is that true of the commission?
Yeah, I believe the facts are they did file both with the department, but nothing was received in a timely manner by the commission.
Was it both electronic or only by mail to the commission?
Pam, I think we just eventually you got one like a month later by mail, right?
We've never received a hard copy. We received the electronic copy April 13th.
April 13th. So eventually I think there was a communication. I think the county actually approached you saying, we've never gotten the green card, what's going on? And so in response, they emailed then the petition.
Maybe I'll be more direct. Did Otero County send both a mail copy and an electronic copy in the same way they did to the department, to the commission in a timely fashion?
Okay, well, I'll go ahead with Mr. Nichols.
I put several people on the email, and I need to pull it up and check to see who all is on there. Be honest, there was some confusion on I don't remember off the top of my head, but I believe there was some conflict in the administrative code and something else on where responses were supposed to go to. But I know that I CC'd folks that were on the prior meetings that we had from the environmental department. for sure.
By way of a little background, the department issued the ACO, and Otero County, through its contractor, responded with a response that appeared to be responding to a notice of violation. We, the department, reached out to Otero County, had a call and said, just to make sure you understand, this is not a notice of violation. It's an administrative compliance order. You have to file an answer and request for hearing if you would like one. And I believe my recollection of the email, I don't have my computer in front of me, is that the commission, Ms. Jones or Mr. Lopez, were not copied on their final answer and request for hearing that was sent to us.
Thoughts, commissioners?
Mr. Chair, can we just defer this for a month and clean it up next month?
Well, they have filed with us.
Yes.
So the question is whether we're willing to accept, I mean, basically, I think it's whether we're willing to accept the filing with the department as tantamount to filing with the commission, because the filing with the commission is untimely. That appears to be the facts in this case. Okay. So it's unlike the prior case where they actually rewrote the petition to make it compliant. In this case, it's just a timing matter.
Chair, if I may, Mr. Roseberry. So you said that Otero County was, the department issued an ACO.
Correct.
And it's your standard form.
Correct.
And that includes a provision towards the end that says, if you want to appeal, you have to do these things. And I'm pretty sure it has the email address for OPF as far as filing.
The ACO had directed them to mail a hard copy to the New Mexico Environment, and I don't have the address in front of me, but the building in which OPF is located. And we did not direct them to email a copy as well, but it did direct them the address and the date by which they were required to respond by.
Okay, thank you. So, Chair, I think you've pointed out a few times how the prior matter had a similar failing. And I think in that instance, the commission decided to let them fix it and come back. So it wasn't on last month's agenda because of that deficiency. So perhaps just for the sake of consistency, that may be an approach here.
Is the department moving to dismiss this compliance order? Giving you a chance to verbally move right now.
Yes, so moved.
Okay. So having a motion and moved, I'll ask for a quick response then from Mr. Nichols.
Can you restate what the motion on the table is for? Again, I wasn't clear.
I move. May I confer with my client just momentarily?
Sorry, was that Mr. Roseborough that was making that motion?
Yes, it was Mr. Roseborough making the motion.
Okay.
Okay, I will retract my motion. Here's what I'll say generally. Otero County has worked with the department in good faith. We are interested in entering into settlement negotiations. My client would like to continue to do that instead of fully enforcing the ACO as issued. So the department does not move to dismiss or move to find Otero County's responses untimely.
Okay. All right. Thank you. So then it's up to the commission what motion you'd like to have, whether to accept or dismiss this petition from Otero County.
It kind of have a moment to speak with to the commission.
Sure.
As Mr. Roseborough said, Otero County does want to resolve this matter, and we want to do it in a cooperative fashion. Not disputing that there are things that need addressed, and it seems in all of our interests to work together to tackle this. I don't see value from litigating this or disputing it, but I need to reserve our ability to do that in case it becomes necessary. And it appears we did have some missteps in the response, but I would ask time to an opportunity to correct that, because we are acting in good faith and wanting to collaboratively address this and take care of it, and do more than just that, to make sure we don't have this come up again in the future, and that we're being good stewards and responsible on with this issue.
I will just say, I don't know that more. So the department is interested in resolving this ACO. I'll just say that. And I don't know that more time will help here. I agree that there's a decision point before the commission, but simply reserving will still be untimely. So certainly the commission, well, I won't tell you what you need to do, but I'm just saying that I don't think that more time will really resolve anything.
Commissioner Sloan.
Mr. Chairman, maybe we could do something like put it off while they enter settlement agreements, and then revisit the settlement, or revisit the whether it was timely or not at the next commission meeting, and that would give some impetus to Otero County to make further good faith efforts. And I guess I would add that I'm not overly inclined to move forward with a hearing given the facts of the matter.
Further thoughts? So, okay, what I'm understanding from the proposal from Mr. Sloan is that we simply move this forward to another date to discuss it further, and not resolve the particular issue that I was sort of trying to force on the parties here today. And I don't disagree with your proposal. Are there any objections to Commissioner Sloan's proposal?
Okay. So just to be clear, the hearing wouldn't be set, and we would just hold this in abeyance. Or...
We probably should do something. So I would entertain a motion to continue this matter.
Mr. Chair, I move that we continue this to next month.
Any second?
Second, with a strong suggestion that the parties find settlement between now and then.
Okay. All right. All right. We'll do a roll call vote on this one.
Okay. Commissioner Bayless, your vote.
Aye.
Chair Brankard.
Yes.
Commissioner Chakelian.
Yes.
Commissioner Chapman.
Yes.
Commissioner Langer.
Yes.
Commissioner Laney.
Yes.
Thank you. Commissioner Fry.
Yes.
Commissioner McWilliams.
Yes.
Commissioner Sloan.
Yes.
Vice Chair Thompson.
Yes.
Commissioner Vigil. And Commissioner Anderson.
Yes.
Motion passes.
Great. Thank you.
Thank you.
Taking the time. All right, are we done? All right, next item number 7. This is WQCC 2618 proposed amendments to 20.6.8 New Mexico Administrative Code. Water Access Treatment and Reuse Alliance et al. As petitioners. This is a continuation of the matter that we heard last month, which was described very briefly in the minutes. That we had a presentation by the petitioners, and we then took public comment both here in the audience, and we also took public comment online. It was a really good amount of comment. That was excellent. And then we had presentations by persons who have entered an appearance in this matter also talk about that. And then finally we had a sort of reply, rebuttal, whatever, from the petitioners. And then we began with questioning of the petitioners in this matter. And frankly, I don't remember where we were, who had asked questions and who needs to ask questions. So
You dealt with the left-hand side of the room?
I know, but people are migrating over to the right-hand side today. I'm not sure what's going on.
Mr. Chair, apologize for interrupting so rudely. The last questions that we had heard were from Commissioner Chapman. And I will say, I think our responses, his questions were technical in nature to some degree, inquiring into the state of the science and quoting some language from relevant papers. And part of our response was we were not terribly well positioned to opine on scientific technical matters. Nevertheless, they were very good questions. And given the procedural posture of our petition, which is we have requested that the commission set the petition for a hearing, and given that one of, if not the fundamental question before the commission is what is the state of the science, and does the state of the science warrant the development of a record related to the draft rule and the petition. We have brought two very qualified technical experts, appreciating that we are not at a state in the proceeding where we are entering technical testimony or admitting anyone as an expert per se. We are at a bit of a more informal place. We would like to allow or request that Dr. Yang or Dr. Zhu and Dr. Zhang have a moment to answer some of Commissioner Chapman's technical questions before proceeding to the remainder of your questions. I will note that to make sure that folks are aware of our relationship with Dr. Zhu and Dr. Zhang, both are researchers at New Mexico State University who are involved in the New Mexico Produced Water Research Consortium. We do not have a formal relationship. When I say we, the petitioning party, the Water Alliance, do not have a formal relationship with the water or with the Produced Water Research Consortium or New Mexico State University. Rather, we have engaged certain of the expert researchers at New Mexico State University who have been advising and collaborating with us as we develop the rule. So much of the substance of the rule is based on the body of research developed by these researchers and other peer researchers of theirs. It's a long way to say or request that we have a moment to take up Commissioner Chapman's questions before moving to additional questions.
Mr. Chapman, did you have additional questions?
I appreciate you all coming here today and providing the technical experts that would presumably be a part of a hearing. I ended my line of questioning and passed my time to fellow commissioners to follow up on questions, and so I reserve further questions for commissioners, and I'm here to listen to what other commissioners have to say about this at this moment.
Okay. I don't necessarily want to have a hearing before the hearing.
Mr. Chair,
So what I would propose is that we continue with questioning from the commissioners and then see what the commission would like to do when we get to the end of that. But I really appreciate folks coming up here to do this. And so maybe we'll have an opportunity to hear. So I guess we'll start from the right side of the room today. And Vice Chair Thompson's looking like he's ready to go. Or we can wait. You want to do last? I don't know. Go ahead, Vice Chair Thompson.
Okay. Thank you. And thank you for the petitioners. And it's good to see my friends from New Mexico State, even though it pains me to say that. First thing, one of the petitioners, Nicholas Maxwell, claims that I have a conflict of interest and I should recuse myself. I'd like to address that just briefly. I've never received any support whatsoever, financial or intellectual support from the oil and gas industry, from the federal or state funding agencies regarding research on produce water. I have no conflict. I can categorically deny that. I have written a rather widely cited report that included a chapter on produce water. It was a review of the technology, the knowledge, but that report was done on my own time with my own resources. Again, I have no vested interest in the outcome of this. So I want to make that clear, and I'm not going to recuse myself. Now, I really only have one question of the petitioners, and it's got a technical component, but it's also got an administrative component, and that is, please,
Mr. Thompson, if I recall Mr. Maxwell's complaint, it was not about that you had a personal conflict of interest, but that you had stated positions about produced water before the legislative committee. Is that correct?
That's correct.
Okay, so if you could just briefly address that.
I don't recall stating positions other than encourage the legislature to pass legislation that we hear this matter before the end of the year. I've got a written copy of I can produce a written copy of my testimony if he would like to see it. Okay, so let me get
so the question was from Mr. Maxwell whether you would be biased in any way on this.
No, I would not be biased.
Thank you.
Thank you. Okay, so let me ask my questions of the petitioners. I am concerned that the regulation is the proposed regulation is not well developed, and my specific concern is that it has a list of about 400 constituents, and they are in various places they're listed as control limits, and in other places they're listed at effluent limits. And it appears from the definition of control limits that has the effect of a standard. Okay, so that's kind of the preface. My concern is that there are not published limits, whether they're control limits or standards, for most of those constituents. The surface and groundwater regulations list 83 compounds as toxic pollutants. 46 are listed for human health standards, 10 additional standards for domestic water supply, and so forth. There are about 140 constituents for surface water. So we got at least 260 other constituents that we don't have standards for. And as I read the proposed rule, it's going to ask the proponents, people submitting applications for permits, to propose standards. And I am really concerned that this is going to throw the commission into a never-ending morass of arguing what these control limits or standards should be. So I guess my question to the petitioners is, if this proposed rule is adopted, what is going to be the impact on the Water Quality Control Commission?
Mr. Chair, Mr. Commissioner, we have been in a series of conversations with the Environment Department, and I have Mr. Knight next to me who's representing the Environment Department, along with NMSU, to simplify that question. So we have been coalescing around a group of constituents that are found in Permian Basin produced water. Most of them, with a minor subset, actually do have published standards, with the remainder not being detected in produced water in over 100 samples taken from the New Mexico Permian, and approximately like 50 to 60 samples taken in the Texas side of the Permian Basin. And so we will have that fully answered in collaboration with the department and NMSU before this matter goes to hearing.
Mr. Chair, Commissioner Thompson, the good doctors from New Mexico State University are the thought leaders on that exercise and have been involved in that list for a period of years. And to the extent you want more elaboration on how that effort is going, Dr. Zhu is prepared to discuss that list. I'll leave it to the chair and yourself if you would like a more technical visit.
So my question is not for Dr. Zhu and Dr. Zhang, who are superb researchers. My question is, if we have a list of contaminants, a lengthy list of contaminants, and it's an applicant for a permit proposes a standard, the Water Quality Control Commission is going to have to review that. And we're not qualified.
Mr. Chair, Commissioner Thompson, clarify, we are in the final stages of populating that table. So the rule, as we will be revising it, will not be asking the commission to or to rely on a permit applicant's proposed standards. That table will be populated based on a body of research that includes a holistic examination of published standards, both at the federal and all state levels, along with robust body of research related to targeted and non-targeted analysis, and also utilization of the control limits in the table 1, which is so that there's a really useful dynamic between table 1 and appendix 1 that will be utilized to help alleviate the burden you're thinking of.
So if you're going to pare this down, but the limits are still going to be proposed by the applicant?
No.
So now we're talking about a pretty substantial change in the document from what was submitted in March. And I wonder if maybe we ought to just kind of, again, put this on abeyance until we've got a final document that's supported by the Environment Department.
Mr. Chair, Commissioner Thompson, I'm telling you something that you already know, but it's certainly not uncommon for a draft rule as contained in a petition to be revised through the rulemaking process. Oftentimes meaningful revision. In this case, we provided a more than comprehensive list to make sure that we were over-inclusive, appreciating that through the work that was being conducted at NMSU and engagement with the Environment Department, that as necessary, we could trim that list without adding something that wasn't already noticed. So in the terms of, is what we will be providing a logical outgrowth of what was originally submitted, I think it would be really hard to say it is not when the list is not growing. Rather, it's being refined and narrowed.
Mr. Chairman, Commissioner Thompson.
I would object to Mr. Armstrong speaking. My name is Marilyn. That's the new energy economy. Mr. Spoken. It's not an appropriate way of handling this. Mr. Eric Thompson asked a question. At this point, my understanding is council or the petition gets to answer. That's the process. Not will come up or not offered. Thank you.
Thank you. I guess I would agree with that. That really, if you want to chat behind the scenes with the Environment Department, and then.
Mr. Chair, I believe that the comment that the director of the Water Protection Bureau wanted to make was that the Environment Department recently filed.
No, I'm sorry.
Recently filed a letter with the commission addressing some of these specific points. And so I would refer the commission to the Environment Department's letter.
And in that letter, just to hone the point for the commission, NMED states that this is not an uncommon event in rulemakings, that you have some technical pieces that are still further to negotiation between the parties in a rulemaking proceeding, and that NMED feels comfortable with this being set for hearing and moving forward based on where the parties are on filling in that chart of analytes and the standards. And so that was specifically stated and put in a written public comment to the commission prior to today's hearing.
I don't know. The commissioners are aware that has been posted on our docketing page. Okay. And I can read that back to you. It doesn't say what you say it says.
It doesn't. I apologize. I don't have it in front of me. So we had spoken with Mr.
I think
Armstrong.
Mr. Armstrong said the department would support this if there were specific numeric standards. I don't see specific numeric standards in this proposal.
We have been working with the Environment Department on creating those specific numeric standards that all of the parties agree upon. Mr. Armstrong was very clear in his public comment, and we had been working before the last hearing date that they support this matter being set for hearing. And I do recall that being his public comment that was given. I have been in communication with the Environment Department. We had a technical meeting with them last week on this particular issue, in which the Environment Department, Mr. Armstrong in particular, said that he supported this being set for hearing and that it was a common practice. He said it basically what I just told you all, to keep on working on technical issues while the rulemaking goes forward.
Well, I guess and I certainly acknowledge and agree that the commission does make changes as a result of hearing, and there are multiple submittals proposed over the course of the rulemaking process. But this is pretty substantial, and that concerns me. So that's my only comment. Thank you.
That's it. Mr. Anderson.
Mr. Chair, I'd like to wait till the end to ask my questions, if that's
Okay. Mr. Bayless.
No comments.
Thank you. Commissioner Chikali.
Would you clarify something for me? Are you proposing to reopen the administrative record from the previous rulemaking and add new, updated technical evidence into that record? And I ask this because the petition stood on several points. One of the more substantial points that I understood was that there's new science, and I wondered whether that leads me to ask my question.
Thank you, Mr. Chair, Commissioner. We are not proposing reopening the old rulemaking case. That rule is law. So that rule was passed by the commission. And so to update the rules, we have to initiate a new rulemaking procedure. Our new rulemaking procedure will present scientific evidence that came into existence after 2022. Secretary Kenny has stated in news interviews in the last, I think, about 18 months, that the record in that prior rulemaking that resulted in the rule only considered science up through 2022. Just taking him at his face, I don't know, I didn't go back and double check that is what they considered, but there's been substantial scientific papers and scientific findings since 2022, a number of which were in 2024 and 2025. So we do propose changes to some of the rulemaking provisions that were adopted in the first rulemakings. We are proposing some of that text be changed. It was completely prohibitive against treated produced water use. We need to change that if we're going to allow certain uses and permits to be issued for certain kinds of uses. Our rule is based on a lengthy scientific conversation with NMSU and several other scientific experts that have happened. Most of that science took place after 2022.
Thank you.
Mr. Sloan.
I don't think I have any questions other than I'm looking at Mr. Armstrong's letter, and I guess I do see where the Environment Department says that they urge the commission to accept the petition and schedule it for a future rulemaking hearing at your May 12th meeting. So I don't know, seems like there's a lot of things in the letter, but I don't have any questions at this point. I would be happy to make a motion when the time comes.
Commissioner McWilliams.
No questions.
Thank you. Mr. Anders?
I don't have any additional questions to that. Thanks.
Great. I thought that's disappointing. I thought everybody would ask the questions that I wanted to ask, so I wouldn't have to ask them.
Chair, I was not on this side of the room during questioning. I had to leave and was on the platform, so I do have some questions.
Excellent.
Unless you want to go first.
No, excellent. Go ahead.
Okay. Thank you. So I will say I have very conflicted feelings about this. And with regard, I think this is actually a question for council to start. Sorry. So it seems like NMED's argument and public comment were that they want to flush out some tables and is there anything stopping NMED from proposing their own petition?
Chair, Madam Commissioner, no.
Okay.
There's nothing in the statute that would prohibit anybody from submitting a new petition.
Okay. And
I'm sorry, just a point of clarification. As it stands right now, NMED is not a party to this petition. So right now, I mean, it's Water Alliance, and they're the petitioner, and they have some public entities that are, but no one else is a party in the petition.
Okay, thank you. And I don't want to have a hearing before hearing, but I did have some technical questions that if I can either just state them as things that I'm concerned about and then not have answers, but I do wonder about the funding for these studies. I am especially concerned if there are any studies that are not funded by industry. And also the longitudinal aspect of the studies. It seems like one of the studies that was included in the petition exposed cells to 24 hours. If we're talking about human health, people will be exposed for much longer than 24 hours. And as a more general statement. I work for a Department of Health, and, you know, my bureau specifically has dealt with this a lot lately with PFAS and other contaminations, and it is really challenging to get things out of the environment once they are in it. And the best way we can protect human health is not putting it in the environment in the first place. So I will let you respond now. Thank you.
Thank you, Mr. Chair, Commissioner Langer. I have confirmed the answer to one of your questions. So yes, they do have funding, federal and state funding that does not come from industry for some of the studies.
For the complete study or a portion of it?
So each study, because there's a bunch of studies they've conducted, always discloses the funding source for each study. So they've got a number of papers and we'd have to go one by one through it, but they always do have that disclosure. The majority of their funding is coming from federal and state sources, largely coming from higher ed, is what Dr. Xu just informed me of.
Thank you.
Okay. Great. All right. Commissioner Behill, any questions? I'm seeing a waving of the hand no.
Chair Brinkert, if I may.
Commissioner Laney.
I realize that I did ask some questions during the last meeting, but I waived asking all of my questions in trying to provide an opportunity for other commissioners to get a word in edgewise. So I do have a couple. I guess they're following on the same line as Commissioner Thompson in that I'm concerned about some of this language that's in here, and it's sounding like the petitioners anticipate revisions to their proposal, excuse me. I'm curious if that will address some of the areas where there seems to be less clarity on actual regulatory enforcement of the rule. Right now, there's a lot of case-by-case language in there, as well as where it appears that the permittee proposes the effluent limits, and that the department works with them to establish those. And again, that kind of comes back to Commissioner Thompson's points in that it's that very large list right now that are not limits nor standards. It's just a huge listing of different chemicals and toxins. Is it anticipated that those will be changes that are included as well, building more transparent enforceability into this rule? Because right now, I think it would be very difficult for the department to enforce this rule, since so much of it seems to be built on this idea of case by case of regulatory discretion. And I recognize that regulatory discretion is a part of what happens, but this one seems to be heavily built on that notion.
Mr. Chair, Commissioner, the answer to your question in short is yes. That is a very large part of the work that has been done with the Environment Department. And certainly in our conversations, I mean, they're more than conversations. It's robust engagement with the Environment Department and their staff over the last year related to all parts of the draft rule, but including language regarding enforceability and the dynamic between the appendix, the list in the appendix in table 1, and ensuring that the standards that exist in the rule are both relevant and enforceable.
This may be a slightly unfair question, but is there a timeline on when we might see these revisions come to us? I mean, it would be great if you guys had those revisions and could do stakeholder engagement with the actual rule more closely aligned to what it sounds like you've discussed with NMED.
Yeah, Mr. Chair, Commissioner, yes, we are very close. That is part of what Dr. Zhu intended to discuss, was the state of that list. But it is populated. So we are very, very close to having the work product in the state that you're contemplating.
Okay. Thank you.
Okay. Do we have anyone else we're missing?
Can I ask a follow-up?
Okay. Yes.
Again, I want to be clear that I understand. So there, at some point, there will be a more focused list, but will it still be the responsibility of the applicant to suggest the permit?
Mr. Commissioner, or Mr. Chair, Commissioner, no, it will not. In the revision, it will be a list of limits that is enforceable by the department and clear cut. Still with some discretion, let's say you wanted a higher ammonia level because you wanted to have ammonia was suitable for certain soil uses or things like that. You could seek a deviation or some minor discretion from the department, but with a clear enforceable list.
Yeah, okay, thank you.
Mr. Chair, can I ask
Mr. Sloan.
Can I ask a question of council? Hours. Does the New Mexico Rules Act apply to this rulemaking process?
Yes.
So under that act, I have to have sort of a complete, this is the rule within 30 days of the hearing and post that. Is that not correct?
I'm sorry, could you restate that?
So I think the Rules Act requires sort of the final rule to be posted for public comment 30 days prior to any hearing. So you have to have essentially what's the final rule. Yes, it might change during the hearing based on logical outgrowth, but you have to have a final rule.
I think generally that's correct.
Thank you.
I would correct our counsel that we have procedural rules that apply instead of the Rules Act when it comes to timelines, et cetera. I believe we have a 60-day notice.
Correct. I was just, I think to the extent, technically, you're correct. The Water Quality Control Commission has rules that apply, and to the extent that they're not covered in the rules, the state rules would by default apply.
Okay. Other questions? Before I jump in here, okay, let me. I have a few questions, but I'll try to keep it on the high level here. So to begin with, let's just, well, first, let me correct a couple of things that were stated last time by you all. First of all, you gave a whole talk relying heavily on, and repeated it today, on the logical outgrowth test. I don't know, Commission Council's aware of this, but about a year and a half ago, the Court of Appeals rejected the logical outgrowth test. Okay, there is an opinion about the Environmental Improvement Board in which I don't blame you if you didn't find it, because it's a memorandum opinion and literally it's in a footnote where they reject the logical outgrowth test and say that in New Mexico, we have to follow the Attorney General's default procedural rules test, sort of a three-part test for changes to a rule. Okay, so logical outgrowth test and all the federal cases that set it up are gone. So now we're stuck with this sort of vague provision in the AG's rules. Anyway, the other thing is, I believe council said at the last meeting that the consortium was approved by the legislature.
There was legislation, Mr. Chair, that separately approved the creation of the legislature. It was not in House Bill 546. It was a line in a different bill, and I don't have the bill number in front of me today, but it passed also in 2019. One of my colleagues at Marathon Oil at that point in time was involved in the piece of legislature that it was included in, and it gave the authority to the Environment Department to enter into the MOU with NMSU for the creation of items like the consortium for academic purposes.
Okay, I'll have to look that one up. But it didn't. But there's no statute creating the consortium.
No, it wasn't.
Consortium is not a statutory body.
No, it's not a statutory body. That is correct.
So unlike Texas and Colorado, which have statutory consortiums, New Mexico does not.
That is correct. It was a grant of authority in a piece of legislation which gave some statutory authority and power to the Environment Department
To help fund.
Yes, and they could
It's a
work.
funding provision.
Yeah, I believe it was a funding provision, if I remember correctly.
Okay.
Yeah.
All right. But I mean, I think that's a big reason why we're stuck here in this is that we don't have a statutory consortium. We don't have a process for bringing these issues to the public. In Texas, Colorado, of course, the consortium has to make regular reports to the legislature and the public about the status of this. They have public meetings. Their membership is defined by a statute. We don't have any of that here in New Mexico. So I think that's why we're here. But anyway, I'll get off my high horse there. So let's start with right from the beginning in the proposal. I believe it's section 2. This is where you create this concept that the discharge use of treated water or reuse of treated water can only occur in 13 counties. And if I heard your testimony right, you were sort of saying that because these are counties that are sort of friendly to produced water.
Mr. Chair, just making sure your question is if the 13 counties in the rule that are listed in terms of defining the geographical scope, if our response to why is because they're friendly to oil and gas production or produced water?
Yeah, I mean, you seem to indicate that these were counties that were more amenable to this.
Well, Mr. Chair, I guess I can't necessarily comment specifically on how amenable they are or not, but I can categorically state that these are counties in which produced water exists. 11 of the 13 counties are counties in which there has been some quantum of production. And the two that there is no production, Otero and Doña Ana County, these are counties which are home to advanced research institutions.
And then, Mr. Chair, obviously there are counties among those 13 counties that are amenable, right? We have San Juan County that has joined, passed a resolution to join the petition as a co-petitioner. And then just recently, Lee County passed a resolution where we are representing them in this matter, and they are a co-petitioner. So you have certain counties that are in the 13 counties that are highly supportive. And we have other counties that have expressed interest in joining.
I guess I'm trying to sort of find issues here that could potentially derail this whole proposal. And it seems like asking the commission, I mean, you've defined, treated produced water as this solution to New Mexico's future water crisis. And yet you're only saying that 13 counties get to solve the water crisis and the other 20 are on their own. Where does the commission have the authority to sort of pick winners and losers under its statute?
Mr. Chair, I guess I would redefine the characterization of the issue from our vantage point. It's not picking winners and losers. Water management is inherently regional and local. And so the lack of produced water in Santa Fe County makes it really challenging for a rule about produced water to be relevant to Santa Fe County. When we're talking about, is the water there so that it could be part of a regional solution? If it's not there, I think there's a logic to, well, this isn't a water source that is relevant to this particular region. So that's the logic behind that.
That may be true, but you're saying the commission needs to make a decision saying you can't even try Santa Fe County or Bernalillo County or Socorro County. You're out of luck. You don't get to use treated produced water.
I will say, Mr. Chair, I think revisiting what Ms. Bradford mentioned, if there is a jurisdiction, a local jurisdiction that expresses interest, that wants to be a winner in exploring an additional water source, there's nothing prohibiting that community from engaging now or even after a rule is set and saying this is a water source we'd like to pursue, so seek amendment of the rule. So I don't think that there's necessarily a firm line drawn in the sand that says that it can't happen in a county that's not presently listed.
Mr. Chair, in regards to your statutory question, and I don't have the statutory language in front of me, but in setting the location for holding a rulemaking, there is some consideration as to whether or not the rule is regional or specific to certain locations, right? And then you could have the rulemaking held in that particular jurisdiction. So I think the Water Alliance is fine wherever the commission would like to hold the rule. If the commission would like this to be general applicability and apply equally to all counties, then that is, the commission's will when it hears this case. What we have found during our public outreach is there are certain counties where no produced water occurs. It's unlikely in the near-term future, within the next 5 to 10 years, anyone's building a pipeline from the Permian Basin to Santa Fe County to dispose or to use produced water here in Santa Fe County. And so, what we've heard from the folks who show up from Santa Fe County is they don't tend to support produced water reuse. In contrast, citizens in Lee County highly support produced water treatment and reuse. Down in that county, they see that water being transported over across the Texas-New Mexico line. And we hear from them during our public engagement that they care very deeply about this issue. And in that sense, that is where we see water being very regional. Which is not unlike other regulatory bodies, many of which that you guys represent, where you do see regional considerations into water use. And I think that is a very important part of this rulemaking as we think about water use. And in some sense, we have heard from different stakeholders that they think that this is a very smart idea because it does add some protection to counties that aren't supportive of produced water reuse. And then it gives flexibility and the ability to look at technical standards for the communities that do want treated produced water reuse. But it is the commission's will. You're the rulemaking body, but nothing precludes the commission, and it definitely is contemplated that you can have a rulemaking of regional applicability.
But we have to define why. And I mean, it's an unusual thing for us not to have a statewide rule. And in this case, we're saying basically to people in 20 counties, you don't get to use treated produced water. Sorry. So it's going to be, I think, really hard if the commission adopts this rule to justify it in front of the Court of Appeals as not being totally arbitrary.
I think the why is there's no produced water in those other counties or produced water research facilities.
So why deny it? I mean, why if Santa Fe County is willing to pay for a huge pipeline down to Eddy County?
Mr. Chair, I will also add, while there was some logic to it, I don't think that you would see opposition from us in expanding the geographic scope of the rule. We were trying to be thoughtful and adopt some logic to the geographic scope, appreciating this is somewhat of it's a new water source, right? And so the regulatory universe around this water source is clearly in a development phase. So if this body thinks it's more appropriate for it to be a statewide rule, we would not oppose that necessarily.
The other thing I'd like to add, Mr. Chair, is the substantive provisions of the rule, the protective provisions of the rule don't vary based on where you use produced water. We want all those protections regardless of where. In that sense, if you use the produced water in Santa Fe County versus Lee County, we still want continuous monitoring. We still want targeted and non-targeted analysis. We still want the science-based standards that we've been working on. We still want later permits for subsequent uses. So we've been trying to think of all the protective standards, regardless of where the water is used. So substantive provisions don't change. If you want it to be of general applicability, you know, we have just received a lot of public comment that people really preferred having some county choice, and we continue to hear that from the public as we engage.
Just to be clear, you can't use produced water in Santa Fe County under this proposed rule.
That is correct, Mr. Chair.
Thank you. I just think that's going to be catnip for the Court of Appeals to throw this rule out.
Mr. Chair, I disagree legally with you. Honestly, there's a technical basis. It's on location of where produced water is produced. We will present technical testimony that supports that. And, you know, it will be based on the commission's weighing of that testimony as to whether or not it wants it to be of general applicability or of regional application. But the Court of Appeals is going to look at the record. And does the administrative record support the rulemaking? And that is my understanding of arbitrary and capriciousness when they weigh that. Sure, I think a Court of Appeals will look at past cases and say, do all rules have to be of general applicability? But that is not what the statute provides. In the past, you have done so. It would be our burden to present the case to you with a sufficient administrative record that justifies the counties where the water, where the rules would apply.
Okay, I don't want to hang on to this too long. So you focused heavily on the science of treatment of produced water. But in the previous rulemaking, had you been there, you would have known that what the commission often focused on was the fact that we didn't know what was in produced water. So the question is, have you gotten folks in the oil industry to fess up about the trade secrets and what's in the produced water?
Mr. Chair, the answer to your question is that the rule provides a comprehensive inquiry and a comprehensive demonstration of what is in the water using multiple methods of detection. And that as well is one of the reasons why we brought Dr. Zhu and Dr. Zhang here today, because we appreciate that that is a point of inquiry. But the science and the technological advancement that exists in this space is incredibly robust. You know, and it's interesting as we look at the state of the science, and your question is really asking the state of the science as it pertains to what is in the water. We've heard a lot of discussion, kind of bantering between ourselves, who are attorneys, not technical experts. We've put forward affidavits from some of the leading scientists on this issue who say that the science has advanced to a place where you can write a rule that would contemplate the reuse of treated produced water in these defined applications. The only argument to the contrary is from counsel from parties who are opposed to this. So you've heard the testimony from the leading researchers on this saying that there is this robust body of science that would allow for your concern to be addressed through a regulatory framework like the one we've put in front of you. And so I can answer your question and say, yes, you know, the provisions in the rule directly address and respond to your concern. And whether or not you believe me is certainly your prerogative. That's why we brought experts to answer that question, hopeful that they would have an opportunity to answer that question so you could stop kind of taking our word for it.
So the answer then is you don't know what's in the produced water, but there hopefully is science that will sort of help you try to figure out what's in the produced water after the fact.
Mr. Chair, that is not a correct characterization of what I believe my partner is trying to state. And I will say this, there has been a lot of research done on non-targeted analysis. So we've talked a lot, right, about targeted and non-targeted analysis. Targeted analysis looks at the NIPTES Plus list, it looks at known analytes. And by and large, researchers, have coalesced around targeted analysis and what's in produced water in New Mexico and Texas. There's been a lot of research done in the last few years on that. Non-targeted analysis gets to the question that you are asking right now. And there's been a whole new body of studies on non-targeted analysis using mass spec instruments in scientific laboratories that is actually better than a frac focused disclosure. So I believe what you're asking is, why won't the oil and gas companies give us a full list and the exact concentrations in frac focus, right? Well, chemicals change downhole. If you think about how far you're going below the Earth's surface, you're going 11,000 feet sometimes, often 6,000 feet, very rarely as shallow as 4,000 feet. And those chemicals combine and Earth's pressures make them change. And then when the water goes through the treatment process, you're going through a thermal process or you're going through a membrane process. You have multiple phases of treatment that get this water to a distilled water quality. Chemicals change again. Non-targeted analysis is what scientists have found that actually gives us the scientific justification and analysis of what's in the water. And that will tell you the families of chemicals from the treated effluent that remain in the water. And that is the evidence we're going to present at hearing, which is better than relying on an oil and gas operator to give you a recipe. You want to figure out what's actually in the water with scientific instruments, and you don't want to have to take any industry's word for it. Let's be able to independently validate it. And that's where the science is today.
Thank you. So in your petition, you mentioned staged implementation of the rule, okay? And I noticed in Mr. Armstrong's statement, he said that the Environment Department would like to see an implementation schedule, particularly a longer ramp up for surface water disposal. Is there any kind of implementation schedule in the rule? I couldn't find it.
Mr. Chair, there is an implementation schedule. It's essentially a 1-year ramp period, during which period there would be a limit on what an applicant, if their permit was approved, on the capacity of their facility, what the capacity it could operate during that first year. And during that first year, the only way you would move beyond that first year period would be compliance and a demonstration of compliance with the permit terms during the first 12 months.
And these will be certain types of permits?
Mr. Chair, I believe the ramp period would be for the types of permits that have a exposure pathway. So discharge permits.
Well, you have a whole classification, stage A, B, C, D. Right. What are we talking about here?
So it'd be a type B or C permit, or A if there were an exposure pathway that the Environment Department had identified.
So they get the permit right away, but then they can't use it all right away for a year?
Correct, Mr. Chair.
And that's in the rule. Okay. I guess I'm confused about having a rule inside your rule that deals with surface water discharge when next month we're going to spend 10 days in a hearing on surface water discharge. How does that work?
Mr. Chair, I'm sorry to interrupt, but are we getting a little far afield of the question of whether to set this for a hearing or not? It seems like we're talking a lot about what we might be talking about in the hearing.
Thank you. I appreciate that. I'm sort of looking for sort of basic potential fatal flaws. There's a lot of details we can get into. Man, I mean, good Lord, we could spend hours talking about car washes and laundromats, right? Because they're specifically allowed in the rule. But I'm not gonna talk about that. I'd love to talk about car washes and laundromats. But I'm just trying to find out if there are simple, like this is a basic conflict issue here. Is there a conflict between what you're doing and what the Environment Department is proposing next month? Why isn't what you're doing part of what what would be an amendment to what the Environment Department is doing next month?
Mr. Chair, you're asking, I think, a good question. We went through an extensive review where the Environment Department sent out our proposed rulemaking to their contractor to look for inconsistencies. So we have been combing through with the Environment Department staff, trying to make sure there aren't inconsistencies. And we continue to look for that. The goal is to have both rules coexist together and for it to be consistent with the produced water rulemaking, the proposal you see in front of you being more stringent than the surface water discharge rule that you guys are going to hear in June. We are a party to that rulemaking for that exact purpose. We actually did raise that question with the Environment Department. Should we bring this as an amendment to that rulemaking? And that is, quite frankly, why we entered an appearance as a party in that rulemaking. The Environment Department's preference has been, at least my understanding is that we bring this as a separate rulemaking because it has so many technical issues that it is going to require extensive technical testimony about produced water specifically. And so we want to give credence to that preference, which I think was instruction that we received from all the commissioners in our first rulemaking petition go around is, how does the Environment Department feel about this? Have you worked with the Environment Department? What feedback are you getting from them? And are you considering that? And so we have really tried to take that feedback and implement it as we move forward with the Environment Department.
Thank you. I appreciate that. All right. Any further questions from commissioners? Mr. Chapman?
Mr. Chair, I do have some follow-up thoughts that have sort of distilled over the last month, and I just took a little bit of time to prepare some statements so that I could more eloquently flush out where I feel about things. So we started this whole process by talking about my skepticism of your presentation of this new science. So yeah, last month I expressed profound skepticism for this idea. In my experience in academia and publishing in peer-reviewed scientific literature is that the weight of evidence that supports something that resembles scientific understanding is something that can take years and decades. And so I want to spend some of my time with my remarks here talking about if the commission were to decide to grant a hearing for this petition, my expectations during the hearing. So I expect that we would hear from toxicologists about potential human health effects, environmental scientists about the impacts on the environment, and engineers about the feasibility of scaling up these pilot projects. I imagine we will hear from scientists from NMSU and the Produced Water Consortium, but I also expect and quite frankly demand that we hear evaluations from independent scientists that are not affiliated with the consortium. I will ask pointed questions of the scientists about long-term cumulative impacts on soil health of metals, total dissolved solids, and radioactive elements commonly found in produced water. I also expect to hear from the department about the results of the permitted pilot projects and how those data shape our understanding of produced water and how the department will implement a produced water reuse program. I will ask how the department envisions insurance compliance and enforcement with any potential future rule. This will be undoubtedly a really large undertaking for the department. I think the hearing would also allow for the commission to ask pointed questions of the oil and gas industry, such as how can we adopt a rule that can assess the character and degree of injury to or interference with health, welfare, environment, and property in the face of trade secrets and hydraulic fracturing fluid unknown composition, and what happens with highly concentrated brine created from treatment. So a yes, setting this petition to hearing today is not an endorsement. It's so that we can potentially have these conversations and ask these pointed questions. It would allow me and I think the commission to examine on the record the state of the science from independent scientists in addition to ones associated with the consortium. I have a profound respect for this body, and I trust that the commission will critically and impartially evaluate the science and make determinations on this evidence. If through a public hearing, if we decide to go that route, the commission determines that there's no credible new science, I have no doubt this rule will fail. And just to close out my thoughts here, should we find at the close of record on the hearing on this matter that the science is not ready, I have no problem voting against any proposed rule not supported by credible evidence. So, you know, lots have been going through my mind over the last month, and I appreciate you all being here again. And yeah, that's sort of how I've been thinking over the last month about the state of this petition and whether or not we should set it for a hearing.
Sorry. We'll have a motion to set or not set this for hearing. If we set it for hearing, then we need to have a discussion about when we're going to have a hearing, because this will be at least 2 or 3 weeks. We went over 2 weeks on a much more limited proposal last time. So particularly as Commissioner Chapman points out, there's a lot of science in this rule, and therefore there's going to have to be a lot of scientific testimony to support all that science. Otherwise, if we don't have substantial evidence, we can't enact those provisions. Right. So anyway, I'm going to open it up. Oh, sure.
Thank you, Chair. All right, so I'm working through your petition and I'm on page 5. There's a quote in here. Well, I'm not sure if it's a quote, but it's in fact, according to Dr. Zach Stoll, purification of produced water is so efficient that minerals need to be added. Do you understand? So I'm not clear, and we had some confusion earlier about footnotes. What's the source of this quotation?
Thank you, Council and Mr. Chair. We filed a notice of errata, which gives an updated citation to Dr. Stoll's testimony. I'll let Mr. Sayer jump in here.
Mr. Chair, I believe, Council, that you're referring to again, I think you mentioned page 5,
yes,
quotation. That was testimony from Dr. Stoll provided to a House committee.
Okay, so I've listened to that many times. He spoke for less than 3 minutes and didn't say that. That's why I'm asking. And the footnote includes other citations, so that's why I'm not clear where that's found.
Council, no, we went back and listened to Mr. Stoll's testimony. I did personally, I mean, I think, is there specific words, but it was a quote included in his testimony. Is that specific statement an issue? And then we also got a signed affidavit from Mr. Stoll that was attached to one of our motion responses.
Right, I'm just focusing on what here is in italicized in the petition. I didn't hear those words at the committee meeting. And again, you in your notice of errata, you talked about a different part of the petition.
Okay.
Where you clarified that the statements may have been in the documents that are cited, or the quote, or what was said in that committee meeting. That's what I'm trying to get clarity on.
Mr. Chair, Council, there was discussion at the hearing regarding this particular topic, where Dr. Stoll referenced, and again, I don't have the hearing in front of me, but we certainly tried to be faithful to the language. This dynamic where oftentimes the water is treated to a standard where it's removed everything. So it's now distilled water, and you typically don't put distilled deionized water on a soil, for example, right? You would need to.
I'm not talking about the underlying.
Right, and
I'm just
appreciate what you're pointing at, but I'm suggesting that that discussion was had, and the concept is whether, and I'm not suggesting that the words maybe are out of order or something, but I'm suggesting that the concept that's being addressed there is not arguable.
Okay. All right. So at the end of page 7, beginning of page 8, there's this. It says that talking about the study, the research that's going on in the consortium, and that it's that in Texas it's providing the basis to advance large-scale produced water treatment and reuse projects. And then there's a footnote that refers to 5, I guess, permit numbers. I looked up the 5, and the 5, to your knowledge, have any of them been granted?
Mr. Chair, they're not permits. They're not permits yet. They're applications for permit.
Have any of them been granted?
As
Oh, go ahead.
Mr. Chair, no, they're pending.
Right. And so I looked at them and one of them dates as far back as December of 23. And all 5 of them show to be in the administratively complete status, which according to the website shows at least 2 more stages after that. And so is what's being advanced in Texas?
The draft permits have been issued to some of those permit applicants. So TCEQ has provided, they've written very long documents with draft permits for the permit applicants to review. TCEQ has a very different process than the Environment Department does here. And so they get feedback from the permit applicant on those draft permits submitted, and then it goes through another technical review with staff. But the staff got to the point where they drafted a permit with all the water standards, which is a very significant milestone.
All right. Well, in the website, it's the next step is the technically complete status step, and that none of them have advanced to that point. So I'm just trying to understand how because the statement is that the research here from the consortium is advancing permits in Texas. And
Mr. Chair,
I'm sorry, but there's a permit that was filed at the same time as 2384, which was the first treated produced water permit here.
Mr. Chair, Council, I believe the language that we used says that the research from the New Mexico Produced Water Research Consortium is at work in Texas, providing the basis to advance projects. And an advancement of an application through the regulatory process is, I think, arguably advancement. And so that's the point we're trying to make, which is why we provided citation versus not providing citation to the applications. We are in close conversation with some of these action or activities that are occurring in Texas, and so are fairly familiar with some of the nuances of the process and where it is in the process. And it definitely is at a point where applicants have received draft permits back. That is not to say that they are complete, but it is to say that they are advancing through the process.
And Council, Mr. Chair, that draft permit is a significant step in the TCEQ process. So, I mean, that, the chart with the analytes that we're talking about for our rulemaking, TCEQ has gone through and created that analyte limit chart in Texas for produced water as part of the draft permit. Some of the permits are about 300 pages long. It is a very substantial step in the TCEQ process. More advanced than where we are in the rulemaking. If you guys got to the rulemaking, you're hearing the science on the record and started to kind of say, this is what we're doing in New Mexico. New Mexico would probably be a little bit more advanced than Texas. But right now, Texas is proposing those standards in its permits where it is more advanced than where we are here today.
Okay, so at the top of page 11, it states that nearly 325,725 acre feet of produced water generated. What's the source for that number?
Annually,
in New Mexico, sorry.
Yeah, Mr. Chair, Council, the Oil Conservation Division produces reporting on the volume of produced water generated.
Is that the source for that number?
It's the primary source for that number, yes.
Okay, because as you're probably aware, NMOGA is challenging the initial rulemaking here. So it's before the Court of Appeals. And in their brief in chief, they said that 165 million or 165,000 acre feet of produced water is generated in New Mexico. And they actually cited OCD as the source for that.
Yeah, I believe for 2026, obviously we don't have complete numbers. They're reported on a monthly basis, but and I'm stretching my recollection at this point, Mr. Chair. But in 2025, I believe it was 2.2 to 2.5 billion barrels, which I think the math breaks down to somewhere close to this figure. But once again, if the math is wrong, that's my fault. But it's suffice it to say, it's whether it's 100,000 acre feet, 250,000 acre feet, 325,000 acre feet, it's a substantial amount of water.
Okay, and Zach Stoll's self-sworn statement submitted on April 14th had a number of 291,000 acre feet. And so the number that you cited in, or that's cited in the petition, how much of that is re-injected by the oil and gas industry?
Mr. Chair, the volume of injected produced water is really not a part of our rule, the draft rule that we've proposed. So I don't have an answer to your question. I can tell you that the vast majority of that water is injected through Class 2 wells, but I don't have that number for you right now.
And counsel, we would want a technical expert, right? That's a technical question to provide that information to you.
Well, I think OCD has that data. That's why I was asking. And the data that I saw was about 40% of it's re-injected.
Yeah, I have not looked at the numbers recently. So you've looked at them more recently than I have.
All right. So last month, I believe it was you, and can't remember who it was when the question that Mr. Chair Thompson was asking, or Vice Chair Thompson was asking about the table that was blank. I thought the response was something along the lines that the parties should look at that as an opportunity for them to go in and fill in their, I guess, their NOIs or part of the rulemaking.
Interesting. Okay. I didn't realize you understood my testimony or not my testimony, but my statement, my argument that way. As I think what we were referring to, and it might have been Mr. Sayer, is that by the parties, NMED had entered an appearance at that point in time. We definitely would take numbers from any of the parties and limits. We held outreach sessions and we had an informal advisory panel. A couple of opponents participated too. Most of them have not given us any feedback on the analytes other than what we've seen in the motions practice. We would welcome that feedback. I would like to have that feedback. It'd be great. We have engaged with NMED and at last month's hearing, we had not had some of the technical meetings we've had subsequently. We had a really nice technical meeting with NMED and NMSU last week. NMSU has conducted a lot of research on technical standards around the country. They have a very robust spreadsheet system, which made us realize that we are pretty close in working with NMED and NMSU on being able to have that completed list with the limits that we talked about earlier today.
Okay, so that's I think that was my question, because what you stated earlier is that now this list is forthcoming.
Yeah.
So that's a big change from a month ago where that you didn't state that.
We did not state that a month ago. We knew the spreadsheets and NMSU's research. What we had not had was a meeting between NMED and NMSU to see, what the agency's sentiment was towards the research that NMSU had conducted. It was a very productive first meeting. I am highly impressed by the research that NMSU has done on the different numerical standards across the United States from all the different states. And I think we got guidance from, in fact, I know we got guidance from NMED staff on further technical questions that they had. So we're going to have another follow-up technical meeting, but we are close. And that was a wonderful discovery.
All right. So my last question is, in August of last year, when we were in the midst of your initial petition, in one of those hearings, you said that obviously this rule is going to be the first of its kind. Is that still accurate?
Yes, that is still accurate.
So there's no state in the United States that New Mexico is behind with respect to that.
So one clarification, Council and Mr. Chair, is that Texas has taken the path that they don't need a rulemaking. And so Texas has permits, right? TCEQ already has the authority that they need regulatory wise to issue a permit. Wyoming already has a permit system. They don't have as much produced water from unconventional drilling. And so a lot of their data and information is from conventional oil and gas wells. California has had long-standing permitting processes in place through different kind of regional water boards, again, from conventional wells primarily, and not from unconventional horizontal wells. So those states don't need a regulatory rule like what we're contemplating. So our rulemaking is different from those states, taking information from those programs, in particular the NIPDES program that's in place and has been used a long time in Wyoming, and then looking at what TCEQ has done. Over the past several years, the Railroad Commission in Texas actually has developed guidelines on surface discharge for treated produced water. And they have had a number of, Mr. Chair.
Pilot projects.
Pilot projects, yes, but yeah, guidelines for pilot projects. Thank you for that clarification. But they actually take the stance that they have authority to move forward. That is my understanding in Texas, which is why you see these big applications for big surface water discharges in Texas, and 5 of them pending, many of them asking up to 500,000 gallons per day of discharge. That no one's seeking additional statutory authority or rulemakings in Texas because they think they have the rules in place.
And this is still the first of its kind.
Yes, our rulemaking, New Mexico's legal system's different, right, than Texas's and Wyoming's and California's.
Mr. Chair, just in council, just making sure we got answers to your questions. I did quickly pull the OCD numbers, and I believe for 2025, the number was 2.7 billion plus or minus barrels of water, which I think if my math should never be trusted, but I think it puts it somewhere just shy of 350,000 acre feet. To your question about injection, I'm not sure if your equation contemplated the movement of New Mexico produced water into Texas. So the volumes of injected water in New Mexico would not be fully representative of the total volume of water managed in the state, whether it's injected here or transported across the border and injected in Texas.
I don't have anything else.
Thank you. Thank you. Just to be clear, the 5 permit applications we're talking about Texas are surface water discharges under Texas's NPDES program, an application specifically for produced water that was approved by the US EPA over 5 years ago. It was your former boss as Region 6 administrator, one of his last acts, who approved that in 2021. We're talking about Ken McQueen. Okay, other questions? All right, discussion. Commissioner Chapman has sort of started the discussion off with his statement. Other discussions about where to go with this. Now, first of all, let me ask if anybody wants to take a break, or should we just go forward? All right, we're going forward. We're going to make a decision here. Discussion. Yes, Commissioner Anderson.
Thank you, Mr. Chair. I just want to say that I share a lot of the concerns that have been expressed through public comment and through the questions that we have here on the commission. And I have a lot of questions and concerns with the proposal that would need to be addressed in a hearing, but that's the purpose of a hearing. So our drought conditions in the state, as we all know, are exceptionally terrible. It's creating statewide water shortages, and every water source must be considered as a potential resource. Also, the plans that we have in place within the state really encourage us to look at diversifying our water resources. And I think that that's a very wise thing to do in such a water short state. So again, many, many questions. We have to be incredibly protective of our water resources, and we also have to be creative about how we approach these challenges. So I would just leave it at that.
Thank you. Other comments from commissioners? Really? All this? All right. I'll just sort of summarize my feelings before we go for Commissioner Thompson.
Thank you. I think that we really do need regulations. There's a lot of water. I think it is challenging, but the challenges can be met. But I am really concerned that the draft proposal we've got before us right now has got too many uncertainties that will have to be resolved during public hearings. And based on the length and difficult conversations we had at our last set of hearings on produced water reuse and treatment, I don't think it's ready for us to hear. So I and it pains me because I do think we need regulations, but at this moment, I'm sort of arguing. My preliminary thoughts are that I will not support this petition.
Thank you. Commissioner Chikalian.
I don't recollect how we dealt with the motions to dismiss. Are they just outstanding, or are we going to in some way dispose of them?
Okay, I think I tried to make it clear that the last meeting that really the only thing that's in front of us is a decision whether or not to set this petition for hearing. That the motions to dismiss, in effect, are
what you said.
Comments, negative comments, obviously, but they are simply part of the comments that we open to the public to do. We don't really treat them separately. I think we're just going to have a vote whether to have a hearing or not, up or down.
Well, that being said, my review of the commission's rule in accepting a petition from a third party is a pretty low bar.
There's no standard.
Right. And it seems to me that this petition has met the standard. Should I make a motion?
Well, I'll just say a few things and then we'll have a motion, okay? So I kind of agree with Vice Chair Thompson. I'm of really mixed feelings here. The commission at the end of the last rulemaking, and I was sort of one of the ones pushing it, put a 5-year time frame on that rule. And the specific goal behind that was that that rule didn't really go very far. And there needed to be other issues addressed. And it was an attempt to try to get the Environment Department to move forward with sort of the next step. Of course, my thought about the next step is kind of like your stage A in this proposed rulemaking, where we look at industrial facilities, we look at more detailed pilot projects, etc. Whereas this is, I don't know, I feel like this, we're just sort of lemmings heading for the cliff with this proposal that's been put before us here. And so I think there are serious legal flaws with this. I think that the whole issue of dividing up the state into winners and losers is something way beyond our authority, and I think will make us look totally arbitrary in our decision making. But more importantly, as Commissioner Thompson put, the rule is just, it's got 22 pages of blank spaces in it. It's not a finished proposal. And yes, the commission has the ability to make changes during the process. But, in 30 plus years of dealing with rules in this state, I've never seen a proposal that is just so full of empty spaces as this one. And we're not the legislature. We don't get to, sort of do what the legislature did with House Bill 546, where council here introduced a simple 4-page bill that dealt with ownership of fluid oil and gas waste. And at the end of the session, we had a 31-page bill that dealt with all sorts of other issues that were not contemplated. And it was no longer called fluid oil and gas waste, and it no longer talked about ownership. And so legislature can do that. We can't do that. We have to go to the public with a proposal that is pretty clear that the public can look at and respond to. And at this point, I don't see this proposal as being at that stage. And that's the point of stakeholder groups, which, is being sort of piecemealed here with some conversations with the Environment Department and some conversations with NMSU. I will note that there were some public comments made last month that really struck me. And the one that comes to mind is Mr. D'Antonio. We talked about the need to have a conversation about produced water. And what struck me initially was, well, I guess that 1.5-year rulemaking we had was not a conversation. And, he's right. We're not having a conversation. We're having formal hearings where the experts will show up and be grilled by lawyers for hours and days. And it's not really a conversation about what's going on here. And I think that if we don't approve going forward with this, I think the commission with the Environment Department ought to look to have some other way of having a conversation. where we have a public forum to bring in expertise to talk about the state of the science and do that. All right. I mean, that's the problem, not having a statutory produced water consortium. They don't have a process for doing that. So I think we have to invent it. So that's my thought. I will not support this proposal in its current form, but commissions will. A motion. Commissioner Sloan.
On that note, I'll throw it out there, and I guess I'll preface it with just because we're having a hearing doesn't mean we adopt a rule, and if we adopt a rule doesn't mean there'll ever be a discharge. It just means we'll have a rule which is kind of required by the legislature. Having said that, I'd move to set the hearing and to allow the chair to set the date, appoint a hearing officer, and determine the location. And also add the caveat that we require a complete rule containing all values/standards not less than 45 days prior to the hearing, unless rule requires submission earlier than the 45 days.
I'll second that.
Further discussion by the commissioners.
I think that, yes, there's things that none of us like in this proposed rule. I think there are things that we may like very well. I think not allowing a hearing to happen does not give us a chance to have the conversation. And I'm going a little bit on faith that NMED's involvement with the petitioner assures that we will have a much better version before we have the hearing. And I'm going to base my vote on that.
More discussion.
Chair Brinkard.
Yes, Commissioner Laney.
Sorry, I wish I was in the room. I just thought I'd add my 2 cents since it seems like that's what we're doing at this point in time. I agree with comments both by Commissioner Chapman and yourself and Commissioner Thompson. I think there's a lot of issues with this rule, but I also recognize that we need to have the conversation, as Commissioner Fry was just saying, and that just by setting the hearing is not predetermined of anything. We, as Commissioner Chapman said, may hear it and not find that it's scientifically sound, or that it is, or that only certain provisions that are in it are, regardless, it's not predetermining anything on the fate of the rule. And I am interested in hearing the technical data, and I do wish very much that this wasn't the rule that we were looking at right now, because I do feel like it's got significant gaps in it. I hope that we see a revised document very soon, because it sounds like much of these issues have been contemplated and that they're changing, but those are only words and we're not seeing them, and no one has had an opportunity to engage in a conversation around those. But I do think there's value in hearing it. I'll leave with one last point, because I felt like you really did a great job. And I agree entirely with the issue about this only being applicable to specific counties. To me, that is poor rulemaking. When the dairy rule or the copper rule were put together, there was no consideration on the counties for which those particular industries exist, even though I'm certain that we could come up with a limited number of counties in which those activities are carried out. I feel like for consistency and state regulation, this rule needs to follow a similar thread of thought, in that while produced water may only exist in these 13 counties, I just feel like it's poor regulation to build a rule where it exempts any other county from said rule, because then we'll have to go back and we'll be doing this forever and ever if counties should expand, or if other counties should become interested in utilizing any treated produced water, pardon. Anyways, I digress. That was my last mention on the issue of counties, because that one really bothers me as well.
Thank you. More thoughts? All right, we have a motion. Do we have a second?
Yes.
Okay, we have a second. So there being nothing further, we'll have a roll call. And this motion is to set a hearing on the matter 26-18.
Chair, and just to clarify, a vote of yes is to hold the hearing.
Yes.
Thank you.
Ready to vote? Okay. Commissioner Bayless, what is your vote?
Yes.
Chair Brankard, what is your vote?
No.
Commissioner Chakelian, what is your vote?
Yes.
Commissioner Chapman,
Yes.
Commissioner Langer,
No.
Commissioner Laney,
Yes.
Commissioner Fry,
Yes.
Commissioner McWilliams,
I abstain.
Commissioner Sloan,
Yes.
Vice Chair Thompson,
No.
Commissioner Vehil. That looked like a no. And Commissioner Anderson.
Yes.
Commissioner Vehil, if you could send a text or something about your vote.
Read your hand signal.
One hand for yes, two hands for no. Two hands.
Chair Brankard, the motion passed.
Was the vote?
1, 2, 3, 4, 5, 6, 7 in the affirmative. 1, 2, 3, 4 no's and 1 abstention. 1 in absentia.
All right, just to clarify, under the commission statute, we need 6 affirmative votes, and so we have them. All right,
Yes.
next question is, when do we have this hearing?
The motion allowed the chair to figure all that out.
Out in 5 years.
Well, I mean, this is a serious issue because obviously the parties want to have this hearing this year and a decision this year. That seems a little ambitious.
Chair Brinkard.
Yes.
I was just going to agree. I don't think that we even have the time in our schedule to hold a hearing of this length. I'm just speculating. It's possible that we may, but I know we have a very full schedule already.
Okay. So we could end up setting a time for next year, which means we're dumping it on the next administration.
Yeah.
I mean, there's a good
think
chance
if we
by
do it
January.
next year, we'd probably
the
have
10
to
of
do
us
it
will be
after
here.
March.
Yeah, after the legislative session next year.
Mm-hmm.
I'd just like to comment on that. We've got very full schedule through September. This hearing is going to be lengthy and contentious. So it seems like perhaps the earliest we could do it is in November, but then we run up against the holidays. And both Thanksgiving and Christmas, it seems to me, I don't see how we can do it before the first of the year.
Yeah, we have a hearing set in November already. Plus, we have the deliberations for the triennial review.
Yes.
Do we have a motion? Commissioner Sloan, I'm assuming that was a serious motion, Commissioner Sloan?
Part of my original motion was to allow the chair to set the date, appoint the hearing officer, and determine the location. So we already passed that motion.
All right. Didn't realize that was part of your motion. All right, I will go forth and set a date.
Chair.
All right.
And I believe last time we set a hearing, the hearing officer was involved in trying to figure out where this would fit with all the parties.
Yeah. I'm sure we will have interventions in this matter coming soon. All right. We take a break, or should we try to start this hearing? All right. Taking a break. Don't be long. 10 minutes.
Switch this person over here. Oops.
I guess you all are not as exciting as the last agenda item. Don't have much of a crowd. Exactly. All right. So I will call on the commission back to order here. And the next item agenda is item 8, WQCC 25-57. This is a hearing in the matter of petition to approve partial abatement completion report for the former Fox and Associate site. JVP Partnership is the petitioner, and I will hand this over to our esteemed hearing officer, Felicia Orth. Take us forward.
Thank you very much, Mr. Chair. My name is Felicia Orth, appointed by the Commission to conduct a hearing on the petition for alternative abatement standards at the former Fox and Associates site on Bryn Mawr in Albuquerque, docketed by the Commission Administrator as WQCC 25-57. The facility is a former geotechnical testing laboratory that disposed of 1,1,1-triochloroethane, it's TCE, down a dry well on the facility property. Previous corrective action and abatement has resulted in cleanup of the source area soils. The remaining actionable contamination is in the Albuquerque Regional Aquifer, which has detached from the source and moved down gradient. Petition for hearing was filed pursuant to 20.1.3 of the New Mexico Administrative Code, the Commission's adjudicatory rules, after the New Mexico Environment Department Groundwater Bureau concluded that the requested alternative abatement standards should not be approved. In addition to petitioner and department, parties include the Albuquerque-Bernalillo County Water Utility Authority, which also opposes the approval of the alternative abatement standards. The Commission is directed to 20.6.2.4103 of its groundwater regulations, setting out the criteria by which this request is evaluated. I did ask the administrator to provide each commissioner with a hard copy of that for reference. Petitioner bears the burden of proof on each of the elements required for approval. The hearing, will be conducted in accordance with 20.1.3, the Commission's adjudicatory procedures, specifically 20.1.3.18, titled Procedures for Variance Hearings. These procedures provide that any member of the general public may testify, and the administrator has received a few public written comments, which are posted on the docketed matters page. I will invite oral public comment during this hearing. Please, if you're here to provide oral public comment, put the appropriate notation on the sign-in sheet. The sign-in sheet is, or speak with Luis Lopez or Pamela Jones over here at the back desk. We'll get you taken care of. All relevant documents are posted on the Commission's Docketed Matters webpage. The parties will present a total of 7 witnesses. We have 3 from the petitioner, 2 from the department, and 2 from the Water Utility Authority. All testimony is taken under oath and subject to cross-examination. The petitioner has arranged for an excellent court reporter to provide a transcript to the commission. Please see the court reporter to purchase a copy of the transcript for yourself. That's David Lee of Cumbrae Reporter. The commission may deliberate immediately following the hearing or may choose to deliberate in a subsequent meeting. They will make that decision when we close the evidentiary record. So, counsel, may I have your appearances? And we'll start with Mr. Domenici.
Good morning, Madam Hearing Officer and Commissioners. Pete Domenici, and I represent the petitioner.
Thank
and I
you.
have my co-counsel, Zach Kim, with me at council table.
All right, thank you, Mr. Knight.
Good morning.
We need you to speak into a, you can even go over there.
Good morning. Andrew Knight with the New Mexico Environment Department, representing the department.
Thank you.
Good morning, everybody. My name is John Stomp, and I am representing the Albuquerque-Bernalillo County Water Utility Authority.
Thank you, Mr. Stomp. All right, are there any preliminary matters before I invite opening statements? No? All right. In that case, each party has the choice to make their opening statement at this time, or you can reserve until immediately prior to your presentation. Mr. Domenici, why don't you start?
Thank you. Members of the commission, the alternative abatement standards is a critical component of the groundwater quality regulations regulating groundwater. New Mexico has chosen not to move in the direction of adopting risk-based corrective action. So corrective action, or abatement as it's called in the regs, is typically governed by a numerical standard. And in order to close a site, you have to meet these numerical standards for 8 consecutive quarters, be below them. That can be extremely difficult, extremely expensive, and in some cases, of very little health or risk-based value. But rather than adopt a risk-based protocol, which many other states have done, which allows sites to close, when you get to a point where the plume may be stable, the contaminants are perhaps slowly attenuating. We sometimes allow natural attenuation, but that requires the state to remain open, monitoring to continue indefinitely, the wells to continue to have to be maintained. And in some cases like this one, which we think is not correct, the state, even after monitoring for a significant period of time, wants additional work on sites that might be considered pretty marginal in terms of the risk and the benefit for that additional work. So what you created, as you and your predecessor, you created an alternative abatement standard process to allow responsible parties to request an alternative standard be adopted on a very much site-specific analysis. In other regulatory regimes, this might be called a variance or something like that. So that's why we follow the variance procedures of the rule. But it is, strictly speaking, it says for this location, the standard for, in this case, 11 DCE will be just for this location. The standard could be either the standard that is already in the risk assessment, tap water risk assessment screening levels. So there's a very safe standard already out there that says if we're screening tap water, which is the same as drinking water, to see if we need to do additional investigation or this exact component, you have to require further work, you would have to be above 284 parts per billion. So that's a existing adopted tap water screening standard. Another standard that we propose that's even lower, but we could satisfy at this site, would be 70 parts per billion. The numerical standard is 7 parts per billion, and that is based on a risk of one risk, I don't think it's cancer, one risk, additional risk in 1 million people over a lifetime of ingestion. That's a extremely stringent and conservative standard. If we use the 1 in 100,000 standard, which is in your regulations, that is the default you use for toxic pollutants that do not have a standard. You use the risk level of 1 in 100,000. If you use that for this circumstance, the number would be 70 parts per billion, and we would be below that. We would adopt that standard, and then this site could be closed. So that's the purpose of alternative abatement. It's to allow a pathway to closure for a site. And at this site, we know this site already is 40 times, is 4 times below the tap water screening level. So if this were just tap water, there would be no further investigation required under the screening levels adopted by this commission and implemented by the Hazardous Waste Bureau and the Groundwater Bureau. If you adopted or just cross-referenced your own toxic pollutant standard of 1 in 100,000, your number would be 70 parts per billion, and we would be below that. So we do think there's a strong risk-based reason why this petition should be considered. The other piece of this, it really comes from the Water Authority, and they are legitimately very concerned about a particular well, their Santa Barbara well. And they've used modeling analysis to try to identify whether this contamination, if the petition were granted, would pose a risk to their Santa Barbara well. Their analysis is based completely on modeling. What we will ask you to consider is, and I want to show a map here and explain a little bit just about where we're located. If you all are familiar with Albuquerque, let's see if we can get our map up there. So I'll keep going while we get it up. But Fox and Associates was actually in the environmental field in the early days. They were doing geotesting, and they were when they ran their lab analysis, they were using solvents in the 70s, and they were putting those solvents in a dry well. And that's really what we're dealing with, is a legacy from the 1970s from a geo testing facility. And it was actually located almost in a house. It was in the between Manal and Candelaria on Bryn Mawr is where this was located. Not a warehouse, not a big industrial facility. It's a little small, several person testing entity. So in the north corner, along the north boundary, there is where the Fox and Associates location was, right on that blue line where there's an X. They were using this dry well in the 80s. NMED actually was doing some testing in this general vicinity for potential Superfund sites, and they did some screening, put in some screening borings, and that's how this site was identified, was from Superfund screening. That is not that uncommon. The state does that at various places around the state. What it is important is many times that screening identifies a source, but that source is not risky enough or does not qualify for CERCLA status, so the site is moved into abatement. So I think that's important. The site never went into CERCLA, but it was identified early on through a CERCLA study process. What happened was, after it went into abatement, a vapor extraction system was put on the well or near that dry well. And to remove the source, there were monitor wells in the shallow perched aquifer, and that part of the site has been closed. There's been soil sampling in the source area that allowed it to be closed. The perched aquifer was determined to be clean, but it is now also dry. And so there's no water in the perched aquifer. So many of the analyses that the Water Authority civil engineers did, they don't even identify that it is, the perched aquifer is no longer. First, they don't identify that it was closed. And then second, they don't identify that it doesn't even exist. So they critique really outdated information. What is critical, and we don't want to pose any threat to a city well, and we don't pose any threat to a city well. What is critical is there are 3 wells in the alluvium just below that perched aquifer, which is part of the very upper tier of the regional aquifer. There is a well, monitor well 7, which is down at the very bottom of the map. That well, depending on the direction of groundwater flow, and the groundwater flow fluctuates, but it generally goes from the top of the box to the south. And depending on other circumstances, it may move over a little bit to the east and a little more to the west. This well is particularly well located to capture where that groundwater gradient may be moving slightly. And it is not very far downstream. It's 720 feet. It has shown either zero detect or 1 part per billion. So it is a true accurate data point of what is happening with this very limited residual contamination. The modeling that the authority did is completely contradicted by this hard piece of data that has been regularly sampled now for I want to say almost 30 years. So their assumptions about what might flow from this and how it might reach Santa Barbara are directly contradicted by the on-site monitor well. The wells that actually show contamination are in the middle here. They're monitor well 4 and monitor well 2. And what those show is, is that, so this just gives an overview of what's going on. And so since the plume has detached from the old Fox site at the north there, this is an unusual site where the responsible party doesn't own any property in this vicinity. The location, the old Fox location has been sold, and that's the money that's been used to fund the activities that have been taking place. So the responsible party is the corporate partnership that owned that, which has limited funds. And you will hear from Charlie Miller's daughter, the managing member of that has dementia. He's in very difficult condition. He's been living under the stress of this for many years. And in light of the risk analysis that I showed you, which is NMED's own risk tools that they use, and they're your tools that you adopted to show that this is not a risk in the groundwater. It would only be a risk, of course, if it's accessed and drinking or ingested. So when we deal with all these groundwater problems, I think it's important to keep in mind they are only a risk if they're going to be ingested. And there is no likelihood. Everywhere here is in the heart of the service area of the city of Albuquerque. It's in the heart of the central core of Northeast Albuquerque. And we can put a barrier on this that prohibits any domestic wells from being drilled in there. So the chance of ingestion of this is virtually none. No one has any reason to drill a well here. A city well the Santa Barbara well is a long distance away, and their modeling that shows it might be impacted is directly contradicted by 30 years of direct data of the down gradient well. And their modeling also does not take into account what would actually happen to this contaminant as it travels. So we will go through the elements of alternative abatement. They're pretty formal. You have to show you've tried to abate it. You have to show it's not feasible or technically practicable to do more. You have to give an analysis that it will not pose a significant risk. We will go through all of that with our expert, Jay Snyder, who put this petition together. Just for your information, another petition was presented to you. Maybe one or two of you were here for that. It was a nitrate situation out by the Old Price's Dairy. Very similar. They tried to remediate that. It was simply not going to be remediated. We put the engineer control, state engineer control on top of that to prohibit wells. That's been platted and designed for affordable housing. Frankly, that property was not going to be developed absent that petition being granted. So there's precedent for these being granted. This one is different. That was nitrates. This is solvents. This is in an already built up area. We're not trying to redevelop. That's not the purpose here. We're actually trying to close a site that we think should be closed. So that's what we hope our evidence will show you. Thank you.
Thank you, Mr. Domenici. Mr. Knight, would you like to offer something now or later? Thank you. Mr. Stomp.
Thank you very much. I'd like to reserve
All right, thank you. Both counsel chose to reserve. Mr. Domenici, if you would call your first witness, please. I'm noticing that this table that might be used as a witness table, A is facing the wrong way and B is not mic'd. So what we've been doing recently with the commission and the board is putting the witness at one end of the dais and any examining counsel, you're fine to sit there. But let's say on cross-exam, the examining counsel can sit at the other side.
Oh, certainly. So I'll call Leslie Alvarado.
All righty.
If you would sit over there.
Yes. And pull the microphone close to you and press the button until it's green. And if you would spell your first and last name.
My first name is Leslie, Leslie, Alvarado, Alvarado.
Do you swear or affirm to tell the truth?
Yes.
Thank you. Go ahead.
Will you state your name for the record, please?
Leslie Alvarado.
And where do you live?
In Albuquerque, well, Tejeras, New Mexico.
And how are you related to Charlie Miller?
He is my father.
And can you describe his health?
Yes. So unfortunately, as Mr. Domenici stated, it started about 4 years ago with Fox and JVP. And for the past 20 years, it's been my father dealing with this and managing this. Unfortunately, over probably the past year, he's experienced some pretty rapid onset signs of dementia and diminished capacity.
And is that why he's not here today?
Yes. He's actually at a doctor's appointment today, so hopefully we're working to get some help for him in his future health.
Have you discussed this situation with him?
I've tried. So, I remember this from when I was a kid. I remember him and my mom talking about the Fox building, and but obviously no details were shared at that point. I had to do some investigation to get Mr. Snyder and Mr. Domenici's phone number to kind of step in to help my father with this. But the questions that I've asked him, he's been unable to answer, even at one point stating, we've never had legal representation for this. So it's gotten to the point where I'm unable to gather much information, unfortunately, from my father.
Is he able to manage, read correspondence from the Environment Department telling him he is required to do something or not required to do something?
I would say at this point, he does not have a full understanding. He's told me multiple times, I get multiple phone calls from him daily. And he's told me multiple times that this is done and taken care of and no further action is necessary. And then other days he's asking about it. So I'm not sure he has the capacity to fully understand documents that are being sent to him.
Is there anyone else that is available to approve work that needs to be done or authorize activities or responses?
Nope, I think at that point that would be me, and I'm not sure I'm qualified.
And you're not an owner of Fox and Associates or JVP?
No.
And do you feel you have any obligation to try to step in or do anything in this matter?
No, I mean, at this point, I'm here, obviously today to represent my father, but my job at this point is making sure that my father's health is taken care of, moving on through the last probably years of his life. So.
And before the last year or two, well, let me ask it this way. Have you noticed that stress related to this situation has impacted your father?
Absolutely. So, among other things, I mean, I think part of the symptoms that he's showing is increased stress. He's become a little bit paranoid, but he gets very worked up. As I stated, I'll get multiple phone calls, stepping out of meetings to try to calm him down. And as of recently, it's been a lot of times it's over this specific matter. And I think a lot of it has to do with he just fully doesn't understand what's happening at this point.
Do you have information as to what the joint venture partnership corporation has available to continue to perform activities?
I've found a somewhat recent bank statement. I've looked for documents, and I really truly haven't found much, to be honest with you.
And how much is in the bank account?
Not a full quote, but I believe it was somewhere around $380,000. And I believe the majority of that was from the sale of the property.
Do you think it would benefit your father to have the certainty of knowing that this site is able to proceed towards closure?
Absolutely. And that is my sole purpose of being here today. I can't offer much value whatsoever as far as science is involved, but I would like to look into closing this matter for my dad, and he's unable to do so for himself. So.
Okay. So I think we may not have stated this on the record. I think all the council have agreed to stipulate to everyone's exhibits. So rather than move this exhibit 1 in, I'm going to move all of my exhibits in, including exhibit 1. So I'll go ahead and do that.
Thank you, Mr. Domenici. Mr. Knight?
No objection.
All right, and you confirm the stipulation. All right, he did. Mr. Stomp?
Yes, I confirm the stipulation.
Thank you very much. All of petitioner's exhibits are admitted. Go ahead.
So I don't have any further questions.
All right. Mr. Knight, do you have questions of this witness?
No.
All right, he said no. Mr. Stomp? No questions for Mr. Stomp. Commissioners, I'll start with Commissioner Sloan on the end. He's nodding his head no. Commissioner Chakalian, no. Commissioner Bayless, no. Commissioner Thompson, we've lost the chair momentarily. Commissioner Chapman, and no. All right. And council, nothing. All right. Thank you very much, Mr. Domenici and Ms. Alvarado.
Thank you, and thank you for your time.
So I'll call my next witness is Jay Snyder.
All right. Thank you. Mr. Snyder, if you would spell your first and last name, please.
J-A-Y.
Green.
J-A-Y, Snyder, S-N-Y-D-E-R.
Thank you. Do you swear or affirm to tell the truth?
I do.
All right, thank you. And I'm sorry, Mr. Domenici, for the interruption. I managed to forget that we have at least 3 commissioners on the platform. Commissioners, I'm very sorry for skipping you. I won't do that again. Did you have questions of the last witness? No. Okay, thank you. I trust if you did, you would have unmuted yourself. Thank you. I forgot. Go ahead, Mr. Domenici.
Mr. Snyder, briefly describe your qualifications.
I am a professional engineer and a professional geologist. I've got a bachelor's degree in geology, a bachelor's degree in meteorology, a master's in geophysics from New Mexico State, and a master's in geological engineering from the University of Idaho.
And describe your experience in groundwater investigation and remediation similar to this site.
It has been my entire practice for 36 years. I have worked on Superfund sites in virtually every state west of the Mississippi, RECRA facilities, including Kirtland Air Force Base here locally, and a number of sites in the state, from groundwater remediation oversight section sites like Charlie's to dairy farms. So I've got a lot of breadth in practice. I've worked on creosote sites, solvent sites, metal sites, and fuel hydrocarbon sites throughout the West.
Were you involved in another alternative abatement petition before the commission?
Yes, actually two of them. The first was on behalf of the former Price's Dairy, and then the second was to provide a clarification, but we had a hearing, which was the clarification that facilitated the residential housing development on an otherwise fallow lot.
Have you been accepted as an expert witness in administrative hearings, state and federal court?
Yes, I have. And in fact, I was a witness during the 2020 update of 20.6.2 rulemaking in 2018.
So I'll move for admission of Jay Snyder as an expert in geohydrology, geologic engineering, groundwater contamination, remediation.
All right, Mr. Knight, do you object to that recognition? Mr. Stomp? All right, no objection. He's so recognized.
Can you focus a little bit on, before you get to the petition, I wanted to ask you just a couple questions. First of all, you weren't the original consultant on this site for Fox, correct?
No.
And was that Metric?
Yes, the first consultant to take up the site when it came out of site inspection that the state was working on was Metric.
And how long have you been involved with this site?
Well, when Gary Richardson passed, his portfolio went to Chuck Easterling and Easterling Engineering locally. And then when Chuck retired, some of the portfolio that was contaminant related that he had acquired from Gary Richardson, Chuck asked me if I was interested in it, and that's how I got involved. I said, yes, I'll deal with it.
Okay. Do you have a PowerPoint that sort of summarizes your direct testimony and rebuttal testimony?
Yes, and it's up.
And you before you get that, I just want to ask one thing. Are you familiar with the abatement process, the groundwater abatement process?
Yes, all elements of it.
And have you taken sites through abatement all the way through, I think what they call it, abatement completion?
Yes.
And did at some point during your work on this site, did you determine that this would be a good site for an alternative abatement petition?
Yes. Yes, I came to that conclusion about 2 years ago, and I'll leave it at that.
Okay. Okay. Please go ahead and let's hear your summary of your direct and rebuttal.
Thank you. Next slide. So I'll start with just a summary of the hydrology and peat cover. regulated, the perched aquifer at about 65 feet, and then the regional groundwater at about 200 feet. The perched aquifer no longer exists because it was fed by an unlined city storm drainage. And that's how it was recharged. The city relined that with a box culvert and cut off the recharge. And within the span of, maybe a half a decade, the perched layer drained down and vanished. So there was no longer any regulated groundwater there. The soil vapor extraction had been applied to the source area and had cleaned up the soil contamination there. We verified that using soil vapor concentrations, which are much more sensitive than soil samples. And we petitioned for a partial closure of the source area, and it was granted in 2019. Obviously, some contamination made it past the perching clay. Next slide, please. Some contamination made it past the perching clay into the regional aquifer. And we've been monitoring that since about 2014, I think. In 2018, to prepare to close out the source area, I put in a multi-port well in the source area where I tested soil vapor concentrations. And I also completed the bottom soil vapor well into the top of the aquifer to test what the source area groundwater concentrations were at that time. And they were at 3.6 and below standards. So we filed for completion of abatement, and it was granted. The regional groundwater plume has detached from the source because the source was cleaned up. And I've observed this at other solvent sites, and it's well understood in the practice that you can get this type of a plume. I believe EPA calls it a type 3 plume, just for the record. And it's sitting down there at Aztec and Lafayette Street. And right now it's stable. It's not migrating. And the concentrations are variable, but they are in general waning. They are not waxing. The water table has risen 25 feet since the authority went on Chama water. And so that has moved groundwater back up into some clay and silt and so forth, which I'll go over. After the release, though, the water table in Albuquerque was still dropping. So this plume moved down through this silty clayey layer and down into sand below it. After 2008, when the water table came up another 25 feet, it moved back up into this. And so that's kind of what has caused some of the variable conditions. Next slide. So the water levels have recovered to almost where they were in 1990, before the Albuquerque Kona Depression really started to accelerate based on USGS modeling. It's moved back up into fine-grained sediments where probably some contamination was sorbed when it moved through this layer when the plume was developed. It's now moved back up into this sorbed contamination, which can resolubilize into the groundwater. And that's known in the practice as back diffusion now. And back diffusion is very problematic with respect to meeting an MCL. But it does explain that the water table has come back up into this lower permeability silty clay zone. It does explain why it's not moving, why it's stable, and but it's persistent and declining. Next. So this shows the direction of groundwater flow from northwest to southeast, MW7 being down gradient. It varies somewhat. You'll see that the model shows that the trajectory is a little bit to the west of this. You will also see a potentiometric surface map. You'll also see a potentiometric surface map presented today that shows it's east of the way it is towards MW7. So it's variable, but the mean flow is towards MW7. NMED put in MW7. They understood where to put in MW7, and it is in the correct position. And this shows what I talked about, the Kona Depression forming in Albuquerque. The star on here is Charlie's site. And these dates are, I got to look at this. The left diagram is 1980. The middle one is 1990. and the right one is 2000. So that shows over 20 years how the Kona Depression formed in Albuquerque. And so you can see how deep, much deeper it was to groundwater at the Red Star in 2000. It has recovered back to about where it was in 1990, about 200 feet below grade. Next. And so this is MW4, and the gap in the record here is where the site was relatively inactive and the data sparse, but you can see how deep the water table was to the left of this diagram. I've marked on here vertically the Chama Water Project coming on in 2008. And you can see the rise in water table that I have seen since I've been involved with the site, which are the data on the right-hand side of this picture. And that represents a rebound of 25 feet. Next. MW4 shows the variability, and MW4 is very instructive. So once the water table rose back up into this silt and clay, we jumped to these higher concentrations from where we were when the water table was lower and down in the sand. And even though the record is highly variable here, you can see the peaks of these and the troughs of these still follow a general degradation rate. And so things are getting better, not worse. And that's what you would expect with a detached plume, correct? It's no longer being sourced, so it's not going to get worse. It can only get better. And that's where we're at. Next. And this is the MW4D well log. It was logged by NMED. And I show here what's happened. So the bottom orange line is low water, and the arrow there, and we're in sand. Since the Rio Chama project went on, the water table rose up into, and you can see those layers up there. They're all silty sand, clay, sandy clay, but lower permeability, more silt, more ability to absorb contamination. And when the water table moved up into it, it's dissolving and partitioning contamination that's been trapped in these layers. Next. And here's the water table map from our recent modeling. And I've put an arrow on here from the dry well to MW7. So that's not the direction of groundwater flow. It's where MW7 is relative to the dry well. And I'm showing even a little bit east of straight towards MW7 right now in this depiction as well. But it varies again because of two things. The gradient is really flat, and it's subject to nuance in pumping with regard to the city's pumping stresses. So can it shift a little bit? Yes, and it absolutely does. Next. And again, this is the figure that Pete had up and he already showed. And I want to look at this because the numbers are hard to see, but I put on this figure, I put the average, the low, and the high over the last 10 monitoring periods in here. And MW2 has had, at the top, an average of 19.5. Again, this is relative to the 3103 standard of 7. It had a high of 48 and a low of 3.6, I think that is. MW4 has varied from a high of 50 to a low of 2.1 or 7.1, and an average of 25.3. And then MW7 has always been below standards. And it was always non-detect until I took the site over and I'm like, I need to know what's going on at MW7. So I had the laboratory actually catalog estimated values of DCE, which they can do. It's not quantified, but it's an indication that it's there. And when I did that, I picked up 0.1 parts per billion, 0.2, 0.5 parts per billion, way below standards. But it makes a perfect sentinel well because you know it's down gradient, you know it's well below standards, and you know if the plume's migrating and mobile, the concentrations are going to increase, and they have not increased. Next slide. I'll go over the abatement history here quick. Next. So in 1978, Fox moved into Bryn Mawr. By 88, the NMED interviews an informant and former employees. Fox declares bankruptcy in 1990, but they plugged the dry well in 85. So the last known timing on release was 85, or 41 years ago. And then under the site inspection program, the NMED did these activities between 1989 and 1998. Next. In 2007, so when it did not become a Superfund site or get listed by EPA out of the CERCLA site inspection process, it finally wound up in abatement, as Mr. Domenici had mentioned earlier. And so Metric was hired and submitted the stage 2 abatement plan in 2007. And they implemented the SVE and operated it. I took over the site about, I think in 2015 or so. And in 2017 is where I put in a multi-level well to see what was left in the source area after it had been cleaned up. In 2018, we submitted a partial abatement completion report. NMED granted it in 2019 and closed it out. And in 2020, all of the shallow wells, there were 3 of them, they were plugged and abandoned. Next. In November of 2024, I sent kind of a tech memo and an email providing, an estimate of the mass remaining, what the concentration trends were telling me to NMED, to just start the conversation on, can we go to an alternative abatement standard? In December of 2024, I got an email that they declined. In 2025 of May, we filed a petition for alternative abatement standard. The NMED then required that I modify the stage 2 abatement plan to actively remediate groundwater contamination. And I'd already pointed out that we were down to about 1.2 kilograms or a liter in the groundwater. We filed a stage 2 abatement plan in return that used the 4103E mechanism of alternative abatement standards to immediately achieve 4103 requirements and close the site. In September 2025, I notified the NMED of the intent to formally file. And in November 2025, after I filed, I got a notice of deficiency on my abatement plan, which basically just kind of threw a monkey wrench in the timetable. So we had to file for dispute resolution to kick that can down the road and have this hearing. Next. Now I want to go over the basis for the alternative abatement standard, and this goes back to the 2020 rulemaking. Next. There we go. So NMED's response to my petition is that it's not that my proposed alternative abatement standard is not protective, and that tap water screening levels are used to determine the presence of contamination and no way a substitute for the 3103 standards. But I propose something that is indeed a 3103 standard. Next. The proposed AAS is at the 1 in 100,000 risk level, which is the NMED risk threshold. They use it in Superfund. They use it to regulate toxic pollutants. It is a 3103 standard per 3103A2, which was added to the rule in 2020. It provides a basis for the NMED to regulate PFAS, for example, in the state. Because PFAS does not have an enumerated standard at 3103A1. You go to 3103 200-3A2 and back to the toxic pollutant list to regulate PFAS. But it's not used to determine the presence of contamination. It is a risk-based standard that follows the EPA protocol going back to the 80s in EPA's risk assessment guidance. Next. And this is how it's determined. This is right out of NMED's risk assessment guidance for site investigations and remediation. And the equations are on the left and the meaning, but this is not just some kind of arbitrary screening level. These are risk-based screening levels following well-established EPA protocol. Next. And this is an excerpt from my testimony in 2018 in the 2020 update of the rule. And Commissioner DeRose Bamman asked me how one could meet the abatement standards of A2 cited under 4103 if there wasn't a numerical standard. I mean, then what is the number? And I pointed out that the Hazardous Waste Bureau had developed the risk assessment guidelines, and that 10 to the minus fifth screening levels, which was the standard for toxic pollutants even before the update of the rule in 2020, that they were all provided in table A1 of the risk assessment guidance. And I had referred to it as the Hazardous Waste Bureau's risk assessment guidance. And an attorney for the state at the hearing told me, no, that applies to all NMED programs. So it's a broad risk assessment guidance. And there was no challenge to it by anyone at the time. Next. So here's how we get to my proposed AAS. That it's a toxic pollutant under 20.6.2, 3103, and it is risk-based. It covers ingestion, inhalation, etc. And I'm required to meet the standards of subsections A, B, and C of 3103 as an abatement, alternative abatement standard requirement. Well, what I proposed is 3103A2 based, so it meets that. Next. So under the standards, A1 are the numerical standards, the enumerated standards, and 11 DCE is 0.007. And again, we've covered this. The standard for toxic pollutants is 1 in 100,000 risk threshold. And almost every state I work in, and I've worked in probably 15 or 20 states, states use 1 in 100,000 risk thresholds. EPA uses 1 in a million. Next. And so where did I find this? And again, it's in the risk assessment guidance. Next. And here's an excerpt right out of NMED's risk assessment guidance. And there's the number 284 for the tap water screening level for 11 DCE. So at 1 in 100,000 risk threshold, the risk-based protective standard for 11 DCE is 284. Next. And again, this is based on ingestion and dermal contact with domestic household water, inhalation of volatiles in domestic household water, developed for residential land use only. So they're more stringent than commercial. Next. And again, it's based on EPA methodology. These and I showed you the equations, but this basically says this is EPA and NMED risk assessment guidance based standard. It's not arbitrary. It's not a screen. It's not just a actionable screening level. Are you regulated? Aren't you regulated? Next. So the toxicological factors change over time, and table A1, NMED has updated several times as toxicological factors change or as they bring in new contaminants. The MCL for DCE was established in 2000 or no 19 89, I think, but it was a while ago. It was when the original MCLs were established in the Safe Drinking Water Act. And so risk factors have changed since then, but at the time it was established at 7. And again, because 10 to the minus fifth allows you 10 times the concentration that 10 to the minus sixth does, if we accept that the 7 was a risk-based standard and the toxicological factors have not changed, I'm still within the state rule under A2 of 1 in 100,000 threshold by taking it to 70 micrograms per liter. And again, out of the risk assessment guidelines, it's 284. I don't need the 284. 70, I haven't had a concentration above 50 in the last 10 monitoring events. Next. And again, I just kind of pointed this out, and my highest concentration between well 4 and well 2 is 50. If I can get 10 times or 10 to the minus fifth risk instead of 10 to the minus sixth on the 3103 A1 enumerated standard of 7, I'm protective. It's protective of human health and the environment, and it can achieve site closure. Next. And now I'll go into some of the comments and my response. Next. NMBD claimed that the boundaries of the contaminant plume have not been defined, and groundwater movement beneath the site ensures that these boundaries will change over time. Next. Monitoring well 7 was placed by NMED, and it is down gradient. It's had very low level hits, like I said, below a part per billion, nowhere near the standard, and it's never increased. So it has just a flat trend of acceptable. The direction of groundwater flow varies a little bit, and again, it's nuanced based on what the city's doing. Do they have to pump? Are we getting rain? Is it dry? I mean, they have a variable pumping schedule. And the direction of groundwater flow has never varied from the direction that I've shown towards MW7, other than maybe 10 degrees one way or 10 degrees the other. But if you took the average, it's right where NMED put their down gradient well. Next. The rise in the water table is what is responsible for the increases in concentrations, and I've already showed that. And the thing that's really peculiar about this site is the variability in the concentrations. We've sampled in February, for example, and we might get a concentration of 30, and then we sample it in August or early September, it might be down to 5. And then it goes back up. So there's definitely variability that's related to nuance going on with the plume moving in there. But I have never seen a plume. If you take like MW4, if its high was 50 and its low was 7.1, I've never seen a plume where that means that you've got a whole lot of contamination still migrating from up gradient through you. It's almost always related to nuance in water level fluctuations or slight changes in gradients, which means that some of these wells are on the edge, are on the edges of this detached stranded plume, and that creates this variability. Next. And I covered the concentrations of MW2 and MW4 in here, and I've already discussed their peaks, their lows, and their average. And that when we did check the groundwater we drilled, I think, 10 feet from the former discharge well, dry disposal well. We had 3.6 at the source area, which means that the cleanup did cut off the migration of contaminants to groundwater, and the plume just slowly detached. Next. The NMED, this is an email in December 2014, where they were not allowing or supporting my AAS discussion, but they state the Groundwater Quality Bureau acknowledges that current site conditions do not appear to present a risk to receptors hydrologically down gradient. However, site conditions are subject to change, which is a true statement for any site. Next slide. On the economic capability of the person. Next slide. EA provided a rough order of magnitude cost estimate that I prepared, that if we were to attempt to pump and treat this and could clean it up in a few years, we'd be at about 1.5 million. Injections might be at about 1 million, and that's if they would result in cleanup in 3 to 5 years. But the range of cost was limited to these assumptions, and there are many sites in Albuquerque where far more money has been spent than that. The Water Authority brought up some other sites, Spartan, Kirtland Air Force Base. There are other sites in town where far more money has been spent. However, far more mass was released, and it's always proportional. Next. I am not familiar in all of my practice with any state or with EPA that 1.2 kilograms mass of contaminant in groundwater would trigger active remediation. In fact, I'm dealing with probably 15 sites throughout the nation where wells have already been impacted, and there's point of use treatment, there's hydraulic control to prevent the discharge to the supply wells, all kinds of mechanisms. So I fully understand the problem. And the example problems that were brought up, some case studies that I want to go over regarding how groundwater is treated and what needs to be cleaned up and what doesn't need to be cleaned up, is the city of Albuquerque, Los Angeles landfill, which followed a very similar trajectory to the former Fox site. North Railroad Avenue up in Espanola, it's a Superfund site. The Mountain View plume in the South Valley, it's a nitrate plume. And then the former Y service station in Clovis, where it's impacted a sole source drinking water aquifer, the Ogallala aquifer, in the city of Clovis. Next. At Los Angeles landfill, the soil and groundwater was, the soil was cleaned up with soil vapor extraction. It was pushed out of the landfill, probably some by leachate, but also significantly by methane gas generation, which will carry these solvents in the vapor phase, almost like groundwater carries the solute in the groundwater transport phase. And so pushed it down and contaminated the groundwater. Once you get that contaminant in the vapor phase over the groundwater, it will partition right into the groundwater and contaminate it that way. It doesn't need to be a liquid to liquid transfer. In 2013, Interra reported this plume of 135 acres, and with the source getting cut off, by I've got a date wrong here, I'm sorry, by 20, but later on, and I'll show it in the figure, it was down to 40 acres. And then by 2020, the actionable plume now is only like 1 acre. So it's been highly successful, and we're kind of on that same trajectory. This has been a very highly successful cleanup. Next slide. And this just shows Los Angeles landfill. And so the left figure, that trace of the red line, that's how big the plume was when Interra engaged in it and they had fully delineated their plume. And again, and it's on here, let me just read this because it's hard to read that. Give me just a second here to find this. Oh, it was 2007. The red line is 2007. The orange line is 2013. So 6 years later, they reduced it that much. And then in 2020 is the figure on the right-hand side where you can see the red line is where they're down to like 2 wells that are just above standards. So this site's getting ready to close out once they get their 8 quarters. Next slide. North Railroad Avenue has struggled a little differently than the Los Angeles landfill. It's a Superfund site. And EPA and NMED have indeed applied the maximum use of technology within the capability of the person. Multiple injections of emulsified vegetable oil and other amendments have occurred to destroy the contamination in place. And what they've injected creates strongly anaerobic conditions, and it degrades the dry cleaner solvent, which is PCE. It degrades to TCE and then to DCE, and then on to vinyl chloride. Next slide. And the problem with reductive dechlorination, the way it started at North Railroad Avenue, and we didn't know it to the degree we do now when the ROD record of decision was signed for North Railroad Avenue. But you can wind up in some precarious spots, and one of them is stalling at vinyl chloride, because vinyl chloride has a WQCC standard of 2, and it's lower than, at the time, the PCE standard, I think, was 20. It's now down to 5. So you can create a problem that's as bad or maybe even a little worse than where you started. Next slide. So nothing is guaranteed. So here is a picture that shows where we're at. And the PCE, which was released, there's almost no plume left there. TCE, which is more toxic than PCE, is that green plume in the middle. TCE has a standard of 5, but it's more toxic than PCE. And then the worst of them all is vinyl chloride. And vinyl chloride didn't even exist when this site started in remediation. And you can see the tan on the right-hand set of figures. That's the vinyl chloride plume. And so the last thing that'll get cleaned up on this site is probably going to be something that was created by the remediation technique. So nothing is guaranteed. And you have to do field scale treatability studies to determine what's appropriate, both technically and economically. Next. The Mountain View plume was a large nitrate plume, and it can be reduced in place, like I was just talking about, by putting a reductant in the groundwater, like the emulsified vegetable oil or other amendments. And a lot of contaminant mass was removed from the Mountain View plume, but the remainder of the plume was allowed to naturally attenuate. And this is common practice. I mean, I write feasibility studies and help prepare records of decisions that have this caveat all the time. Because, in groundwater remediation, any practitioner knows that, getting the first 80 or 90% out comes down on this steep slope, and you can spend twice as much money trying to get the last 10%. But if your plume is stable and declining and not migrating and does not threaten any receptors, you spend your money getting it down 90%, and then you monitor and let natural attenuation take out the last 10%. And that's what's going on here. They actively remediate it down to a target level of 40 milligrams per liter, which is 10 times the nitrate standard of 10. And now they're allowing it to attenuate. Next. And the last one is the former Y station. This is a very old abandoned gas station before the Petroleum Storage Tank Bureau regulations were even written. And it had ethylene dibromide. For anybody here that's familiar with Kirtland, it had ethylene dibromide concentrations that exceeded what Kirtland started with. And PSTB, it's a state lead site, so PSTB is the lead regulator and funding it. And they're addressing the source area, but allowing a large part of the solute plume to attenuate without even any initial treatment, to just attenuate, period. Next slide. And so this is where they're actively remediating. This is the source area, and you can see where the former Shamrock station was. This is a figure that I excerpted from Daniel B. Stevens and Associates. Next slide. This shows the entire groundwater plume. And the left-hand figure is benzene. And the area in the orange ellipse, that's not being treated at all. The highest benzene concentration in that orange ellipse is 3,600 against a 3103A1 standard for benzene of 5. So it is 3,600 divided by 5 times standards. The plume to the right is ethylene dibromide. The entire plume within the red ellipse is not being treated whatsoever. There's also plume delineation issues with benzene and ethylene dibromide. Next slide. NMED ordered the stage 2 abatement plan modification. We had to go to dispute resolution. We advised, and I went over this in some of the chronology, but we advised them of the intent for an AAS. And professionally, while I was there, was what Leslie testified to. It was becoming increasingly difficult for me to consult Charlie Miller regarding what was going on and where we're going because of his declining state. And so I'm like, how can we protectively close this site that is well documented? It's in the record. Anybody that does a phase 1 real estate transaction, this will come up. They'll know exactly what's in the record. It will be a complete record, and there'll be no surprises, and there'll be no non-disclosures. We submitted it. We submitted the petition. We were issued the directive to submit a stage 2 abatement plan. So I prepared a stage 2 abatement plan that attached my petition to the plan because it meets 4103 standards. If the commission grants this, it will meet 4103 standards. So we will be closed by rule, not really any exception. We just needed to use a variance in 4103E to get to a safe closure. If AAS is not granted, the NMED demands for active remediation, regardless of what I've shown in case studies of far more contaminated sites. We'll have to move towards dispute resolution and work through that. Next slide. So in summary, the tap water screening levels are risk-based and based on toxicology. They're not arbitrary. And the state says the risk threshold is 1 in 100,000, not 1 in a million. The federal MCLs, which most of the 3103 standards are from, are based on 1 in a million. And it's why in the 2020 rulemaking, NMED moved trichloroethene from 100 down to 5, which was the federal MCL. We were odd before they did that. There's no other state I've ever worked in that where, TCE was 20 times the MCL, but we got it fixed. 3103A2 specifies 1 in 100,000. So by rule, we go over to the toxic pollutant list. DCE is there. I apply it that way at 1 in 100,000 as specified in 3103A2. Next. The federal MCL for DCE came into effect in 1989. Tap water screening levels are based on toxicological factor, and they're not to determine the presence of contamination. I've got to delineate, whether I get an alternative standard or not, I've got to delineate my plume down to 7. And depending on conditions, it might be not down to non-detect because DCE is not natural. So, there's no background. The tap water screening levels are protective at 1 in 100,000. And again, the MCL's at 1 in a million. Next. So in closing, we've really got 2 alternatives, and this is important. If I have to achieve the 3103 standard, which is my left bullet list here, at some point, the JVP partners are not viable. And I mean, I think based on what Leslie's dealing with right now, I think we're there. When there's not an RP, we're not even going to monitor. I'm not going to have a client. There'll be no RP left to enforce on for the state. The wells will be idle and they will not be plugged. And unplugged wells that are idle are a threat to groundwater. suspect everybody in this room knows that. And the problem with them is they're all in the city streets. But if they were in unpaved areas, they get lost. And a lot of them in this state have been lost. If they're in paved areas, when the city resurfaces those streets, they can get lost. If they take it right down to base course and repave it, they'll get scraped off with an end loader and a grader. And now you've got an open conduit to groundwater. Unplugged wells are not good. The site's going to move into an orphan status. And it's already listed on the orphan list in NMED's orphan document. Why, I don't know, because it really has been active. And again, the wellheads could be destroyed with the street improvements. If I get my alternative abatement standard, where we will be is on the right-hand column. And it's going to provide a human health-based standard that is protective. That's one of the targets I need to hit in the alternative in the 4103E criteria, is I've got to be protective. It will let me achieve the 4103 requirements, so I can then proceed directly to an appropriate abatement completion and no further action. The OSE prohibition on well drilling in that rectangle that I drew will ensure that there's no exposure. And by the way, the state and the EPA put the exact restriction on groundwater in their remediation zone at North Railroad Avenue up in Espanola. So that's not uncommon. And the administrative record will be complete. Again, there will be no surprises. It'll be in the record. And I'm going to plug the wells. The wells will be plugged. There will no longer be any conduit to groundwater. There won't be any threat to groundwater. Next. And I am concluded.
Let me ask you one to follow up, and then we'll let you go. In terms of how much has been spent on this site by JVP, how much have they spent with EA approximately?
I would say on the order of $150,000 to $200,000.
And the, if I understood correctly, the SBE installation and the source activities, those were done by prior consultants?
By metric, yes.
And if you would have done that work, what would that have cost? We don't have metrics records, so I'm just asking what.
Right, but given the size of that system in that point in time, like if I'd have bid on that for the Petroleum Storage Tank Bureau, I'd have bid somewhere around 250 to 350.
So $500,000 as being spent would be in the ballpark based on your experience?
That's not unreasonable. I mean, if one put a range on this of like 350,000 to 500,000 total, I don't think anybody would question how did you spend that much money on for the work that's been done.
And how much does it cost to monitor this, say the last year, several years per year? How much does that cost?
It's $13,000 per year.
Okay, thank you. That's all I have.
All right, thank you very much, Mr. Snyder, Mr. Domenici. We need a lunch break. Let's come back at 10:02, please.
Testimony. Is this you filed this?
Yes.
Okay, here he is. So let's see if he's on. So I would call Sergio Reyes Zul.
Mr. Zool, hello. Would you spell your first and last name, please?
Hello. Sergio, Sergio. Last name is Reyes Dzul, Reyes Dzul.
Thank you. Do you swear or affirm to tell the truth?
Yes.
Thank you. Go ahead, Mr. Domenici.
So is this in the record? So were you in charge of the public notice for the alternative abatement petition?
Yes, sir, I was.
And did you provide a summary of your direct testimony that was filed along with a notice of intent and exhibits, on May 8th, 2026?
I believe that's the correct date, but yes, I did.
And just so you understand, I think all of that's already been admitted as an exhibit, but I want to make sure for the record. So this would be, for the record, the notice, unopposed notice of intent. There's exhibits 10 through 14, and then his direct testimony was all filed as part of that package. So I just want to confirm that that's admitted into evidence.
Yes, I consider it part of the stipulated admission.
Do you adopt your direct testimony today?
Yes,
By adopt it means you, without going through it, you're adopting it as your testimony.
that's correct.
Okay, so I will pass the witness for any questions.
Thank you, Mr. Domenici. I'll pause for a moment in the event there are questions from the other parties. The answer was no. I'll pause for a moment in the event there are questions from commissioners at the table. No. No. Commissioners on the platform, please unmute yourself if you have questions. No. All right. Thank you very much.
Let me, if you could bear, I just want to follow up on one question.
All
So
right.
how many public notices did you mail approximately?
I believe it was 3,058, which included the tribes. It was actually 3,060, including the Board of Health and the mayor.
Okay, that's all I have. Thank you.
All right. Thank you, Mr. Domenici. Thank you, Mr. DeZul.
Thank you.
We will return to Mr. Snyder. If you would resume your position, and Mr. Knight, if you would come to the other end of the dais.
Good afternoon. Mr. Snyder, I'm Andrew Knight with the New Mexico Environment Department. And I just have a few questions on your testimony.
Very good.
How many monitoring wells are at this site?
Right now there is MW 2, 3, 4, and 7. And that was negotiated as the abatement plan area with NMED when we closed out the source area.
And who paid for all of those monitoring wells to be installed?
NMED.
And is it true that the petitioners never installed any monitoring wells at this site? Or never paid for any wells to be installed?
They paid for the vertical well that I put in. I know this is a fact because I did it. They paid for the vertical well that I put into the source area, post soil vapor extraction cleanup, to test vapor concentrations below the perching layer and to test groundwater right at the point of discharge.
And does that well have a designation?
It was SVMW1, I believe. It was plugged and abandoned when we closed out the source area.
Okay, thank you. So, let's see. So other than monitoring well 7, there aren't any other monitoring wells outside of the source area. Is that correct?
No, there's 4. There's MW3, which is cross gradient to the west. There's MW2, which is sitting on the cross gradient some to the northeast. MW4, which is right near the intersection of Lafayette and Aztec. And then MW7, which is down gradient.
Other than MW7, though, there aren't any monitoring wells that are outside the area of the plume. Is that correct?
No, that's not correct. MW3 is outside of the plume. And MW2 was outside of the plume when I first found it and sampled it and redeveloped it in that time frame. And then it started this seasonal variability that I see in MW4. I mean, they track right along with each other.
So MW2 was originally testing non-detect, and now it is showing detections.
Exactly, and I attribute that to the rise in the water table and then these nuanced gradients that are related to city well pumping.
And let's see. So there aren't any monitoring wells to the north or to the.
Yes, there were to the north, and they were clean, and yeah.
Which wells are those?
Well, that SVMW1 that I put in to the north was clean and plugged and abandoned when we closed the source area out.
And where is that located?
Right at the dry well. Right
Yeah,
on.
right at the source.
Yes, right
Yes.
at the source.
So the plume has moved over time.
Historically, the plume moved, yes, and they do. How far they move and how long they become is a function of the source strength, and that's a function of, are you still discharging to groundwater? And when we closed out the source area, it was determined that there was no longer any discharge to the regional aquifer at 200 feet.
Correct, but the groundwater still moves in the Albuquerque regional aquifer.
Absolutely, it does.
So on the monitoring wells that are there, do you happen to know the screening interval, or at what depth these wells are sampling groundwater?
Yes, it's in the record, and yeah, I know the completion depths on it.
Are they all at about the same depth?
They were all able to sample groundwater when it was 25 feet lower, and they were all able to sample groundwater at its current position.
But there aren't any monitoring wells that are significantly deeper than those four that you mentioned.
No, I'm sorry. There's a fifth well, MW4D, and it is deeper than MW4, and it's clean. So we have vertical delineation right at our hottest monitoring well, MW4.
But only in that one well.
Yeah.
Mr. Snyder, what exactly are the boundaries of this plume?
They're within the rectangle, the abatement plan area that I drew.
Do you believe that the boundaries of this plume are a rectangle?
No, the rectangle was the agreed upon abatement plan area when we closed out the source area. I mean, when we closed out the source area, we then had to establish, okay, now what are we dealing with?
But you don't know the exact boundaries of this plume to the north, south, east, and west. Isn't that correct?
That is incorrect.
How do you know? What evidence do you have for the
MW3 is below standards, so I know I'm clean to the west. MW7 is clean and always clean down gradient. VMW1 was clean at the cleaned up source area, and MW2 at times defines clean to the northeast, and at times goes back above standards and fluctuates, like I showed in the record for MW4.
But that doesn't qualify as the boundary of a plume, does it?
Well, it does at times. What it tells me is we are right on the edge of the plume. If you've got a plume that's being sourced and it's growing, the contamination goes up, 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 and up. It doesn't go up, down, up, down, up, down. And again, you have to think about my testimony where it's attributable to the water table coming up 25 feet and into some silt, clay, and silty sand zones, which absorbed contamination as the plume dropped through it, as the Albuquerque Kona Depression grew from 1990 until 2000.
So is it your testimony that a single monitoring well is adequate to define the edge of a plume?
It depends. It was installed as, again, NMED designed that monitoring well network. I have always, if you take a look at the layout, that would have been their cross gradient well to the northeast, exactly where we're talking.
Is it fair to say, would you agree with me that this plume has been smeared? Is that a term you would find acceptable?
I usually don't use smear in the terms in terms to describe a solute plume. That's more of a source area terminology, and typically more so for like light non-aqueous phase liquids like a gasoline release.
So you mentioned, I guess, the possibility of a well prohibition if alternative abatement standards were to be granted. Has anyone applied for that well prohibition yet?
Yes, and the NMED helps facilitate it. But we put that prohibition on the former Price's Dairy, where we got the alternative abatement standard and closed it.
But has anyone applied for a well prohibition for this site?
No, not yet. It would come after. It would come after closure. Okay. It's part of the AAS. So if the AAS is granted, given my petition, I'm obligated then to provide the GIS files, the meets and bounds of what I want to restrict. NMED will help facilitate that with Office of State Engineer, and then it's in the record.
But that well prohibition, is it automatic? Does OS? No. Okay. So
no, that is an activity that I'll have to undertake with the support of NMED should I get this AAS. Because I can't go straight to the OSE and do it. If I do it in concert with NMED, then they'll put it in place.
But the decision to grant that prohibition, it's not within the control of either NMED or this commission. Isn't that correct?
It is under the control of the Office of State Engineers. And by rule, the Office of State Engineers has forever prohibited completing a well in a known area of contamination. So that exists, that institutional control exists by rule right now. This is an institutional control that's even on that, so that it will be immediately discovered if somebody because it's in the GIS database. If somebody files a well permit application within those meets and bounds, it will come up as you can't drill here.
Okay, that's all the questions.
All right, thank you very much, Mr. Knight. Mr. Stomp, do you have questions?
I do.
And Mr. Snyder, while Mr. Stomp is walking to his seat, please be careful about not stepping on the end of questions.
Oh, okay. I'm sorry.
Thank you.
Sorry about that. Mr. Snyder, do you mind if I call you Jay?
That is fine.
So if you could help me out here a little bit, you've made a lot of statements in your petition about what certain things are, and I'd like you to give us a definition of what that means.
Okay.
For example, in your exhibit 3 of your petition on page 2 of 13, you say that the plume is not being destructed by biodegradation or hydrolysis. Is not being destructed by biodegradation or hydrolysis, but rather by dispersion and advection. Can you tell me what advection is?
Advection is the transport of the groundwater and the solute that's in it.
So it's the contamination moving in the groundwater.
Yes, it's moving along with the flow of groundwater. Now, there are factors that prohibit it from moving at the same rate as the groundwater. And it's those factors that can create a stable plume, even though you still have your groundwater underflow and through flow.
Yeah, I didn't ask you about whether the plume was stable. I'll get to that. So when you say advection, you're saying the contaminant moves. It's moving. Is this plume moving?
No,
it's not moving.
No.
Your testimony here today is that this plume is not moving.
Relative to its WQCC standard, no.
That's not what I asked. Is the plume moving?
How do you define the plume? If we
you're the expert. You've defined the plume. You've given us a figure that has a square on it.
Relative
and supposedly that rectangular is the plume size. Right. Is that plume the extent of the contamination that's out from this site?
No.
What is dispersion and diffusion?
Well, dispersion is, for example, if you have, let's say you've got a trough with running water in it and you put a drop in that trough with an eyedropper of, say, red food coloring. You know how it would spread out some and thin out some and become pink? Mm-hmm. That's dispersion. Okay. That takes place in the groundwater only on a much slower basis.
Okay. So you have the movement of groundwater, you have advection that's moving, and then you have dispersion where it's spreading out. And you have somewhat of a leading edge of the plume or something to define what's actually moving along, because it's not solely advection and it's not solely dispersion or diffusion.
Or absorption.
Or absorption.
Yeah, or absorption. That's correct. And that's correct.
Okay. And you said the plume is not being destructed by biodegradation or hydrolysis. So the mass that's contained within the plume is not changing.
It will partition into the soil matrix via absorption. Mm-hmm. So it will be depleted from the groundwater. Mm-hmm. It's the same principle as how a Brita filter takes a contaminant out of your tap water if you install it.
Sure, except it's trapped and it can become reabsorbed by the groundwater, can it not?
It can, and that's an ongoing process. And the question is it getting reabsorbed above standards or below standards? If it's reabsorbed below standards, then it may not be actionable and require action.
Okay. So the soil has this contaminant that's in it, and it's absorbed to the soil, but it can become reabsorbed, and then, as you're saying, the groundwater is fluctuating up and down. So this basically is a secondary source of contamination, is it not?
Back diffusion. I've referred to that process as back diffusion, mm-hmm. and it is considered a secondary source from a pathway analysis. Mm-hmm. It's not considered a source from a discharge perspective.
Understand. So we have an ongoing source at the site.
I did not say that.
I just asked you that.
No, I said that it can repartition, but it does not mean that it's a significant source of contamination. I'll caveat it with significant. It may not be. It may be stable. It may not be stable.
When you answer your questions, I would appreciate it if you would give me what your definitions of significant, minor, what do these mean? I don't know what
relative to a standard or a cleanup target.
What standard?
The 3103A1 standard is what we're working on right now.
All right. So the soil is absorbed in absorbed in the soil. The groundwater goes up and down. It's a source for the soil. It goes back into the groundwater and starts moving away. And then the groundwater goes down again. It moves some more. And then the groundwater goes up and it has more contamination that's added to it, and so on and so forth. That's what I think you called was a seasonal fluctuation.
Well, these fluctuations are now that the water table has risen 25 feet in rebound to the switch to surface water. I don't anticipate the water table dropping 25 feet again, but it may. But these oscillations are up in these silt, clay, and silty sand layers. And so we're looking at pretty minor fluctuations in water levels now. And yet they can be significant depending on whether you're in a silty zone or a clay zone. And I think we've got slight shifting in our gradients, which is why I'm getting some of the variable concentration trend.
Can you state what your definition of conservation of mass is?
Conservation of mass is wherever it's partitioned or whatever's been destroyed, if you've got some bioremediation going on, should add up to what was, there initially or released.
Okay. But we don't have any biodegradation. You already said that there was no your written testimony says that the plume is not being destructed by biodegradation. Are you changing that testimony?
I am not changing that testimony. If there is some biodegradation going on, it's so minuscule that, for example, if I was looking at this for EPA and doing a feasibility study, I would not consider biodegradation a viable alternative.
So on the one hand, you're saying it's not there, and on the other hand, you're saying, well, it could be there.
No, I didn't.
So I'm confused.
No, I didn't.
You just said it could be so low that it's not measurable, but that means it's there. That means it's biodegrading. You said if there's none happening, and then there might be some happening. I'm confused. You can't say, you can't have both. You can't say, you said, and these are your words, the plume is not being destructed by biodegradation or hydrolysis. I don't know why I can't say that. I apologize to everybody, but rather by dispersion and advection.
And what that means by practice is I am not going to tell anybody that biodegradation will take care of this problem. To give you an example of what I'm talking about, though, if we had like the dry cleaner plume, right? You've got perchloroethylene. If 99% of your plume 20 years later is perchloroethylene and you've got 2% trichloroethylene, I would still not, you've got some biodegradation going on. I would not claim biodegradation as a mechanism that's going to deal with the perchloroethylene. These are not that sharp of boundaries, but as a practitioner, you know how to look at it and say, that process will work, that process won't work.
You're an expert. You've been designated as an expert. We did not disagree with you being an expert. You're an expert in the field. When you say there's no biodegradation, we believe there's no biodegradation. You can't change that testimony by saying, in practice, there's a little. That doesn't work. You're the expert. You said there's no biodegradation, so there is or there isn't.
I'm not objecting to the form.
Yeah,
Hold on, gentlemen, please. Mr. Stump, you've become argumentative, so I'm going to ask you to dial that back. And Mr. Snyder, again, please don't begin your answers until he's done with this question.
Thank you, Madam Hearing Officer. I'm going to move on. Do you know how much mass of DCE remains at the site?
I have calculated it at 1.2 kilograms.
And that's that square that you did in that figure that we'll call up here in a little bit?
Yes.
And the basis of that calculation is?
I used, because the data were not collected by NMED when they installed the wells. Nobody did back then, by the way. It wasn't an omission. But because the data didn't exist, I used the default parameters that are very conservative in the New Mexico risk assessment guidelines to make my partitioning calculation. Most of it was an easy calculation because it was just the volume of groundwater times the concentration of groundwater. And that's the bulk of what's left. And then I think I had maybe 20% or whatever as sorbed mass.
Are you familiar with the 1992 site assessment and then expanded 1998 assessment?
I have looked at them, yes.
I have them as exhibits if you'd like me to pull them up. In those reports, NMED estimated that the business illegally dumped somewhere around 3,000 gallons of motor oil, solvents, other contaminants. They estimated this was like 35 gallons a week for more than 5 years. You called it a discharge in your presentation, but it was 35 gallons per week for 5 years. Did you estimate the amount of total mass that the various contaminants were illegally dumped into the dry hole?
When I took the site from Charles Easterling, it had already gone all the way through soil vapor extraction and cleanup. I started off testing soil vapors to see if we had any actionable contamination left above the perching layer. And by the way, the perching layer probably did a significant job of keeping whatever the mass was discharged through that well from going deeper into the regional aquifer. Not perfect because some got through, but when I started doing my testing, because it was near the end of the soil vapor extraction and the on-site cleanup, I tested the vapor intrusion pathway. I put in VMW1 to test soil vapor concentrations below the aquitard and the groundwater at the source area. And then we proceeded to closing it out because we were below standards above the perched layer. But we did not get above standards in the perched groundwater. The perched groundwater vanished because it drained down when they lined the box culvert line to the storm drainage.
Okay, so I'll ask the question again. Do you know how much mass of DCE was removed? I'm sorry, did you estimate the total mass of the contaminants that were illegally dumped at the site? That's the question.
No, I did not.
Okay. Do you know how much mass of the 1,1 DCE was removed using the SVE system?
I do not.
So you don't know the total mass. You don't know how much was removed. Did you do a calculation? If the density is say 1.21, that's the number that you used in your calculations. 3,000 gallons of DCE would be about 13,800 kilograms of mass that was dumped into the hole. Now, it wasn't all DCE. Some of it was motor oil, some of it was xylene, some of it was other things. But even if it was 50% of that, somewhat around 7,500 kilograms of DCE was dropped into the dry hole. We don't know, you don't know how much SVE was removed.
No, nor do I know if it was 98% waste oil.
So you don't know how much mass is actually out there. They dumped 7,500 or 8,000 kilograms. You don't know how much SVE, so you don't really know the mass that's out there.
The mass that's presently out there in the source area is below standards and it was closed out by NMED.
That's not my question. Do you know the mass of contaminants that is at the plume that exists out on the site itself or outside of the site?
The mass that's outside the site is estimated at 1.2 kilograms.
Okay, that's your testimony that you understand that the total mass at the site, even though they dumped 8,000, we don't have any records of how much was taken out. Your testimony today is there's 1 kilogram left of 8,000 kilograms.
I testified, I just stated the mass outside the source area, which has been cleaned up and closed out, the mass that's outside the source area, I estimate at 1.2 kilograms.
Okay. Could you pull up the presentation? And I would like to go to, sorry, I don't know his exhibit numbers.
Was it on the PowerPoint?
Yeah, it's on the PowerPoint.
You just have to, I think, say to keep going.
Yeah, I will there it is. Thanks, Pete. I think that's it, or the one that's just like that. And I'm hearing off, so do you mind if I step and get my glasses really quick? I apologize. Sucks getting. Oh, can you give me the one that has the box, please? I'm sorry. That one. Thank you. So that 1 kilogram is the one that's located that you calculated. Is it that's in this box?
Yes, I used my highest average concentrations in the volume of groundwater, and then the volume of that box.
Okay. The average concentration, but the actual plume concentration, the actual plume concentration as a whole, we don't know that number. You know numbers at monitoring well 4, you know numbers at monitoring well 3, monitoring well 2, and monitoring well 7, but that whole area that's between monitoring well 4 and monitoring well 7, we don't have any data for that, do we not?
Right. So when I made my calculation, I applied the concentrations from, I believe, MW2 and MW4.
I understand what you did. I'm asking a different question. That concentration between those points, you do not know that exact concentration.
You don't know the concentration between any 2 monitoring wells. So the answer is no, I don't know.
Okay.
I wouldn't know if they were 10 feet apart what it was 5 feet away.
Okay. And then the box itself, you said that's the size of the plume and the size of the abatement area. They're the one and the same. I think Mr. Knight asked you that question.
That is what was negotiated when we got no further action on the source area and defined what remained of abatement and what we would do. And that agreement was this.
Okay. And is that your testimony that that's the location of the plume?
Yes.
Okay. So if we look at the eastern edge of that plume, where do we have information where the actual concentration is known along that eastern edge?
The eastern, since the plume is oriented southeast instead of due north, the cross gradient well that the NMED installed was MW2, and it was lower, and then picked up this I'm searching for a word here, but the variability in the concentration graph, in the concentration graph, just like MW4 did. And that started to occur when the groundwater came back up into, again, the silty clay, sandy clay.
Okay, but that's not my question. The eastern edge of the plume that you've identified, other than monitoring well 2, which is located at the top right-hand corner, at the bottom right-hand corner, where along that edge, along that eastern edge, do you know the concentration of the plume?
Oh, I don't.
But you said that's the size of the plume.
That's what was negotiated when we closed out.
That doesn't determine the size of the plume. The plume is determined by actual data.
Right, which is what I've been. That's what I've been.
We don't have that data.
Okay, gentlemen.
I apologize.
One at a time, and please dial it back again, Mr. Stone.
I'm sorry. I just get excitable, and I apologize to you, Mr. Snyder, and everyone. It's my personality, and it's hard to turn off, and I apologize. So along that eastern edge, there is no monitoring wells that would actually give you the data that you would need to actually draw that box. Because we don't know the concentration.
Yes,
and you said you estimated the concentration of the plume from the 2 points.
NMED agreed to that box. Let's settle it right there. Okay.
So NMED decided what the size of the plume.
It was negotiated at the time we closed out the source area, what's left and what's the plan of action going forward. Okay. And we've executed everything according to NMED direction.
Okay. And is that in your direct testimony?
It was related to the source area closeout. So I don't have a whole lot of source area closeout specifics in my testimony because it's not germane for what I'm asking for here.
But you did the calculations and you drew that square and you said it was based on an agreement with NMED. So you had to identify what that agreement is. Is that agreement in writing in your testimony?
No.
Okay, this is brand new. Nobody's heard this before.
Well, the agreement's not on paper. It was negotiated with the bureau chief at the time,
Okay.
and we established it, and we've been executing the plan since.
Okay. So we've established that we don't know the concentration of the plume between monitoring well 4 and 7. And we don't know the concentration of the plume along the eastern edge. Other than those points, we can't really define a plume.
I will make this point. If the plume is moving east, it's not moving towards Santa Barbara number 1.
Okay. Well, we'll get to that. I'd like to look at the exhibit that has the lines, the crossed hatch. I think you passed it up. He says it's the next one. He's on top of it over here. Those are lines that you put on this paper that showed basically the hydraulic grade line of the aquifer, correct?
February 2026, yes.
Okay. And if you look at those lines and you draw the flow path, which would be the advection portion of it, right? The
Yes.
advection portion of the groundwater would be heading directly perpendicular to those lines, correct? And the diffusion and dispersion would be spreading out from that. Okay. So if you look at monitoring well 4, if you draw a straight perpendicular line down from monitoring well 4, it doesn't hit monitoring well 7, does it?
This is the February 2026 map. So on this map, you can make that statement and it would be correct, but that direction has been variable slightly. Like I testified to, 10 degrees one way, maybe 10 degrees the other way. The mean groundwater flow direction is pretty much as depicted.
But you made statements earlier that monitoring well 7 was the Sentinel well, and it showed it was great because it was located in a spot at which the contamination would always go, that no matter where it was detected in these up gradient wells, it would hit monitoring well 7, and therefore it was a perfect Sentinel well. Wasn't that your testimony?
Yes.
So the concentrations of contaminants that reach monitoring well 2, if you draw a perpendicular line to those lines down, that's not even on this map, is it? It's so far away from monitoring well 7, I don't know that we can see it. But it's certainly quite a bit of ways from monitoring well 7.
Yeah, it's like probably 800 feet away, the way it profiles. The groundwater flows, a groundwater plume flows in the mean direction of groundwater. The groundwater can fluctuate and vary, but the center line of the plume, the center mass of the plume, will always be in the mean direction of groundwater flow. And I think the mean direction of groundwater flow coincides with where NMED placed that well when they decided where to put a down gradient monitoring well. You can do, the gradient is so flat here, and some of the subtle changes from the city pumping that we see, because we're in the middle, you're aware of that, you're with the water authority. We're in the middle of Santa Barbara, and then the pumping stresses to the north of us causes these variations in the gradient. But the mean gradient has always been towards MW7 and towards Santa Barbara. And MW7 is a better Sentinel well for the Santa Barbara well than it would be if it was placed farther to the east.
Okay. Could you pull up my exhibit 8, figure 3, please? It's figure 3. I don't know the page. Well, hold on, I can. It's past those tables. There's down, yeah, past that. One more. There you go. Thank you, right there. This is figure 3. This is the water table elevations that were measured at the Fox and Associates site on August 14th, 1998. And you can see monitoring well 1, 2, 3, 4, and 7's at the bottom. What direction is the groundwater flow in 1998?
I would have to, you have 1, 2, 3, you have 5 wells. I would have to reconcile 1, 2, 3. I'd have to reconcile about 4 3-point problems and then determine the average flow direction from those 3-point problems. This is taking the nuance, the fine nuance out of a flat gradient.
That's not what I'm asking you. I'm referring to this figure. This figure was done by NMED.
Mm-hmm.
Did you dispute this figure?
Until I do multiple 3-point problems on a 5-well system, because I've done them on this site every time we sample it. You do 3-point problems and the gradient is so flat, you get varying 3-point problem directions, and then you reconcile a mean groundwater flow direction. Here, they're depicting something that's more to the east.
Correct. This is the gradient in 1998 that NMED used, same as you, did the same calculations. It's a very shallow gradient. Each one of those lines represents 1/4 of a foot. But you said the direction of the flow is to the east.
To the east.
To the east.
Oh, well, to the east southeast. The direction of the flow, the way they're depicting it, I did not reconcile this figure, so I would have to actually reconcile it. I will say this though, if this is circa 98, I'm a little confused why they used this to design their monitoring system and put MW7 where they did. Moreover, if this is true and the only thing going on, MW7 should have never had a detection of anything in it.
And you said it haven't. You said
because it is way. I'm sorry. Please finish.
No, you said it hasn't.
Yes, it has.
The point I'm making.
I've got detectable.
Yeah, hold on. Yeah. Thank you, David. Truly, gentlemen, Mr. Somp, you should be asking questions to elicit information and not arguing with him. I'm going to invite you to perhaps focus on making points through your own witnesses and not trying to draw the exact point you want to make through Mr. Snyder's lips. Let's begin again, and please be very careful not to step on each other's statements.
Thank you. I'm going to move on.
Can I provide clarification to where we were? I have said.
Hold on, Mr. Snyder.
Okay.
Let Mr. Stump move on.
Okay. Could you turn to Petitioner's Exhibit 9 and it's Figure 3? I think that was it before. All right, this is your exhibit Figure 3 from Exhibit 9. It shows the same area of affected groundwater and abatement area. Can you tell me when you have a chance to see that, what are those dimensions on that abatement area?
I think it's 300 by 800. I would have, I can't see from here, but off of memory, I think that's what it was, 300 by.
And the previous one we showed was 600 by 400?
I don't think so. I mean, I don't.
We could go to that one if you want. In your direct testimony on page of Exhibit 3, in paragraph 5, when you're describing the petition requirements, the question was, describe the water body or water course affected by the discharge. You said, this is your words, the area of impacted groundwater encompasses about 240,000 square feet. What's 800 times 400?
32,000.
So this is not that number.
I thought I said this was 300 by 800.
I don't remember what that number was. Is that 300 by 800?
I can go get it and read it. I mean, if we're going to go there, let me. It's 300 by 800. Yes, it is 300 by 800.
Okay.
240,000.
Okay. And then you took the depth of that to be 20 feet.
Yes.
In terms of the amount of affected volume.
Yes.
Is there a monitoring well that's located within that square that tells you that the depth of the plume is 20 feet?
MW4D is there.
That's one point. Is there any other points in there that have any concentrations that you know of that we could use to determine the depth of the plume?
No, it's typical to have only 1 or 2 vertical delineation wells on a contaminant site this size.
Okay. So the answer is no. We don't have any other information on the depth of the plume except for one monitoring well.
No.
Okay. All right. Let's go to your economics for San Manchama water. As part of your calculation for the 240,000 square feet at 20 feet deep, you said that the volume was 33 acre feet. And you used a number to estimate what the economic value of that was to compare as part of your economic and social costs. Is that correct?
Yes.
Okay. So can you explain to me what San Manchama Project water is?
My understanding, and I am not a water resource engineer. I am a contaminant hydrologist, but my understanding is it's New Mexico's allocation out of the Colorado River Compact. For years, it was just stored in Heron Reservoir, and the city finally decided to use its resource.
So do you know how San Manchama is permitted and used in the Middle Rio Grande?
I do not.
And the Water Authority has a permit for its use. Do you know what the conditions of use are in that permit?
I do not.
Do you know how much San Manchama costs for the water itself, the permitting, the treatment, and distribution?
I do not.
Do you know what the percentages of groundwater and surface water that the Water Authority uses or plans to use in the future?
I do not.
Are you familiar with the Water Authority's groundwater permit, RG 960?
I do not.
Are you aware that they have a right to pump up to 155,000 acre feet a year and to fully utilize that permit, RG 960?
If it's in their permit, they are.
And are you aware that the groundwater that's impacted by this site is part of the area of which the Water Authority can serve its customers?
Yes.
So any contamination in this site would affect the Water Authority's ability to fulfill its legal obligation or to enable it to fulfill its legal obligations and for use of its RG 960 permit?
No.
No.
No. There's a number of contaminant plumes in Albuquerque, and the degree to which it's diminished the city's ability to fulfill its water right, I haven't analyzed, but if there's a number, I'd be interested to know.
Do you know that preserving and protecting the groundwater is a key policy for the Water Authority?
It's a key policy for everyone in this room.
Did you consider the cost of having to monitor, treat, and dispose of the contamination if it reaches the Santa Barbara well?
It will not reach the Santa Barbara well based on the data and 40 years of plume travel.
But you don't know where the plume is. You testified earlier that we don't know. We talked about that eastern edge. We do not know where the plume is.
He's
Mr.
arguing
Stump.
again.
Thank you.
Thank
Mr.
you.
Domenici, Mr. Stump, please move on.
Okay.
And would you estimate how much longer you're,
Just a few more minutes.
okay?
The administrative area, you said is going to be the same box. That's what you would recommend to the state engineer's office? Or you would have to do something different? Would it be bigger than that box or smaller than that box?
How I work is if I get my alternative abatement standard, I will work with NMED, who I am sure will in turn work with the water authority to establish the zone we want to provide the Office of State Engineer. If it needs to be larger, I'm amenable to that. It just needs to be protective.
And if you look at that picture there, that square that you've drawn, that could be the size of the administrative control, I guess it could be bigger. Do you see private property located within that square?
Yes.
So if that's the area of contaminant, hasn't it already affected the value of private property that's already been affected by the groundwater contamination?
No.
No. And wouldn't the administrative controls prohibit the use of or the ability for these private property owners to get a domestic well for themselves in the future?
They're on public water supply. I'm not sure they would even get a permit for a domestic well within your water right.
They have a constitutional right under the New Mexico Constitution to a domestic well.
Mr. Stump, I'm going to ask you not to invite the witness to speculate.
I want to object to Mr. Stomp testifying about different things. It's just what he did.
Thank you. Do you have other questions, Mr. Stump?
I do. If the plume does not stay in the area, because it is moving, and you've said it's moving, if the plume does not stay in its area, because it already represents a present hazard to the public health, because you're having to draw an administrative boundary.
Same objection. Another long testimony.
Okay, I'll ask a question.
All right.
Does the administrative control prohibit the use of private wells or public wells within that area?
That could be zoned, right? So we can prohibit the upper part of the aquifer, but not the lower part. There's hydraulic considerations that need to be made. When you get a site, like I brought it up, this institutional control, this prohibition is in place at the North Railroad Avenue plume in Espanola. On a problem like that, they're going to prohibit any well drilling and period until they get it cleaned up. Here, you could do a partial prohibition of, say, the upper 100 feet of the aquifer, but you could designate what you're going to do or take the whole area. But I would not expect anyone in that neighborhood to drill a domestic well in their front yard when they're on city water. I wouldn't expect them to put in a septic tank system. They're on city sewer.
Further questions?
Thank you, Mr. Stump. All right, let me turn to the commission. Maybe I'll start on the platform. Commissioner Zemlich, do you have questions of Mr. Stump?
Schneider.
Sorry, Mr. Snyder.
Thank you. I don't have any questions at this time.
All right, thank you. You can change your mind. Commissioner Laney.
I think I do. Some of them may just be to clarify. I'm not a technical expert, so I just want to make sure that I've followed things. Let me see here. This is a little outside of my understanding. So it sounds like there's the potential for a well prohibition, that may be necessary for an indefinite period of time. Does that indicate that the contamination remains hazardous in that area?
Yes, it's based on plume stability and the decline in concentrations at MW4 that I showed.
Okay. So I guess then, can we establish that there's no future hazard if that's the case? If that prohibition remains necessary, then it would seem that the hazard remains potential. And I'm trying to understand the flow of things, but can we establish that when the groundwater flow conditions appear to be somewhat dynamic, and changing and evolving?
Subtly changing. Subtly changing. Dynamic is not a term I would use to describe what I'm observing in this plume.
Okay. I'm not sure I got an answer here, and I may have just misheard this. There was a little bit of back and forth going on at the time that may have distorted what I was hearing. So there was a question asked about resorption in the soil, and that potentially being a source of contamination. And I don't know that I heard an answer. You said that's the question that we need, and I don't know what. Can you explain that to me? I got a little confused in that section of it. I don't know what parts of that really meant.
Thanks. I'll be glad to clarify. So when the contamination absorbed into the soil as the plume drops through this clay layer that I've described, it becomes trapped there. When the water table came back up into it, it desorbs to some degree back into the water. Now, as the water moves horizontally, and the contamination that the water picked up that desorbed, as it moves into clean soil, it's going to resorb into the soil and be depleted. So that's a depletion mechanism. That's how a plume can be stable even if the groundwater is still moving.
Okay.
And it's the same process as how it sorbs onto your Brita filter on your faucet, and it stays trapped there.
Okay. So there was a point of resorbed, so that it doesn't. I'm still struggling with the resorbed portion, I suppose. I apologize.
I'm sorry, Commissioner. There's two processes. Desorption, that's when it partitions from the soil into the water. And then the resorption would be when the water carries into clean soil that has sorptive capacity and it partitions back into the soil.
Okay. Thank you. I think I have a better understanding of the process that's occurring there. I'm going to switch slightly to some of the economic feasibility portions. If the plume is projected to achieve standards naturally in approximately 11 years, which is what you had included as an approximation, how is compliance not feasible?
Compliance is not feasible because the responsible party is going to become unviable. I'm glad you asked that question. If Charlie was 50, we wouldn't be here. This is about, can I close this site in a safe, protective manner with a full administrative record so that it's protective? Or is it going to become an orphan site?
Okay. I guess I have like an internal question for the commission is how do we distinguish between when it's technically infeasible, economically burdensome, or administratively inconvenient? And I don't know that I have good clarity there, but I'm hoping some of the questions that fellow commissioners ask will help me understand. I did have another question, I think maybe a couple more. Let me read my notes here, apologies. I guess this was more on on the technical side, so separate from the economic side. And you've sort of answered part of this, but I'll ask it anyways. If the concentrations continue to decrease, then on the technical side, how is it technically infeasible to establish that this is that how is it technically infeasible? Apologize, my notes weren't very clear there.
Again, it is not technically infeasible in that if I'm running out of responsible party, we're running out of time is the problem.
Sure. Yes, I understand that. All right. I think that's it for me for right this minute, but I would ask that if more questions pop into my head, I can be allowed to ask them.
Always, Commissioner.
Thank you.
Commissioner Vihil, do you have questions of Mr. Snyder? I think I saw you shake your head no, right? All right, I think I saw him shake his head. Commissioner Chakalian, do you have questions of Mr. Snyder?
I have one. Can you hear me?
Yes, go ahead.
Okay. Mr. Snyder, your testimony relies heavily on the assumption that the plume is fully delineated and stable. Given that no monitoring wells exist down gradient beyond MW7 toward the municipal well field, what specific evidence can you offer this commission, other than the absence of detection at MW7, that the plume has not migrated outside the current monitoring network in ways your model cannot detect?
I'm sorry, could you repeat that question?
Sure. I'm going to start out with your testimony relies heavily on the assumption that the plume is fully delineated and stable. Given that no monitoring wells exist down gradient beyond MW7 toward the municipal well field, what specific evidence can you offer this commission, other than absence of detection at MW7, that the plume has not migrated outside the current monitoring network in ways that your model cannot detect?
Can you break that down? There's like 3 or 4 questions there. I'll answer the first one though. If you've got a clean down gradient well, you never put a second clean down gradient well. I'm not familiar of that as a practice.
The question goes to the reliability of your model. That's really what I'm trying to get at here. Because there is no monitoring well down gradient beyond MW7. Okay, so do you understand the premise of the question now?
Yes, there's not enough mass to contaminate at MW7, so there's not enough mass to contaminate further down gradient.
Okay, if that's your answer, then thank you.
Thank you. Let's start in the room. Commissioner Langer, do you have questions? No. Commissioner Fry?
Thank you, Madam Hearing Officer. I want to go back to what Commissioner Laney was talking about, and that's partly to establish maybe we have a different way of naming the material. You're talking about soil, and to me, soil is at the surface. It's developed through various I can't think of the word I want, but various ways. And you're talking about at depth, correct? So I would call that sediment.
I would too. I can too. In practice, in my company, we have this argument too frequently.
Okay.
And yet EPA would call it a soil sample. They call sediment samples out of a river or a lake.
Which might be a difference of engineering versus geology or. Okay.
Yeah.
So my other question related to that is, so your stating that the contaminants are resorbing into the soil and then desorbing at different times. How are you determining that?
When a plume becomes stable, if you have no, so let me talk about this 1,1 DCE plume. When a plume becomes stable, it can become stable for a couple of reasons, but you have to have a depletion mechanism. Otherwise, as I was asked by Mr. Stomp, the groundwater is moving and the contaminants are going to move with it unless something sieves out or depletes the contaminants from the water, cleans it up. And that's that absorption process. Another thing that can do it is biodegradation. But biodegradation of 1,1 DCE is rare. So even if a minuscule amount's going on, you would never claim, oh, biodegradation's working. You wouldn't do that. So you can have a stable plume even though you've got groundwater moving through it if it is no longer being sourced at the source area. And that's what we demonstrated when we closed out the source area. Now it's detached and it's drifting, and it can absorb and retard to the point where it becomes stable as it just slowly declines through these physical processes, not biological processes.
So is there some method that you're using to make that determination whether desorption, I mean, explain this to me in more detail because I'm.
So when I assess a site right now, we would collect the data from our sediment or soil, and you can run geotechnical tests on it for bulk density, initial moisture content, etc. How much organic carbon is in the soil from, say, detritus and silt or whatever. That's what provides the absorption, by the way, is some type of organic matter. It's directly proportional. And so you can measure these parameters that you need to make exactly the analysis and the questions you're asking about. Now, if you've got a plume that's 40 to 50 years old, like this one, and the plume is stable, and you've got wells that are not fluctuating or going up over time consistently, they can fluctuate within a range. It's a weird statistic, but that can happen. But as long as it's staying there and it's staying bound and it's not growing spatially significantly, you would call that plume at a minimum stable. And then if your concentrations, like I showed with the 2 red lines on MW4, are declining over time, you would refer to it as stable and declining. And when you're stable and declining, that gives you more options to deal with it to be protective of human health and the environment, other than physical removal and or in situ treatment.
So is it correct to say, excuse me, that you're making some assumptions and not actually physically making these measurements to make this?
It's based on plume behavior.
Okay.
So it's what we're seeing, how the plume behaves, which is typical. On a lot of old Superfund sites, they never collected any of this data like 35, 40 years ago. Like in South Valley Superfund site, I mean, way back then, that, you know, the science and the practice has grown a lot since 1990.
And it would be based on models, basically.
However you want to define models, right? I mean, they can be very complex. They can be fairly simple, depending on what your data use is and your data need and you know, the question you're trying to answer.
Mm-hmm. Okay, thank you. And then let me see here. So could you name the method that you are using to characterize flow directions?
We use 3-point problems on our wells. We've got MW2, 4, 3, and 7.
Mm-hmm.
And so we'll do like 2, 4, 7, 4, 3, 7, whatever. We'll do them all. We'll reconcile vectors off of those 3-point problems, the same way you do strike and dip on a rock surface, right? So we resolve those, and then we come up with a mean groundwater flow direction in our domain based on what we're seeing there. Okay. Some of these wells, when we gauge them, they may have water levels that are only like, you know, 5/100ths of a foot apart, and the wells are 100 feet apart. It is a very flat gradient. If you've got a steeper gradient, it gets more reconcilable more readily. We're trying to measure that on something that's flat.
Okay, just making sure you're done. Would there be any reason? So, I think what the city is arguing is that you don't have a good idea of that flow direction, if I'm understanding it right. So can you think of another method you could use to show that? Is there would it be feasible to use other methods?
No.
Okay. Not like tracer dyes or anything.
Not
Not a tracer dye or anything and I'm not a hydrologist, so.
and that's what I thought of when I said no, because the wells are, the domain's big enough and the wells are far apart that by the time you got done doing a dye study, it would be really difficult to see a return. I mean, you could be at 5 years and not see a return and not know if you're done or need to wait another 3 years, right? Something like that.
Yeah. Okay. Thank you. No more questions.
Thank you, Commissioner Chapman. Mr. Chair.
Sorry, I just heard you say something a minute ago in response to Commissioner Laney. I think you said it was a double negative here, that a cleanup is not technologically infeasible.
I did a double negative. I can clarify that if.
But does that mean that a further cleanup of the groundwater is technologically feasible?
By long-term monitoring, yes, it would be feasible.
Okay, thank you. That's all I.
Commissioner Thompson.
Okay. So the principal contaminant that you believe was released, principal regulated contaminant that you believe that was released into this dry pit was TCE, trichloroethylene.
Trichloroethane, 1,1,1 trichloroethane.
Okay. You don't mention it in your reports, and I looked at the analytical lab results, and I didn't see either TCA or TCE mentioned. So is it correct that it's completely gone?
We report TCA in all of our monitoring tables, and it's down around 1, 2, 3, 4, 5 parts per billion. And it's got a standard of a WQCC standard of 200. So, I mean, we're like at 100, the standard on 111 TCA. But by the way, the 11 TCA is principally what was discharged. It will hydrolyze almost immediately into 11 DCE.
And so that is a hydrolysis, not a degradation product?
It is a hydrolysis. It's exactly what happened at Person Station down in the South Valley.
What happened at
Person Station in the South Valley. Because they were using a PERC TCE, well, they were using a PERC TCA blend, and they wound up with a PERC 11 DCE plume is what wound up under Ethicon. It's commonly understood.
But again, it's abiotic.
It is abiotic.
I was not aware of that. Thank you. Okay, there's been a lot of discussion about, and let me rephrase it as I understand it, equilibrium between the sorbed material and the solution material in solution. And I think that is something that some of the commission is not clear about, but it is an equilibrium. It's a dynamic equilibrium. Correct me if I'm wrong. It's a dynamic equilibrium between the sorbed material and the soluble material. Is that correct?
Yes.
And that is often measured by a distribution coefficient. And you reported in one of your reports a distribution coefficient.
Yes.
Was that experimentally measured, or was that based on literature values?
It was taken out of the risk assessment guidance of the New Mexico risk assessment guidance. There are default parameters for making these calculations in the risk assessment guidance, in that it was not measured before and the data wasn't there to even attempt to measure it by, fraction of organic carbon times KOC. I just used the default KD out of the risk assessment guidelines.
That's probably as good as you're going to get, because those KD values can vary by orders of magnitude depending on the material. So Mr. Stomp was asking you questions about the total mass, and it looks like you based that question on the soluble concentration of DCE. Is that correct? Or did you also include the mass absorbed material?
I included the mass absorbed as well, which is why I had to use the default KD from the risk assessment guidance. It was the only place I could get a referenceable value that would be defensible to make that comparison.
Okay.
But I did Zorb, mass, and solute. And of course, solute was easy, although I had to estimate total porosity, right? It hadn't been measured, but for, these types of materials, that's not a broad range either. So,
no, I agree. Could you use that KD, the distribution coefficient, for estimating the velocity of the contaminant plume?
Yes.
And that involves calculation of a retardation factor?
Right. I would calculate the groundwater velocity first, and then I would apply that desorption, that retardation, right? I would divide my groundwater velocity by that value. And that would tell me how fast the DCE is moving.
And you didn't do that?
No.
Is there any need to do a retardation calculation?
The plume is 40 to 50 years old and 700 feet down gradient. We're not above standards. I mean, and so I relied on direct observation and the data rather than a calculation.
Yeah. Okay.
A groundwater flow model would have been useful, but it's beyond the means of my client. The resources are more limited than some other entities that have contamination issues. And it's a very small mass of contaminant.
Yeah. Okay. One last question. Are the wells, the water level has risen 25 feet. Are some of the monitoring wells or all of the monitoring wells now submerged?
Yes.
And is that a problem from the perspective of understanding the nature and behavior of the contaminant plume?
Yes, it can be problematic. We, at another site in town, because of the water level rises, we actually checked that with, I think, 2 or 3 monitoring wells in downtown, north of downtown Albuquerque, between the Big I and downtown. And what we found was the shallower, we had water table monitoring wells then that were in this risen water table, and they were clean. The contamination, when you get pretty far down gradient in these plumes, the contamination tends to stay in its transmissive channel, without a whole lot of this going on. But this reaching up into this old material, this clay silt material that's notorious for back diffusion, I think is what caused back diffusion. I think is what's caused, the fluctuations and the increase somewhat in concentrations. Nonetheless, I think we can be protective.
Okay, thank you. That's all I have.
Thank you, Commissioner Bayless. Commissioner Sloan.
I'll ask a few probably in random order here. You said something about a period of 10 monitoring events, but you didn't say over what period of time that was. So
I think maybe 3 or 4 of those were annual, and we've done I think now about, we started to see this fluctuation and the state said, go to monitoring twice a year. I think we started that about 4 or 5 years ago. I can bring up a table and we can answer that question exactly, but I mean, that's the best I recall it.
Okay. And that leads me to my next question, I guess, is why do the levels fluctuate?
I think they fluctuate again. And again, this is my professional judgment and hypothesis, but I think it's because of very slight water level changes presently and very slight changes and shifts in the groundwater gradient, subtle shifts, again, related to what the city is doing pumping, because we're caught between two pumping centers at this site.
I guess I didn't realize that there were two. There's one that's south, right? Where's the other one?
Yes, there's to the north. There's a pump and well field up by like McLeod and San Mateo, I think it is, or
So given the drought and potentially maybe loss of San Juan Chama water, if the city starts pumping more, are you going to potentially see gradients shifting, another drop, and a more movement of the plume in one direction or another, depending on which pumping system they're using?
the direction of groundwater flow has always been predominantly, not even predominantly, it's always been southerly, southeasterly towards Santa Barbara number 1. Santa Barbara number 1 is what I've always considered driving this steady, fairly steady direction. Again, it varies 10 degrees plus or minus whatever. We see that in the record. But Santa Barbara number 1 is, you know, pretty much straight south and clearly a concern when I took the site over from Easterling. That was my concern, is are we being protective of that well?
So switching gears yet again, the box culvert that you said stopped the discharge to the shallow aquifer, where is that located?
It is right. I mean, it is 10 feet from the discharge well. I mean, it is like right on the north property boundary of the source area, way at the north end of the box.
And then two more, I guess. Are there breakdown products of DCE that, and have you looked for them? I mean, you talked a little bit, I think, about the site and the dry cleaners that went through the different breakdown products, and the one was the most toxic was the final version. So have you looked at any of that here?
Yes, yes. The method that I use to test for my solvents, it picks up vinyl chloride and it also picks up dichloroethane, which would be the only two pathways once you're at 1,1 DCE.
And you didn't find any? Is
No,
that what you're telling me?
No.
Thanks. So my last question goes kind of to the rules and regulations. You've been talking a lot about sort of a risk-based standard. My understanding of the rules is that we use a risk-based standard when there isn't a numerical standard, but in this case, there is a numerical standard. So why would we not stick with the numerical standard? Why switch to the risk-based?
Because I don't want the site to become an orphan site. And so I can use 3103A2 and still meet the protectiveness standard, not cause harm to human health or the environment, be protective, and we're still there. There's no doubt it's a surrogate. They're not equal. I agree. I agree wholeheartedly. They're not equal. But I proposed it because it's by NMED's own document protective.
But they're not equal. So you talked about that it would meet the standard in 11 years. Is that 11 years of just sort of monitoring and doing nothing? You're basically saying, I think that the plume isn't going to move. So if it's going to meet it in 11 years and you have to sample it twice a year just to make sure, why would we not just stick with it?
It's going to be an orphan site and there's not going to be a responsible party to do that monitoring.
Okay, thanks.
All right, is there any reason not to excuse Mr. Snyder?
I'd like to redirect.
All right, go ahead.
So could you put that map up that had the box that we've looked at so much? So we've talked a lot about the stability and the characteristics of the plume inside that box. I just want you to repeat, what is the highest number that has been identified for 1,1 DCE within that box over the last 20 years?
50 at MW4.
When we say 50, we're talking 50 parts per billion.
Micrograms per liter, parts per billion, yes.
Okay, and then just so the record's clear, what is the screening level at the tap for 1,1 DCE?
284 at a 1 in 100,000 risk from the risk assessment guidance.
So nothing inside this box, regardless of how stable the plume is, or if it's moving slightly, or you might be a little bit off, nothing in there has ever been more than, now I'm doing my math like Matthias, but more than 1/5 of the tap screening level established by NMED.
Yes, 1/5.
And so all of the, when you characterize a box like that, don't you consider, of course you could put a well every 20 feet or 30 feet, but don't you consider the contaminant that you're looking at, which is 1,1 DCE, and the standards that might apply to it with respect to safety or health?
Yes.
And so would there be any circumstance where you would want 5 or 10 times as much data to evaluate a mostly stable plume where the highest level you've ever seen over 40 years is 50 parts per billion of 1,1 DCE?
It really depends on plume behavior. I mean, if this was moving and unstable, we wouldn't be here.
Now, I just want to walk through how water in that plume, because it looks, this is a aerial photo. I want to walk through how water in that plume would actually become tap water.
It would have to migrate all the way to Santa Barbara #1.
Well, or if someone put a well in.
Or if someone put a well in.
So if someone put a well in here, I just want you to describe, let's say we put a well, we'd have to get down to the water, right?
Yes.
And typically most people would go below the water before they would screen their well.
That is correct. Well below the water table.
And then they would screen it for a significant period of time so they get proper inflow, a significant length.
Right.
And so let's say this contaminated water is at 200 to 220 feet, and I drill a well and I start screening it at 300 feet to 400 feet. And so my pump is pulling that 100-foot column of water out, which is 80 to 100 feet below any contaminated water. So what is the likelihood that any of this water would actually make it to the tap?
Slim, but you would demonstrate that with some hydraulic calculations and also maybe with some localized modeling. You could figure out what that was. But again, that scenario that you just drew, that setup, is what I was getting at earlier when I said you might just, restrict well completion in the top 100 feet of the aquifer there.
Or for a municipal well, say the top 1,000 feet. And then if they wanted to pump further below, the top 1,000 would not have any screen. And the water they would be pumping would be 1,000 feet below surface.
They would screen below the surface. Exactly how they would do that, the Water Utility Authority people would know, because it's going to be where they're going to get good water at high rates.
And does 1,1 DCE volatilize?
Yes.
So as water were going up the well column, would the 1,1 DCE volatilize?
Not up the well column, because it has to volatilize. It's got to be in contact with air.
So once it hits the air, then it would volatilize.
Yes. And that's a pathway that is established in establishing the tap water screening level. And the pathway is, are you going to breathe this when you take a hot shower? Is the way EPA looks at it.
So they make the smallest pathway possible.
They look at several pathways and then add up the risk.
We need a break soon, Mr. Demente.
Let me just see it. Okay, that's all I have. Thank you.
Thank you very much. Let's take a break and let's just do 12 minutes and then we'll bring it home. 3:40. We are back after a short break. The petitioner, as I understand it, has completed their presentation. We'll move then to the department. Mr. Knight. And is it okay to go back to the okay, sorry, otherwise I would have asked them to clear out over the break, but I think this worked pretty well.
And Madam Hearing Officer, if there's no objection, I'm just going to waive my opening remarks. I think we all know where the department's position is. So I would just like to examine my two witnesses and have them stand for questions as a panel, if I may, to save some more time.
That's terrific. Thank you, Mr. Knight. Gentlemen, if you would, one at a time, spell your first and last name.
Or I can go first because mine is green. My name is Noel Hernandez. Do you want me to spell it out?
Spell it, please.
NOELHERNANDEZ.
Do you swear or affirm to tell the truth?
I do.
Thank you, sir.
Good afternoon. Justin Ball, JUSTIN BALL.
Do you swear or affirm to tell the truth?
I do.
Thank you. Go ahead, Mr. Knight.
Okay, we're going to start with Mr. Hernandez. And Mr. Hernandez, could you briefly describe your educational background?
Yes. I have a bachelor's of science degree in geology and a master's of business administration with a concentration in sustainability and environmental compliance.
And where are you employed?
I've been with NMED since January 2021. My current role is Senior Water Resource Professional with the Groundwater Quality Bureau. Sorry, for the Groundwater Quality Remediation Oversight Section since October 2023.
And what do you do in that capacity?
I provide technical and regulatory oversight for sites with vapor intrusion, soil and groundwater contamination.
And where have you worked before NMED?
Prior to NMED, for about 12 years, I was a project manager, staff geologist for environmental consulting firms and engineering firms.
And did you file written testimony in this matter?
I did.
And do you have any changes or corrections that you'd like to make to that written testimony at this time?
I don't.
Do you therefore adopt that written testimony as your testimony here today?
I do.
Please provide a short summary of your written testimony, starting with the site description.
Sure. The site addressed as 3412 Bryn Mawr, Northeast Albuquerque, was leased to Fox and Associates by the partnership JVP Ventures One Incorporated, who were the owners of the site. The former Fox facility was an environmental engineer firm which conducted material testing and disposed of used solvent within an on-site 25-foot deep dry well between 1979 to 1985. Past investigations determined that not only were solvents being disposed of in there, but it included asphalt residue, motor oil, hydraulic fluid.
Residue?
Yes. Motor oil and hydraulic fluid.
Could you describe the geology and hydrogeology of the site?
The site is located within the Albuquerque Basin, which is underlain by mostly sand and gravels to a depth of about 200 feet. Initially, site disposal activities impacted subsurface soils and a perch aquifer, which is present at approximately 55 to 65 feet. However, due to some stormwater infrastructure improvements in the vicinity, that eliminated the recharge of the perch aquifer, and the perch aquifer was discovered to be dry and no longer present in about 2018. And so therefore, currently, the affected groundwater is the Albuquerque Regional Aquifer at approximately 200 feet. And as was mentioned before, groundwater flow on site is the south-southeast, and contamination consists of 11 DCE from, excuse me. And I just want to make a note that it impacted one of the regional aquifers that provides water for Albuquerque. The site is also less than half a mile from the Albuquerque's drinking water supply well.
Thank you. Please describe briefly just the history of abatement activities at the site and also the current conditions there.
Okay. So between 1988 and 2020, abatement activities at the site included investigations and sampling of soil vapor, groundwater, with laboratory analysis of volatile organic compounds. This included installation of soil vapor and groundwater monitoring wells to evaluate and monitor the perch aquifer and the regional aquifer. In addition, in that time frame, a soil vapor extraction system was operated between 2008 and 2012, which reduced volatile organic compounds in soil above the perch aquifer to below applicable risk space. Applicable. Sorry. Risk-based residential screening levels. And then in November 2019, NMD approved that abatement completion report, which was mentioned earlier, which redefined the abatement plan area and required continued abatement activities for the remaining concentrations of 11 DCE in the regional aquifer, and that migrated offsite. The redefined abatement area for the site included site monitoring wells MW2, MW3, MW4, and MW7. Approval of the abatement completion report also granted no further action for the property located at 3412 Bryn Mawr, since it met the New Mexico ground and surface water standards for soil, vapor, soil, and groundwater, as well as risk-based screening levels for soil and soil vapor. Therefore, groundwater monitoring and soil vapor extraction wells located in the original abatement plan area were plugged and abandoned. In May 2021, due to the detections of 11 DCE reported in monitoring wells MW2 and MW4, NMD requested petitioner to submit a proposal to increase routine annual groundwater monitoring and sampling events to semi-annual. In July 2021, NMD approved routine semi-annual groundwater monitoring and sampling for wells located within the new abatement plan area. In May 2025, due to the persistent presence of 11 DCE in groundwater at monitoring wells MW2 and MW4, NMD requested the petitioner to submit a stage 2 abatement plan modification proposal to select and design an abatement option that will result in attainment of the requirements set forth in 20.6.2.4103 NMAC. In November 2025, NMD sent petitioner a notice of deficiency letter for failure to submit a stage 2 abatement modification proposal to address the persistent presence of 11 DCE in groundwater at monitoring wells MW2 and MW4. In March 2026, on behalf of petitioner, EA submitted the most current semi-annual groundwater monitoring report. And based on that data presented in the report, MW2 and MW4 contained consistent detections of 11 DCE above WQCC groundwater standard. Those consistent detections in MW2 and MW4 indicate that 11 DCE plume is not bounded and may extend east of the site, which while the intermittent detections of 11 DCE at concentrations below the WQCC groundwater standard in MW7 suggest that plume may be expanding southward. In addition, there is insufficient information to determine groundwater impacts east of the site, and this presents a critical data gap for determining total impact.
How does the proposed alternative abatement standard compare with what is required by our regulations?
Can you repeat that?
Yeah. How does the proposed alternative abatement standard that they're proposing here today, how does that compare with what is required by the regulations?
What they're proposing in the alternative abatement standards for the site is 200 micrograms per liter for 11 DCE. The numerical groundwater standard for 11 DCE is 7 micrograms per liter. That's pretty much 40 times higher than the standard.
Okay, thank you. And now I'd like to move on to my next witness. Who has already stated and spelled his name for the record. Mr. Ball, where are you employed?
At the New Mexico Environment Department in the Groundwater Quality Bureau.
How long have you been with the department? And what is your current position?
18 years and 2 months. I'm currently the Bureau Chief of the Groundwater Quality Bureau.
And did you file written testimony in this matter?
I did.
And do you have any changes or corrections that you would like to make to that testimony at this time?
No.
Do you therefore adopt that written testimony as your testimony here today?
I do.
Please provide a brief summary of your written testimony then.
Alternative abatement standards fall within the Water Quality Control Commission's authority to grant a variance from any requirement of the water quality regulations pursuant to the Water Quality Act. The Commission is required to review petitions for alternative abatement standards in accordance with the procedures for review of variance petitions provided in the Commission's adjudicatory process. The Commission's abatement regulations provide that a person abating water pollution pursuant to an approved abatement plan may submit a petition for approval of an alternative abatement standard. Petition for alternative abatement standards must demonstrate at least one of the following criteria. A, compliance with the standard would not be feasible by the maximum use of commercially accepted abatement technology. B, compliance with the standard would not be feasible by the maximum use of technology within the economic capability of the person. C, there's no reasonable relationship between the economic and social costs and benefits of attainment of a standard. Or D, compliance with the standard is technically infeasible following the maximum use of commercially accepted abatement technology as demonstrated by a statistically valid extrapolation of the decrease in concentration of any water contaminant over a 20-year period, such that the projected future reductions during that time would be less than 20% of the concentration at the time technical infeasibility is proposed.
So what are the criteria for approval of an alternative abatement standard by this commission?
The abatement regulations at 20.6.2 4103E3 identify the criteria that must be met for the commission to approve an alternative abatement petition. A, at least one of the criteria set forth in paragraph 1, which I just read, has been met, and the proposed alternative abatement standard is technically achievable and cost benefit justifiable, and compliance with the proposed alternative abatement standard will not create a present or future hazard to public health or undue damage to property.
And so how has the department evaluated the petition using these criteria?
Petitioner claims that the criteria of subparagraphs B and C are met. Subparagraph B addresses whether compliance with the standard would be feasible with the maximum use of technology within the economic capability of the person. Subparagraph C addresses whether there's a reasonable relationship between the economic and social costs and benefits of attainment of the standard. With respect to subparagraph B criteria, language in the petition acknowledges that technology exists that can achieve the standard. The petition identifies in situ injection and pump and treat as in situ injection and pump and treat as remedial options, and provides cost estimates for those options ranging from $980,000 to $1.5 million. The petition claims that JPV Trust is close to exhausting its funds and does not have the economic capability to actively remediate the site. The petition does not present any documentation to facilitate an evaluation of the economic capability of the petitioner to perform active remediation of contaminated groundwater. Thus, NMED believes petitioner has failed to make a demonstration of the applicability of that criteria. With respect to subparagraph C criteria, the petition assigns a value to an acre foot of water, calculates the value of the affected volume of groundwater over a period of 22.5 years, and compares the value of the affected volume to the cost of active groundwater remediation. The petition asserts that the cost of active remediation exceeds the value of the volume of contaminated water. Thus, there is no reasonable relationship between the economic and social costs and benefits of attainment of the standard. NMED does not have a role in the acquisition and transfer of water rights and therefore cannot comment on the veracity of the value assigned to the petitioner to an acre foot of water. Nevertheless, water is not merely a commodity having a transactional value. It is essential to life and has an intrinsic value that the transactional cost of a water right cannot fully measure. Additionally, an evaluation of economic costs should consider potential impacts to Albuquerque-Bernalillo County Water Utility Authority and their customers. ABC WUA provides water and wastewater services to the greater Albuquerque area. The petition states that Santa Barbara No. 1 production well is located a half-mile down gradient of the site, and the Volandia well field is one Andia well field is 1.2 miles northeast of the site. It would be reasonable for any evaluation of economic costs to consider the cost that might be incurred by ABC WUA if 1,1 DCE contamination in the regional aquifer forced ABC WUA to treat groundwater to meet regulatory standards or take production wells out of service. NMED considers the petitioner's evaluation of the relationship between the economic cost and benefits of attainment of the standard to be incomplete, and therefore does not believe petitioner has made the demonstration necessary to satisfy subparagraph C's criteria. Subparagraph C's criteria also addresses social costs and benefits of attainment of the standard. The petition refers to the use of administrative controls to ensure that contaminated groundwater is never used for potable supply as a means to address social impacts. The petitioner states that prior abatement activities at the site involved soil vapor extraction and resulted in cleanup of soil contaminated and contaminated soil gas. Petitioner has never attempted to remediate contaminated groundwater at the site through implementation of an active groundwater remedy. Therefore, NMED believes the approval of the proposed AAS could have substantial social costs in terms of the effects on policies for the protection and restoration of groundwater quality in New Mexico. Approval of alternative abatement standards for the site, absent any attempt by the petitioner to actively remediate groundwater contamination and any attempt to achieve the established standard, would be contrary to the stated purpose of the abatement regulation. The abatement regulations establish a policy for abatement of polluted subsurface water, which has a background concentration of 10,000 milligrams per liter or less of total dissolved solids, to facilitate use of the water as a domestic and agricultural water supply. The abatement regulations require abatement of groundwater having a TDS, total dissolved solid concentration of 10,000 milligrams per liter or less, such that the standards promulgated in section 3103 of 20.6.2 NMAC are met at any place of withdrawal of water for present or foreseeable or reasonably foreseeable future use. NMED contends that the location of contaminated groundwater attributable to the site represents a place of withdrawal for present or reasonably foreseeable future use, as the Commission determined previously that use or application of institutional controls, such as those proposed by the petitioner, are not an appropriate criterion for determining place of withdrawal. Please see NMED Exhibit 11, which is the WQCC decision and order on remand dated February 4th, 2009. NMED considers petitioner's evaluation of the relationship between the social cost and benefits of attainment of the standard to be flawed, and therefore does not believe petitioner has made the demonstration necessary to satisfy subparagraph C criteria.
Thank you. Is the proposed alternative abatement standard technically achievable and costs? Now we're talking about the proposed alternative standard. In your opinion, is it technically achievable and is it cost benefit justifiable?
The proposed alternative abatement standard is technically achievable as current concentrations of 1,1 DCE in groundwater at the site are less than the proposed alternative abatement standards. The proposed alternative abatement standards is not cost benefit justifiable, and I would refer to you to my previous testimony.
Okay. Will compliance with the alternative abatement standard create a present or future hazard to public health or undue damage to property?
The petitioner claims that the proposed alternative abatement standard will not create a present or future hazard through the use of administrative controls to prevent access to contaminated groundwater, and no undue damage to property will result from the alternative abatement standard. Petitioner fails to identify specific reasons and information to support these claims. NMED believes approval of the proposed alternative abatement standard could present a future hazard to public health. The proposed alternative abatement standard of 284 micrograms per liter is 40 times greater than the promulgated groundwater standard of 7 micrograms per liter. Exposure to a higher concentration of 1,1 DCE in a residential supply well could result in more severe or different adverse health effects compared to exposure at a lower concentration. In summary, the petitioner has failed to demonstrate at least one of the criteria described in 20.6.2 4103E1, and the proposed alternative abatement standard is not cost benefit justifiable, and the petitioner has not demonstrated that approval of the proposed alternative abatement standards will not pose a future hazard to public health. Therefore, petitioner has not met the requirements for approval of the alternative abatement standards, and the petition should be denied.
And having sat here today and heard or having reviewed, the written testimony of the Water Authority, do you have any comments on the Water Authority's testimony?
An alternative abatement standard petition must define the three-dimensional body of the plume. Yes, sir. An alternative abatement standard petition must define the three-dimensional body of the plume. While the petitioners have defined an area in the petition, I want to point out a few technical points that I think are important as put forth by ABC WUA. Ms. McNell's exhibit number 1, page 4 states, the groundwater contamination observed in MW4 suggests a pathway existed to the regional water table from the perched saturated zone. However, the pathways from the dry well and the perched saturated zone to the regional aquifer has never been investigated and remains a critical gap at the site. In addition, the existing monitoring network is insufficient to bound the contaminated plume both laterally and vertically. End of quote. My understanding is that JVP, and as Mr. Schneider has testified, that JVP has not installed monitoring wells in the regional aquifer, with the exception of the multi-level vapor well MW1 that was able to collect water from the regional aquifer very close to the source area, and it was below standards. But because of the concentrations in MW2 and MW4, we know that contaminants have made it through the aquitard that created the perched aquifer at some point. But it's unknown if it poured over the edge of the aquifer or found a window in the middle of the aquitard. I do know that it didn't simply go straight down. And due to the concentrations seen in MW01, VMW01, I bring this up because it speaks to how well the plume in the regional aquifer has been defined. Mr. Gates' testimony on behalf of ABC WUA Exhibit 14, page 4, has a simple visual analysis that I would point out is really good to understand the idea of whether or not the plume is well defined. In my career, when I've been speaking with responsible parties, they always ask, how many wells do we need? And I always say two things. I say that the data will decide, because you don't know what you're going to find when you put a hole in the ground until you collect a sample. And the second response is, I need to know where the plume is and where it isn't. We must define the edges of the plume. As shown in Mr. Gates' figure, there are not defined edges to the plume to the south and southeast. And I support Mr. Gates' observations and conclusions in general, but I would like to state I agree with the points 1, 2, 3 relating to plume delineation, and points 11, 12, 13, 14, and 15 related to plume behavior.
Thank you. And finally, does NMED regulate based on the mass of contaminants?
No.
Could you elaborate?
Groundwater Quality Bureau makes decisions on plume delineations or if a cleanup is sufficient only by concentrations in soil, soil vapor, and groundwater. An engineer may need to calculate the mass to correctly size components of a remedial system, which NEBD would provide input on during the review of a stage 2 abatement plan proposal. The mass of a contaminant removed in a cleanup isn't germane, only what remains in soil, soil vapor, and groundwater. NEBD's determination of a closure of a site is made on those same criteria of concentrations, regardless if the original spill was 100 gallons or a million gallons. Parenthetically, I would say in the regulations, the only place that we require a mass would be in the spill regulations of 20.6.2 3103. A1, so part F, requires the discharger to report the estimated volume of discharge within 24 hours of the spill. That information is useful to the department to make decisions on assigning personnel and actions to take immediately upon notification of a spill.
But the concept mass is never a factor when in cleanup or remediation, other than for the spill regulations. Is that right?
That's correct.
Okay. And that concludes my examination of my witnesses, and they are available for questioning.
Thank you, Mr. Knight. Mr. Domenici, do you have questions?
Thanks, Dan.
Microphone.
Mr. Ball, how many alternative abatement petitions have you reviewed since you've been the bureau chief?
I think this is the first one as bureau chief.
Were you involved in the prices alternative abatement petition?
I provided support to other staff members that were addressing that, but I am familiar with it.
Do you recall that the alternative abatement standard in that case for nitrates was more than 10 times the numerical standard?
I don't recall the exact number, but I'll stipulate it.
Was the social cost of this commission adopting an alternative abatement standard that was 10 times the numerical standard, was that a social cost inconsistent with the policy of the groundwater regulations?
Mr. Domenici, correct me if I'm wrong, wasn't the petition relying upon the fourth portion of the criteria where abatement was conducted on that isolated portion of the aquifer and the petitioner was unsuccessful in meeting a regulatory standard after active remediation for a period of years?
I think that is correct. So I guess what I'm trying to ask is, it sounded to me like your interpretation of the social cost of granting an alternative standard to a numerical standard is so much that subpart C of the regulation would never be available, because the social cost of using 4301 E, 4103E C, if I understood correctly, you're saying the social cost of granting an alternative standard that is different from the numerical standard in any case would call for denial of that petition.
I would interpret my testimony as that this petition fails on those grounds.
You didn't say this petition. When you testified, you were actually stated, and I recall it, you just testified, we have a record, that the social cost of an alternative standard other than the numerical standard would always be greater than the benefit. So you essentially don't believe that subpart C should be used for any alternative abatement standard because the social cost of allowing that alternative standard somehow outweighs the benefit, right?
I would just state that it is the commission's duty to judge the petition on that basis.
Well, your expert testimony, and you're not a sociologist, right?
That is correct.
So when you're talking social costs, did you consider the social costs of having orphan sites? Basically not having a tool to close sites that are going to head into orphan status. Have you considered that deficiency in your regulatory program?
Not for this matter.
For any matter?
I have had lots of thoughts and considerations on orphan sites. They're not germane to this. To this petition. Relative
well,
to
you
my
understand
analysis.
one of the grounds for this is to avoid an orphan site. I'm just asking, that's a preface. Let me ask the question. You understand and that this isn't the only potentially orphan site in New Mexico?
I am well aware of the sites that are under abatement in which it is unlikely they will be closed. Yes.
So I'm just trying to find out when you are testifying to the commission as the chief of groundwater, and you're talking about there's the relationship between economic and social costs and benefits. What I heard was there's a social cost in and of itself to approving an alternative abatement standard. That's a cost to society because we should not approve abatement standards, different than numerical standards, right?
I'll just restate that the commission is empowered and is responsible for making those determinations.
Do you think the commission should give any weight to your evaluation of social costs of granting this petition?
I expect that they will.
And so I'm trying to find out, since you're not a sociologist, you seem to be talking about policy of the water quality regulations, at least the abatement regulations, right? But the alternative abatement standards are the abatement regulations, right?
They can be if they are adopted by the Water Quality Control Commission.
Well, they were adopted by the Water Quality Control Commission. That's why they're in the regulations.
My answer was with regards to a particular petition. But yes, I agree that the rules do allow for the alternative abatement.
So I just want to be clear, granting an alternative abatement petition does not violate the abatement regulations. It is actually part of the regulations.
Correct.
So let's look at the costs. Did you understand that So first of all, you understand that when NMED corresponds with JVP, they are corresponding, and I'm going to read this from your May 12th letter.
Can
It's
you
to,
give me the, pardon me, I'd like to read along with you.
well, let me just read this and see if you need to. Well, if you want to, go ahead. It's in your, it's your Exhibit 6.
Go ahead.
So that says JVP Venture One Inc., right? You see that, who it's addressed to?
Right under Charlie Miller, yes.
And then it's called the former Fox and Associates Inc. facility, right?
Correct.
And did you see earlier that Fox and Associates has been through bankruptcy?
Yes,
And are you aware of that?
I am.
And are you aware that JVP Venture Inc. has a bank account with less than $400,000 in it based on testimony today?
I am aware of it based on the testimony today. I was not aware of any, well, I would say that information was not included in written testimony.
And you indicated that when, so yeah, I'm just trying to apply this criteria under subpart C of the abatement rule, or alternative abatement standard E. There's no reasonable relationship between the economic and social costs and benefits of attainment. So the economic costs were spelled out by Mr. Snyder, right? He gave two estimates, one of in situ injection and one of pump and treat. Did you review those in his testimony?
I've read his testimony and heard it today, yes.
And the total cost for in situ injection is between 1 million and 1.5 million, according to his testimony.
Okay.
And the total cost of pump and treat is between 980,000 and 1.28 million.
Okay.
And I'm trying to understand how you actually apply subpart C here. You have it in front of you in the regulation?
Yes.
And I want to be as clear as I can. What is the benefit to attaining the numerical standard? What's the benefit to that?
If the numerical standard is met in all monitoring points within the regional aquifer associated with this site, then closure can be obtained and no restrictions to future use would occur.
And did you quantify that benefit?
No. Other than what I've testified relative to the, in response to the testimony of that has been provided by the petitioner.
Did you put a dollar amount on that?
There was calculations, yes.
What was your calculation?
I did not. I repeated what was provided. I countered with the idea that in addition to the simple analysis of how much an acre feet costs, we also need to consider the additional costs that BC may occur due to impacts to the regional aquifer.
Did you come up with a statistical percentage of that those impacts would ever occur?
No.
You understand by probability, you would have to take the cost and reduce it by the probability. And if the probability were 0, the cost would actually come down to 0, right?
I wouldn't necessarily state that, but.
Well, that makes sense, right? So if you're saying we're going to save the cost of saving the Rio Grande, but we're not going to harm the Rio Grande, then That's not actually a benefit, right? There has to be harm, reasonably probable harm, or at least some proximate harm in order for to avoid that had to be a benefit. Well, let me just ask it this way. What is your calculation, yours, not relying on someone else, of the likelihood that the water authority will have to pay a single penny if this petition is granted?
In the same way that it's not part of my purview to calculate how much it costs to clean up a site, I don't believe I have those responsibilities in accordance with the regulations.
And therefore the commission shouldn't take your testimony about that possibility, shouldn't give it any weight, right? You're disclaiming you have any expertise or knowledge or responsibility on that, so there should be no weight given that, correct?
I'm pointing out issues that the commission needs to take into consideration when they follow these regulations.
So do you have any evaluation of the likelihood that anyone would actually be prohibited from drilling a well if the state engineer restriction that is proposed by the petition is put in place?
Are you asking me to speculate on the likelihood that someone would ignore a prohibition for installing a well?
No, not ignore it. If someone said, I want a well, and now I've gone to check with the state, I can't drill one. So I've already made the choice, I want one, but I can't do it. So do you have any evidence that that is likely to happen? In that location, that site-specific location?
I don't think that question is asking me to speculate significantly on the actions of.
I just want to make sure if you have any evidence that we can get it from you. You don't have any evidence, right? That anyone in that area would be likely to want to drill a well that would be prohibited by this state engineer restriction, correct?
I would refer you to the state engineer to get an answer to that question.
Okay, so the state engineer, the water authority, trying to find out when you look at the economic costs and benefit, do you interpret that to include the economic cost to the responsible party?
We're talking about C at the moment.
Yeah, I'm focusing on C.
There's no reasonable relationship between the economic and social cost and benefits of attainment of the standards set forth of this section. I think we would need to look at all of the impacted entities. So yes, it would be economically beneficial to the responsible party if this is granted, but the social costs and the other economic benefits are, I believe, are a societal question.
I just want to be sure I know what those are. The social costs, again, I think you testified earlier, the social costs were to the abatement regulation policy.
Yes.
Which includes this particular provision. Isn't that kind of circular? So you're saying this regulation requires we look at the social costs. If we look at the social costs, we don't use the regulation. That doesn't seem to make sense as to why that language would be in there.
Madam Hearing Officer, I'm going to object. I think that misstates the witness's testimony.
All right. Mr. Ball, would you please clarify your testimony?
Put up Jay's chart. No, the one.
Madam,
No, Zach.
my apologies. I have gone through my testimony in this panicked moment, and I cannot find the exact statement where I stated as a policy, the Environment Department, well, I'll just paraphrase and say the Environment Department needs to look at each petition, but in general, we are charged to follow the regulations and require cleanup to standards.
I think you were testifying that there would be a social cost to basically to using the alternative abatement section of the abatement regs. So is that your testimony or not? Is there a adverse social cost that you're testifying to utilizing the alternative abatement petition option of the abatement regs?
Yes, I think that there is that the history of this commission and these alternative abatement standards, they've rarely been granted. And I think that is appropriate in general. And I do think that there are reasons and there should be alternative abatement standards for specific sites when the conditions are met.
And if we could look at this chart here. Well, let me keep this moving so I can move on. Are you aware that and this could be either of you on the panel, because this may have come from Mr. Hernandez. Are you aware in December 2024 that Mr. Hernandez wrote to Mr. Snyder, the Groundwater Bureau acknowledges that current site conditions do not appear to present a risk to receptors hydrologically down gradient. However, site conditions are subject to change. Mr. Hernandez, do you recall writing that to Mr. Snyder? I do. Did Mr. Ball receive a copy of that communication? I believe so. Did Mr. Ball concur with that communication at that time? I think so. And at that time, the fact that the readings in Monitor Well 2 and Monitor Well 4 were going up was already known to the Bureau, wasn't it? Yes. And then in 2025, a year later, after this petition was filed, NMED writes, the boundaries of the contaminant plume have not been defined, and groundwater movement beneath the site ensures that those boundaries will change over time. Were you part of that communication, Mr. Hernandez? I think so. And isn't it true that at that time, between that 1 year time period, nothing had changed with respect to NMED's position that current site conditions do not appear a risk to receptors hydrologically down gradient, correct? Yes. So the precise boundaries of the plume might have been somewhat in question, but the risk to hydrologically down gradient receptors, it never changed from your letter in December 24 through today, correct, Mr. Hernandez? Yes. And just so I'm clear, a receptor can include the Santa Barbara well, correct? Yes. May I have 1 minute, Madam Hairston?
Yes.
So my last line of questioning back to you, Mr. Ball. What do you understand the tap screening levels to represent?
First, I would say that the tables in the document that has been referenced are published by the Hazardous Waste Bureau in support of the Groundwater Quality Bureau and the department. Those have not been adopted by the WQCC. My understanding is that a toxicologist looks at the available information and comes up with risk assessment values for all exposure pathways for all the available chemicals of concern. And the tap water value is one of them.
And you don't disagree that there is a tap water value for the contaminant we're interested in this case, do you?
I do not disagree. I'm sorry, that was a double negative. I agree.
And I think there might have been a little, thank you for clarifying my question. I think there might have been a distinction between you and Mr. Snyder. So when you have a screening level and you run a sample and the sample is below the screening level, generally that's interpreted to mean you don't need to do further investigation. That's what I interpret the screening level to be. And if you're above it, then you need to continue your screening. Is your understanding of that different as to what a screening level is?
Can you clarify the context in which you're asking that question?
When you're utilizing the risk assessment screening levels, I think they're in the Hazardous Waste Bureau guidelines.
Right.
Well, let's just do it generally. A screening level usually is to decide a cutoff. Don't you agree? That's why they call it screening.
Right. Yes, I think that's appropriate. I will, if I may, I'll talk a little bit about how they're utilized, specifically in groundwater. It was referenced earlier about PFAS. PFAS is defined in the regulations as a toxic pollutant. For toxic pollutants in which there is not a numerical standard, then we allow the responsible party to calculate what the risk level is at the 1 times 10 to the negative 10th. 1 times 10 to the negative 5th standard, or 1 in 100,000, in accordance with a subpart of 3103. When they, sorry, the references, they can use that reference as a shortcut, right? Where they don't have to do a full risk analysis, toxicological study to establish a site-specific standard for that compound in groundwater.
And that, therefore, the screening level becomes the toxic pollutant level where there is no numerical standard. If there is a screening level for that particular chemical.
If it's defined as a toxic pollutant, and if there's not a numerical standard.
And if that occurs, or when that occurs, that use of that number is considered protective of human health and the environment, correct?
Yes.
Therefore, the use of the 284, which is in this for this constituent, is protective of human health and the environment, correct?
I would need to look specifically on the totality of the inputs of risk. So there's cancerous, there's non-cancerous. And in the course of the testimony today, we haven't talked about how the numerical standard was adopted by this commission. It predates me, I'm not familiar with it, but there may be other things that, in addition to the cancer risk, that may have been an issue associated with the establishment of the 7 parts per billion.
I don't believe there's any cancer risk involved here with this. Do you have any evidence that cancer risk is even related to the regulatory threshold for 1.1 DCE?
I have not done that research prior to this testimony.
What I was trying to do is say, if you are using those screening levels for toxic pollutants, so you do not require the responsible party to do a full-blown toxicology analysis, and you consider those screening levels protective of human health and the environment, therefore, 1.1 DCE at 284 parts per billion is protective of human health and the environment, based on the Environment Department's own determination.
I was about to say yes until you said the Environment Department's own determination.
Okay. Regardless of that, it is protective, right?
It is a mechanism to be protective of human health. Yes.
Okay, thank you. That's all I have. Thank you for your panel.
Thank you. Mr. Stump, do you have questions of the Bureau panel?
I have one question. Mr. Ball, other than the testimony today about the economic capability of the petitioner, has NMED received any written or any other documentation or evidence to support the criteria required for economic capability?
No.
That's all.
Oh, thank you. Let's start with commission questioning. Commissioner Sloan. Thank you. Commissioner Bayless. No. Commissioner Thompson.
Yeah, one simple question. The soil screen or the screening levels, where are they found? Are they in 20.6.2?
No, they are a separate document that's published by the Hazardous Waste Bureau. It's got a long title, but it includes site characterization, and there are various tables of screening levels for various compounds and media.
And do they have the force of regulation?
No.
So it's a guidance document.
Correct.
Okay, thank you.
Mr. Chair.
No questions.
Commissioner Chapman.
No questions.
Commissioner Fry.
I feel like this is so general and I'm not sure the right person to ask of, but so what happens if the abatement standard is rejected?
If the commission does not adopt.
Let me put it another way. If we do not adopt the abatement standards and I can't think of his name, runs out of money, what happens?
Right now, I'm forgetting that I'm Mr. Chair, members of the committee. Thank you for the question. So Yes, the alternative abatement standard petition, if it fails, then the application will be continuation of the appropriate regulations and the published numerical standards. The regional aquifer is above those standards, and therefore, as we've required in communications, a stage 2 abatement plan would need to be prepared and submitted for an immediate review. There's been statements by the petitioner about what the outcome of that will be. I don't have anything else to say other than, okay, maybe that's true. But as a follow-up question, are you asking about orphan sites in general, or?
Well, I mean, it does, if there's no money, it becomes orphan site. Is that correct?
We continue to keep it on the abatement side until there's no further activities and we can't find a responsible party. And then, yes, it would effectively go into onto an orphan site list.
And who does that fall under at that point?
Well, I do have a little bit of good news. For the first time ever, the legislature appropriated $20 million in the previous session to address abandoned and neglected contaminated sites, which is this realm, but also abandoned uranium sites. And the department has divvied up that money and spent it as fast as we can. And we've been successful in knocking out, on the groundwater side, we're currently digging up soil that's been contaminated at 2 sites. Excuse me, one in Bloomfield and one in Tucumcari. I would ask anybody if they're interested. There's a website, it's the Neglected Contaminated Sites, and you can see the updates on the activities that we have conducted. Those sites were shovel ready. A lot of work had been done through the brownfields federal grants and some works both state level, federal level for brownfields, and I believe some OCD funding for the Bloomfield site for a period of years. So these were shovel ready, and we've been digging, and we're going to consume all of that money. The next the most recent legislative, at the previous legislative session, we amended the Water Quality Act, created the Neglected Contaminated Sites Fund, and has changed the remit to the Water Quality Control Commission to adopt regulations for the department to address neglected contaminated sites. We have not prepared those regulations for review. I don't expect to do that anytime soon because of backlog. But in this last session, we received $5 million that has gone or will go into that fund. So in the big scheme of things, we have many, many, many sites that should be or could be considered orphan sites. And we don't have enough resources to address them all.
Okay, so if it's rejected, there's no money, then it falls on the state to remediate, basically, and to pay for the remediation. Is that correct?
Yes.
Okay.
It would fall on the taxpayers.
Okay. And then what happens if the abatement standard is adopted?
If the abatement standard is adopted, then they would be eligible for closure. They would have met the standards in the regional aquifer.
Okay. And would there be monitoring involved or anything at all?
There is, part of the regulations does mention post-closure monitoring.
Mm-hmm.
We've closed so few sites that I'm not sure how often that has been required. Typically, it hasn't.
Okay. Okay. Thank you.
Thank you. Commissioner Langer,
No questions.
Commissioner Laney on the platform.
I do have some questions, possibly for clarification purposes, my own benefit. But it does seem, this is going to be on the cost benefit discussion. And to the best of my looking through, there really isn't a methodology or a calculation that's established through the rule, which is understandable. Is there a methodology for that the NMED believes should govern a cost benefit analysis under the rule, or is that the responsibility of the petitioner for the alternative abatement?
I think we, Madam Hearing Officer, started the proceedings with a statement that the petitioner had the proof of burden of proof. Thank you. But to answer the rest of the question, I don't believe the department has a, we don't have a policy to evaluate that, or would have done.
And that's, you know, looking at the rule, I understood that that would likely be the answer. I was just wanting to ask. I had some similar questions to Commissioner Fry, but I think she addressed those well enough that I have my answers. Let me just check my notes really quick to make sure there wasn't something else that I wanted to bring up. Oh, I just want to make sure I understood the statement, and there was no attempt at remedy for the abatement. Is that correct?
For the regional groundwater aquifer, there's been no attempted active remediation.
So the issue, it seems, has been known for a number of years.
That's correct.
And this question only recently dawned on me, so it's really not a question for you, and it'll probably go unanswered, but I'm curious why the alternative abatement wasn't sought before in the past, because the issue has been persistent for such a long period of time. That I realize you may not be able to answer that. So.
I think that's best answered by the petitioners.
Yeah. Thank you.
Commissioner Zemlich?
I don't have any questions. Thank you.
Thank you. Commissioner Vihil? Nope. All right. Commissioner Chikalian? You may have stepped away. Oh, Commissioner Chikalian?
No questions. Thank you.
All right. Thank you. Anything further? Commissioner Sloan?
Just have one quick question for clarity. Could a stage 2 abatement plan just be monitoring with a contingency for active remediation if they see movement or increase in concentration, or is stage 2 has to have active abatement?
I would say that anybody's preference is for active remediation. In this particular case, I think we've the petitioner, Mr. Schneider, basically laid out the reason why monitored natural attenuation wouldn't be accepted by the department, because there's not a process that's occurring that will drop the concentrations below standards by a naturally occurring activity, right? A biological activity in this case. So I don't think that we should agree to long-term monitoring as an abatement activity.
So do you believe that we heard today that this site will meet standards in 11 years? essentially left alone.
I did not dive into those calculations that Mr. Schneider provided. In thinking about those things, we need to look at our regulations as best as possible. So the time frame that we typically look at is the 20 years that's mentioned in the variance part of the process. I would want to look really closely at that calculation that Mr. Schneider provided. And I guess my first question would be, how much has the concentrations changed over time? Like this compound was in the regional aquifer 40 years ago. If you did this same calculation 40 years ago, would you still come up with 11? And the empirical evidence is that it hasn't degraded. I guess at this point, I'm hesitant to draw a conclusion.
Thank you.
Anything further from any commissioner? Mr. Knight, do you have any follow-up?
I do not.
Right.
Could I have some follow-up?
So-
Could I follow up on Commissioner Fry's questions?
All right, go ahead.
We get 5 minutes to go here.
We do need to have that discussion. Do you have just one question?
It would be a line of 6 or 8 questions, so.
Okay, I think we may not have time to do that.
Sure.
So, Mr. Chair, you obviously know where we are, and perhaps you're the best one. I mean, in the progress of the case, the best one to lead a discussion as to when we might be able to finish this.
Well, I don't think the commissioners plan on being here tomorrow. Although we do have the room tomorrow.
Yes.
We do have the room tomorrow. We don't have a court reporter, correct? That's a problem. Our next meeting time is June 8th, which we've scheduled for another rulemaking hearing, but we can sort of delay that to the afternoon, say, while we do this in the morning.
Is that June 8th or 9th?
8th, because we're starting on a Monday.
On Monday, okay.
And we're going for 2 weeks.
Okay.
We're busy.
That's a better day for me, the 8th. So, but I'll defer to everyone else. I know there's other people with the schedule.
I'm just throwing it out to the commissioners about availability, et cetera.
They already promised. Sorry. We should ask Mr. Stomp if his witnesses are going to be available that day.
Elsie is available. Right, is out of the country.
Okay. It would be in the morning.
Mountain Daylight Time.
Airlines aren't going to be flying on it.
Yeah.
They're out of gas, man.
Nobody's leaving the country. Oh, that's a problem.
What if we started at 8? Sometimes we do that.
He's going to be 40.
Yeah, that doesn't sound good for him.
We doing it online on his phone.
How much time for this witness?
Probably 25 minutes, correct?
This building before they come in here with the stormtroopers and get us out?
Pam or Luis, what time do we actually need to be out of the room tonight?
Supposedly 5.
But we've pushed it to about 5:15, 5:20 in the past. They'll start locking the doors close to 5:30 though.
I need time to back up. So I'll stay as late as you want.
Okay.
We're still finishing a redirect here from.
Well, I think
Council.
I think we can count on the department to be here for the duration. Is that correct, gentlemen?
We were at your service.
All right. Yeah, I'm less worried about that.
Right, but we're not going to get to another witness today.
Okay. It's,
Yeah, we get, I mean, what time are you arriving on your flight? Yeah. Ooh, leaving the country, yeah.
I arrived at
3 p.m. their time? Could we do this on, I don't know, Mr. Diminish, did you have a problem with the Tuesday?
I really do. I missed a mediation session today. That's every. It's
You
the
never
same.
settle anything?
It's the first Tuesday of second Tuesday of every month, just like you guys.
Is that right? Okay.
That's for the Lower Rio Grande.
and actually, Mr. Chair, if I might, that primacy hearing has 27 witnesses and is one of the commission's highest priorities this year. At the moment, we have just a compliance order case at the July meeting. How's everybody fixed for the second Tuesday in July? We could put you before the compliance order case.
July 14th, Bastille Day. What's everybody up to? Flag Day, I guess. Oh, we did. You're right. Yeah. Bastille Day.
July 14th?
That works for the petitioner.
Going once, Mr. Knight, yes?
Mr. Stomp?
All right. All right.
Yeah.
Oh,
All right.
that sounds good then. All righty. I'm sorry we could not fit everything on the agenda into one day here today, but thank you all very much.
Yes, thank
we'll
you.
resume the matter on July 14th, and I will invite public comment on that day. Thank you.